say good morning to everyone. Let's go ahead and set forth our appearances for the record. We'll first start with the plaintiff, then we'll move to the defense.
Your Honor, Will Kemp for plaintiffs.
Good morning, Your Honor. Robert Eglett for plaintiffs.
Judicial District Court for plaintiffs. Brianna Switzler for plaintiffs.
Good morning, Your Honor. Eric Pepperman for plaintiffs.
Your Honor. Good morning, Your Honor. Brad Johnson, Tyler Watson, and Michael Esposito.
Good morning, Your Honor.
Very good morning. I have some questions. I guess we didn't make much headway. What?
Mr. Freeman is on Zoom.
Okay, Mr. Freeman, let's go ahead and set forth our appearance.
Oh, good morning, Eric Freeman for Real Water.
Thank you, sir. Anyone else? Did I overlook anyone? Okay, I'm not hearing 47 motions. Just telling everyone that. I'm starting a wrongful death case on Wednesday. 5-year case. It's going to trial. And so I look here, and we actually have our own matrix from both the Gallagher and the Brown case. And a lot of these issues I've decided already. So why should I have oral argument on this exact same issue? And here's my point. And this is very unique, I will admit. I don't know of any other trial judge that had to hear the same basic facts in 3 separate jury trials involving different plaintiffs against the same target defendants. I don't think anyone's ever had to do that. And the first time, I think we spent, what, 6 weeks, 8 weeks on pretrial motions?
We spent probably 6 weeks, Your Honor.
Yeah, 6 weeks. And all I have is a day and a half. Has there been any change in the law as far as products liability is concerned in the state of Nevada?
Not that I know of, Your Honor.
Right? There hasn't been any change. Anything unique about the underlying facts as it relates to liability in this case?
Yes, Your Honor, there is. We have different plaintiffs having different backgrounds and different claims, so those are different.
You didn't listen to my question. I said as far as liability. I didn't talk about injury causation. That's a different issue.
Sure.
I'm talking about the underlying facts regarding hydrazine in the water at the facility.
Well, Your Honor, if you're asking about is there any different facts as related to liability, I believe in the past they conceded the liability. We're not conceding liability.
Okay, I understand. So you're telling me I have to hear the motions for summary judgment? Or I should take them under advisement and we'll... And here's my point. I think this is a really valid point. There's issues regarding judicial economy, right? And just because the parties can't settle, that doesn't mean you unnecessarily burden the trial courts. Because how many cases have we gone to have had gone to trial?
This is number 5, Your Honor.
Number 5, and this will be my 3rd.
Correct, Your Honor. And then 6th one scheduled in front of Judge Hardy in September.
Right. So where do we go from here? Because I'm very concerned, because I looked at this, I counted the number. We have 47 contested motions, and 12 can be submitted on the papers. That's my calculation. Am I wrong on that? I might have missed one or two.
Hey, Judge, as I understood it, Counsel for Water wanted to make their record on these motions. So I thought the most efficient way would just be to go through them one by one and just do very brief 20, 30-second arguments. I think
How many second arguments?
Well, remember when Judge Goldman had the egg timer back in the day? You know, he said if you can do it in the time it takes this egg timer sand to drain. You know, I mean, our arguments will be very quick. We're just gonna say, Judge, you rule on this before here, you rule in blah blah blah. And
Okay.
whatever record they want to make, great. But I think that would be more efficient, just because otherwise we'd be submitting a lot of arguments and then we'd be waiting for a week or 10 days to get the rulings back. I just think that's an efficient way to do it. This kind of checklist approach.
Well, all right, that's interesting because when we went through these motions which needed to be argued, it was plaintiffs in large part wanted to argue motions, argue their motions, argue against our motions. We had it very limited. So to answer your question is, Your Honor, if you're not inclined to hear argument,
Well, my point is this,
you can't.
It's unrealistic to hear argument on 47 discrete motions.
It was unrealistic preparing for it when we drafted them, Your Honor. So I certainly understand.
If I had 6 weeks,
No,
like I had before.
I can tell you, as far as I'm concerned, I'm arguing 9 of these motions, and one of them I'm arguing is combined with 2 motions. Every single one of my arguments are less than 5 minutes, some of them like 2-3 minutes, that's it.
Yeah, Judge, we took the approach at the meet and confer that it would be less burdensome on the court and the parties, just to do a checklist approach here than, you know, because they're the ones that won't accept the prior rulings. They're the ones that want to make their record. So we can say, hey.
And I respect making the record, but,
Right.
I mean, I get that, and that's why I spent 6 weeks in the first case that went to trial. And we vetted it, and it's my recollection, some were taken under advisement, and I issued, not just granted or denied, but I had some very detailed analysis as far as some of the minute orders are concerned.
Right, the prior accident rulings are a really good example of that. Your ruling was 4 or 5 pages long going through the prior accident cases, so.
All right. Sir?
Your Honor, just on that specific point, I do believe that is something that we would like to address today. I've gone through those minute orders in detail. I've looked at Kraus, I've looked at Andrews, I've looked at all of the case law. And I've seen the test that Your Honor put together, the 6-factor analysis on prior incidents. And to the extent that the court is applying these particular cases, I do think there's something that we need to discuss as far as what the ultimate standard for admission is.
Okay, and my question is this, how long can you put that on the record?
30 seconds, Your Honor.
Okay, so how about this then? Do we have a timer? Do we have a timer?
Judge, I think we could kind of hit each other on the head. I don't think we need a formal time.
Yeah, I mean, because we're talking about.
We just get as far as we can get. If we don't get them done the next day and a half, then the rest of them get submitted.
Yeah, well, and then there's the issue there though, is, and we're running a pretty tight ship, because once I finish the wrongful death case, I will go into this. Because when does that wrongful death case starts Wednesday, right?
It starts on Wednesday, and it finishes on the 21st, and we're immediately into this trial.
See what I mean?
Yeah, for sure.
No, we understand there's no other time to handle these motions, but, you know, I guess, you know, if we don't finish in the next, because people are taking too long in their argument, then the rest of them are submitted, Judge.
All right, anyone else? Sir?
Yeah, yes, Your Honor, we've got 4 motions for summary judgment. We can argue those. The motions in limine, we can just deal with. I don't pretend to tell the court how to operate.
No, I understand, but I think you understand my concern,
Absolutely.
you know, because it's, and unless there's a change in facts, or, then there's clearly no change in the case law. We still follow the restatement of the courts, 402A. And it would be the second, not the third restatement of torts, right? Okay. Well, all I'm gonna do is, I'm just gonna start on page 2. And I did receive, I'll say it for the record, I received the joint status report regarding pretrial motions, and I've reviewed that.
Or instead of going in the order of the motions are filed, because then you've got summary judgment motions like way down the list, maybe we should just do the summary judgment motions first. I think there's actually 5 of them.
Let me see here. I see we have plaintiff's motion for summary judgment as to claims for strict products liability. We have summary judgment on medical expenses deemed reasonable, necessary, and customary. Let me see. Where's another summary
You
judgment?
got, then that's all plaintiffs, and you got 3 from defendants.
Okay, where's the defense at?
There's this motion for partial summary judgment regarding Caroline Strong's claims, motion for partial summary judgments regarding Kathleen Garcia's claims, and motion for partial summary judgment regarding Lisa King's claims, and that's my understanding, the extent of the defendant's MSJs.
What page does that start on?
On the joint status report, Your Honor,
Yes.
it's on page 6.
Okay.
About right above section 2.
I agree with that representation, Your Honor.
I just want to make sure I can find them. So we're talking about Real Water defendant's motion for partial summary judgment regarding Carolyn Strong's claim,
Yes, Your Honor.
and then Kathleen.
Garcia's, and then Lisa King's.
All right, and so I guess we would start out with plaintiff's motion for summary judgment as to claims for strict products liability and selling an adulterated product. I guess secondly would be medical expenses deemed reasonable, necessary, and customary. And then we circle back to defendant's motion for partial summary judgment regarding Carolyn Strong's claim, Kathleen Gasius's claim, and last but not least, Lisa King's claim. Is that correct?
Yes, Your Honor.
Okay.
And plaintiff's motion for summary judgment, as to plaintiff's claim for strict product liability against Nevada Beverage wasn't addressed in the status report, so is that one being,
That's moot, Your Honor.
okay.
It's moot. Oh, we went through all of them, trust me. Okay, let's get started with number one. I guess, bullet point one, plaintiff's motion for summary judgment as to plaintiff's claims for strict products liability against Real Water defendants, and that Real Water defendants sold an adulterated product.
All right, that's me, Your Honor.
Mr. Pepperman, you got the floor, sir.
So, Your Honor, I break this motion up into essentially three subparts. The first subpart is liability. You know, that is the question of is water containing hydrazine or rocket fuel, a known liver toxin, unreasonably dangerous and defective under the consumer expectation test. I think that is a resoundingly simple question to answer. Every single trial that we've done, Real Water is admitted that their product is defective because it contains hydrazine. They've stipulated to it over and over and over again before this court. In the Brown trial, this court entered summary judgment on the same exact issue, and the court's well aware, its summary judgment order, Real Water's repeated prior admissions on this is not some trial strategy. It's based on the undisputed evidence in the case. And briefly, Shane, if you could pull up reply, page 3. These are the bullet points, just a few of the many times where Real Water admitted hydrazine is in the water, there shouldn't be hydrazine in the water, that hydrazine is harmful, it caused the plaintiffs harm, there's no dispute that Real Water has hydrazine in it. In the bottom paragraph, this is a quote from the hearing on the motion for summary judgment in Brown, where Real Water's prior counsel is saying, hey, this isn't the attorneys saying this is Brent Jones, the owner of Real Water, saying that hydrazine shouldn't be in the water. So it's not something that, you know, Real Water can bring in new attorneys and come in and then suddenly all the facts and evidence are different. Shane, if we can go to page 4. And again, just a brief recap of the evidence of what these admissions and the court's prior summary judgment ruling was based on. The FDA found high levels of hydrazine in every sample tested of the E2 concentrate, which is used to make all Real Water, including the 5-gallon jugs and the retail bottles. We have expert testimony, Dr. Najam, who has testified in all 4 trials and has explained how the hydrazine was being produced and created in the E2 concentrate and how it was being added to the finished product and why the finished product had hydrazine and rocket fuel and made everybody sick. We also have the testimony of Blaine Jones, testifying as the 30B6 representative for Real Water, where he testified he always made the hydrazine, or the E2 concentrate, he always made it the same way with the titanium tubes and the electrolysis and these same ingredients. And page 5, Shane. This is all corroborated again by the numerous liver failure injuries that has been before this court that Real Water admitted previously was caused by hydrazine in their product, and the numerous customer complaints, you know, going back a decade that we have about chemical smells, gasoline-like substances, oily substances, fishy smells, which the experts have said, hey, this is what hydrazine looks like, this is what hydrazine smells like. It's in the water. Court's already granted summary judgment as to this liability issue. Real Water's admitted it over and over and over again, and there's really no basis for them to oppose it here. That gets us to the second subpart, which is causation. Now, granted, causation is different for each individual plaintiff, but the rubric of this is still the same. And so I know the court is well aware of this rubric, but summary judgment, it helps me articulate it when I just go through and explain it. And so when you have a motion for summary judgment, you have the moving party setting forth evidence they have on an issue. If the evidence is sufficient to warrant summary judgment on causation in the absence of contrary evidence, plaintiffs establish their burden. And that is the Kuzi v. University and Community College System case. Once we do that, once we establish our evidence of causation, then the burden shifts to Real Water, and they have the burden to produce specific facts and evidence that show a genuine dispute for trial. So in this case, if we can go to page 7 of the reply, James. What do you need to prove causation? Evidence that the injury was caused by the defective product. So first thing we have is Dr. Hudson's qualified medical testimony. Dr. Hudson's been the same medical hepatologist expert in each of the prior 4 cases. He reviewed all the plaintiffs, or in this case, 13 of the plaintiffs. One of them settled, so 12. Looked at their Real Water consumption, looked at their medical records, did a differential diagnosis, and he came to the opinion, based upon all the information, the studies, the literature on hydrazine, his investigations, your opinion that each of the plaintiffs in this case have suffered some form of liver injury and or acute liver failure as a result of consuming Real Water? Answer, yes, sir. That's qualified medical expert testimony on causation. In the absence of contrary evidence, that satisfies the burden for judgment as a matter of law. That's what we have here with respect to the majority of the plaintiffs. Granted, Dr. Hudson did not opine about Gossius and Strong, but there's no dispute that they suffered liver injuries after drinking Real Water. The dispute with them is damages. Well, there's questions of whether their stroke was related to it or a miscarriage, but we are not pursuing that. We're not seeking summary judgment on that issue in this motion. The simple question is there any contrary evidence with respect to any of these plaintiffs that rebuts summary judgment that Real Water, hydrazine, rocket fuel caused their liver injuries, or in Ms. Gossius' case, acute gastroenterological distress. And that is where plaintiffs establish their burden, and Real Water has nothing. They have no qualified medical expert to come in and say, no, it wasn't hydrazine that caused this injury, it was something else, to a reasonable degree of medical probability.
No independent alternative causation?
No independent alternative causation. I'm not sure what they're going to try to argue here. The opposition wasn't exactly clear, but the most they've ever argued was, well, it could have been this, it could have been that, it could have been this. But no one says that to a reasonable degree of medical probability. There's
Those days are gone.
no admissible.
Could have been this, could have been that.
Exactly.
Williams took care of all that.
That's the Williams case. It's
My
clear.
case wasn't named after me, but.
Right.
My client's your honor, James Williams.
But you were the right one. You were the
Mr.
one who
Kemp-
got that right.
Mr. Kemp and I were the plaintiff's lawyers in that case, and I handled the appeal. As well as Giglio, the other Seminole case, where I was the trial lawyer, you were the judge, and I handled that appeal.
I understand. I know both of them very well.
So that's liability and causation. That summary judgment is appropriate on the strict liability claims. The last subpart is adulteration, and as we set forth in the brief, this has been stipulated in the past and also entered on summary judgment that it's not even a question. You have rocket fuel in bottled drinking water. Is that an adulterated product? You look at NRS 585.300, sets forth several ways in which a product is adulterated, including when it consists in whole or in part of any substance that is otherwise unfit for food. There's no question that hydrazine rocket fuel is unfit for food. Same with 21 USC 342A3, that's a federal counterpart. You can't have rocket fuel in bottled water, it's adulterated. There shouldn't be a dispute about this at trial. Summary judgment should be entered on those three subparts. Thank you, Your Honor.
Thank you. And we'll hear from the opposition.
Yes, Your Honor. Brad Johnson on behalf of the defendants. Your Honor, what's interesting is that I know, based upon the past, plaintiffs are very interested in just having something rubber stamped here today because they've had 4 or 5 trials, etc. This is a different trial. We may have the same parties. They're different facts, and there's different defenses. We do not concede liability. So to have counsel come up here and say, rule in our favor because they conceded it in the past, is not a very good argument. But that's the one that they keep hammering on over and over again. In appealing to the court's natural inclination, why do I have to hear this again? This isn't a prove-up trial. This is a trial.
I mean, I understand that. All I want to know is what evidence that you have that hydrazine in drinking water would not be considered an effective product and reasonably dangerous.
They have to prove that that happened, Your Honor. First of all, number one is they have not proved that hydrazine is causing a problem. They cannot, if I just go through the facts with you, I'll tell you exactly what your answer is, Your Honor. They make inaccurate factual assertions.
But don't we have, wasn't there an epidemiological study done in this case as it pertains to general causation? You see that sometimes in mass tort cases, toxic tort cases.
Mm-hmm.
Didn't we have that study?
No, what we had was their expert, Dr. Hudson, says there is no study that can establish whether hydrazine at the minimum level will cause liver damage. There is no study that establishes what absolute amount of hydrazine would cause liver damage. That's what we have.
But I mean, there's no requirement in the law regarding absolute, right? I mean, there's nothing in the law that says absolute as far as it relates to burden of proof.
Right. And
It's
if you,
preponderance of the evidence, more likely true than not.
and
Absolute would be a higher standard than you see in a criminal case.
well, Your Honor, I wasn't saying absolute in the context of what their burden of proof is. I'm saying is that you asked me that there were studies establishing hydrazine would cause liver damage, and their own expert can establish what those limits would be, one way or another. That's not absolute, that's total. Number two is, if we go through what their factual assertions are, Your Honor, they have to, this isn't simply if hydrazine is in the water, it's an adulterated product. No, what they're claiming is there's hydrazine in every drop of water, and no amount of that, no minimum amount of that is going to cause liver damage to every plaintiff in this case. That was their motion. And if you go through that motion, they're saying as long as there's liability, there's causation and there's damage. Well, Your Honor, just because you're bringing not all products that are defective cause harm. They have to establish that. That's a question of fact. It's a question of fact if plaintiffs have to convince the jury that each consumed real water, that each real water they consumed had a hydrazine, that each water they consumed had
I have a
enough.
question for you.
Yes, Your Honor.
Do you have any expert opinion that would controvert the opinion given by Dr. Hudson in this case?
Yes, Dr. Hudson's opinion itself.
What do you mean, yes, Dr. Hudson's opinion himself?
Dr. Hudson backs off on his opinions, Your Honor. Dr. Hudson says hydrazine caused these problems, but can't back it up. We can traverse Dr. Hudson on the stand. Williams allows us to do that.
I mean, Williams doesn't stand for the proposition that you have an automatic right to cross-examination when you have no expert. If that's the case, we would never grant summary judgment.
Williams stands for the proposition.
Because you could have taken his deposition, right?
Yes, we took his
And,
deposition.
and what did he say? Did he back up his opinion right here? I'm looking here, it says question, and this is on page 7 of the reply. Based upon all that information, those studies, those investigations, is it your opinion that each plaintiff in this case has suffered from some form of liver injury and/or acute liver failure as a result of consuming real water? Answer yes. Sir, yes, sir, that was the answer.
Yes, and under Hallmark, he has to be able to point to where he is basing his opinions. When I asked him, where are you basing your opinions, specifically that hydrazine causes liver damage, he couldn't focus on anything. He couldn't point out anything. This is my point, Your Honor, that simply because an expert comes up and makes an opinion that you can challenge, which we did, and which he admitted, that doesn't give you grounds for summary judgment. And if I can complete my record, Your Honor, they also have to come in and prove harm, and that each was harmed. So the fact that the court granted motions before is irrelevant because we're not conceding liability. But expert opinions are not conceded.
So you're not saying that hydrazine in drinking water is not a defective product and reasonably dangerous under the restatement of torts 428?
Not according to the proof. Additional questions of fact exist. First of all, they don't meet the Rule 56 standards. There's questions of fact whether each, keep in mind, this is for all the plaintiffs. I know they're backing off on it now, but I can only argue what was in the pleadings. They each drank from a 5-gallon concentrate, or even claimed that they did. The expert opinions don't erase questions of fact, specifically whether there are, one, did they drink the water? In this particular case, we don't concede that they all drank the water. In fact, there are several of these claimants that we contend didn't drink the water at all. And so the same expert that they're hanging their hat on their opinions as it relates to causing liver damage isn't supported by the facts either. Additionally, Your Honor, we have the expert reports that they have in support. Those contain hearsay and are admissible and they're unsworn. The reports that they presented to you, that for you to rely upon, doesn't have the required.
I'm relying upon his deposition testimony.
Well, no, Your Honor, they attach to their motions reports,
I understand.
and that's
But
what I'm
they also
talking about.
included deposition testimony, right?
Man, excuse me?
I mean, they also included deposition testimony, and that would meet the requirements of Rule 56.
Right, and we are relying upon his testimony as well, Your Honor, to dispute it. He can come in and testify all he wants that I believe that hydrazine caused liver damage in these people, but when we traverse him under Hallmark, he doesn't have the basis for it, because there is no scientific basis for it on a peer review at all. It's just his opinion. Dr. Tenner disputes the entire theory of Dr. Hudson, and doesn't believe that this is the liver damage that these people are claiming is not caused by a drug, that's idiopathic. So they failed to produce any evidence that real water was consumed by each of these plaintiffs, and if so, whether it was adulterated. They have not been able to establish. There's all questions of fact in this, Your Honor, and they're putting you in a bad position whereby they're trying to say you need to rule in their favor on liability and causation and damages in this case. Despite the fact that all of those are disputed and all of those issues are questions of fact for the jury to determine, not the court. So if you look at their reports, there's nothing on Diaz, Nally, Strong, Gacias. They have experts who don't even address Gacias or address Strong. And that's uncontested. For those reasons, Your Honor, we believe that their motion should be denied.
Thank you, sir. Mr. Peppermint.
Thank you, Your Honor. I want to first just point out, I think the most significant thing here is that you asked, what evidence do you have to support a genuine dispute for trial on any of these issues? You did not receive an answer to that. That's because they have no evidence. All you heard was this conclusory dismissal as if we have not presented any evidence, but that is contrary to everything before you. Reiterate, when Dr. Hudson is asked in his deposition, and based upon all that information, those studies, those investigations, is it your opinion that each of the plaintiffs in this case have suffered from some form of liver injury or acute liver failure as a result of consuming real water? That information is the medical records of the plaintiffs. It's the studies are the studies on hydrazine showing that it is a liver toxin, which has never been previously in dispute because it is a liver toxin. The scientific evidence establishes it is a liver toxin. The investigations is the epidemiological investigations that Your Honor asked him about that he didn't respond to. There were epidemiological investigations. The MMWR report, the FDA investigation where they tested the concentrate, which by the way, no plaintiffs drank the concentrate. They drank the water that the concentrate was used to make the finished product. The concentrate is where the expert testimony establishes hydrazine was being created and it was being added to the finished product. That's why when the FDA tested every sample of E2 concentrate, they found hydrazine at very high levels in it. That's why when the defense, UNFI, if you recall, tested the retail bottles, because they wanted to say exactly what he just suggested. Oh, it's only the 5 gallons, it's not the retail bottles. So they tested the retail bottles. That's the Eurofins testing that we cite in this an exhibit to the motion. They found hydrazine in every single bottle of the retail bottles, except for one, which there was just not enough high enough levels of it to be in there, and the oldest one because hydrazine degrades. We've explained that as well. Every piece of information that is before this court, the studies, the expert testimony, the investigations, establishes that hydrazine was more probable than not the cause of each plaintiff's liver injuries in this case. There is no question of fact for trial. We have met our burden by setting forth that evidence. The burden shifts to real water. They cannot meet the burden to show a genuine issue of fact. They cite to Dr. Tenner. Dr. Tenner's not their expert, Your Honor. Dr. Tenner's been excluded from every single trial because his opinions are, it could have been this, it could have been that, it could have been this. He does the same thing here with respect to one plaintiff, Andrea Bordnay. But that was Nevada Beverage's expert. Nevada Beverage settled out. Dr. Tenner's not even their expert. They don't even cite to their own expert, their medical expert, as creating a genuine issue of material fact to rebut Dr. Hudson's unrebutted medical causation testimony. So there is no question of fact. They have not shown you one piece of evidence. What they've said is, oh, well, you shouldn't grant summary judgment, not based on the evidence in front of you, but so we can get Dr. Hudson on the stand and try to, question whether his medical expert opinion is really his medical expert opinion. But, Your Honor, I'll just refer the court back to the standards in the case. The cases that we cite, Wood v. Safeway, that is the quintessential arguments as to some metaphysical doubts as to the operative facts. It's not evidence disputing other evidence. That's what creates a genuine issue for trial. The Francis v. Wynn Las Vegas case, where the court said, look, one side has evidence, the other side doesn't, that requires summary judgment. So we have 3 issues here. Liability, is water containing hydrazine defective? Unquestionably, the answer is yes. Is there medical causation for each of the plaintiffs? Unquestionably, the answer is yes. They can't show you one piece of evidence from any expert in which they have an alternative causation theory for the known liver toxin that's in the water that these people are drinking.
And/or plausibility theory.
Or plausibility theory. There's nothing. They've not identified one single piece of evidence in the entire argument to rebut the mountain of evidence that's before this court on these issues. So with that, Your Honor, we'd ask that summary judgment be entered. And then the trial proceed as to damages and punitive liability and punitive damages. Thank you.
Okay. As far as plaintiff's motion for summary judgment as to plaintiff's claims for strict products liability against the real water defendants, and that real water defendants sold adulterated product, I'm going to grant that motion. Let's move on to the next one. And unfortunately, how long did that one take?
That's probably gonna be the second one.
24 minutes. And that was a good job. Everybody was very brief there. Some of these motions just take time. Next up will be?
Good morning, Your Honor. Robert Eglett on behalf of the plaintiffs. And this is plaintiff's motion for summary judgment regarding the medical expenses should be deemed reasonable, necessary, and customary based on lack of defense expert testimony. Plaintiff's expert, Dr. Hudson, opines in his reports that all of the plaintiff's past medical care and bills were reasonable and necessary. None of Real Water's experts dispute this, and Real Water did not challenge this opinion at Dr. Hudson's deposition. Since experts cannot offer new opinions at this time, there is no dispute of material fact regarding whether each of the plaintiff's past medical expenses are reasonable, customary, and necessary. Real Water attempts to refute plaintiff's past medical expenses by focusing on disputes regarding causation, Your Honor. However, this motion simply seeks to establish the amount the plaintiff's past medical bills to be awarded if the jury finds that Real Water caused the plaintiff's injuries, and the court just found that. So I think that argument's out the window. Nothing in Real Water's opposition demonstrates a dispute of material fact. They have no expert opinion to refute Dr. Hudson's, and the cases Real Water cites are in opposition. Wyeth and Countryside relate to whether there was sufficient evidence to support the jury's damages award, not whether damages can be awarded at the summary judgment stage. Defendants have not met their burden in opposing this summary judgment motion, and this same motion has been granted in 3 prior Real Water trials, including twice by this court, and it should be granted again. Thank you, Your Honor.
Thank you, sir. And as far as the specials we're talking about, they're set forth on page 2 and 3 of the moving papers.
Correct, Your Honor.
All right, sir.
Thank you, Your Honor. Your Honor, again, this is a question of fact, not a question of law. First of all, Bonnar is settled, so I don't know why that's listed there. We go through the additional plaintiffs here: Bourdonnais, Chang, Davis, Richards, Diaz, Delmar, King, Van Buren, Mano, Morris, Nally, and Oliveira. Doesn't address Casillas. It doesn't address Strong. They attach Hudson's report, and somehow that equals, as a matter of law, what the medical expenses are. Well, Your Honor, we don't agree with that. Medical expenses are a factual inquiry. We've given you case law, the Contero versus McDonald case, 116 Nevada, 1181. It states the juror is not bound by that testimony, and in fact, we could stipulate to what the reasonable and necessary expenses were, and the jury wouldn't be bound by it if they don't believe the plaintiff's claims. It's a question of fact. There's no citation in their motions. I understand that these are, at this point, for plaintiffs, almost
But
like...
why do we have Rule 50A and Rule 50B motions if the jury is the end of all end, specifically on that issue? Because hypothetically, juries can go down the wrong path from time to time based upon the evidence.
I guess we can all go down the wrong path, Your Honor, but my point is, representing the Supreme Court statement that this is a factual inquiry as to whether or not these medical expenses are reasonable, necessary, and related to it, especially when they're making claims.
But here's my question: doesn't that depend on the status of the evidence?
Sure.
You say it because if there's no, there's no evidence in opposition, how does that become a question of fact? You don't have a question of fact. It's unopposed. And that's why we have Rule 58 motions, right? That's why we have summary judgment motions. Because everything doesn't necessarily go to the jury, and that's my point, right?
Well,
I mean, we can flip it around. Hypothetically, if the defense said, I mean, if the plaintiff doesn't have an expert, that's why courts grant summary judgment. It just doesn't go to the jury.
okay, Your Honor. In their motion, they didn't cite to, there are no citations other than Rule 56 in the motions that we had to oppose. Instead, we get back to Hudson's in his declaration. He's not an epidemiologist. He's not someone who'd be qualified to come in and prove up other people's medical
But an
records.
epidemiologist wouldn't be called specifically as it relates to the reasonableness and necessity of medical treatment, right? Epidemiology typically does what the CDC does, and they do a general causation analysis.
Right, and my point is that there's nothing in his report indicating how he came up with the numbers. He was basically given a number and just simply rubber stamped them. Didn't go through, there's no foundation as it relates to how he came up with the numbers, where he found those numbers, who he spoke to, what documents he relied upon. It's just a summary, this is reasonable and necessary. Didn't do any of that. I mean, even Don Cook has to come up here and lay the foundations for what's reasonable and necessary. She's not a doctor at all, Your Honor. Dr. Hudson doesn't do it. Also, we've cited that the opinion that hydrazine was found in the 2020 water, it must have been there before 2020. Well, we've cited the Howard versus City of Coos Bay, 87 2nd, 1032, states that is a question of fact. It is, reasoning says that Dr. Hudson is insufficient to establish causation as a matter of law. And I know the court's already ruled apparently there is causation in this particular case, but there are arguments that Dr. Goldsmith confirmed. They got into causation in their opposition, that Dr. Goldsmith confirmed what Dr. Hudson said is patently false. It's not true. Again, they leave out some plaintiffs in this case, whereas as it relates to Bourdonnais and King, that would fall outside of what Dr. Goldsmith believed would be any chance of having hydrazine exposure because it related to the 2020 spike, and Ms. Bourdonnais and Ms. King claimed they consumed water before them. And again, expert Tenor stated specifically that Bourdonnais looked at her background and determined that her liver ailment was not caused by drug induced, and as a result, her future damages and past damages wouldn't apply as well. All of these are questions of fact which prevent the court from granting summary judgment on them.
And I have one question for you, and this is off the page 4 of the opposition. And let me see if I get this right page number. Page 4, line 16, and here's a quote, I guess, from a Nevada case, and that would be Prabhu versus Levine. Oh, I know that case very well. All right. Anyway, here's a question. It says, quote, a jury is permitted wide latitude in awarding tort damages, and the jury's findings will be upheld if supported by substantial evidence. My point is this: what if you have no evidence? Right? Because typically, if a jury is going to make a determination, there has to be a question of fact. Here, there appears to be no question of fact because there's no expert opinion. Right? And so, under those circumstances, those cases don't go to the jury. If the appropriate motion's filed. And it could be by 50A or it can be by summary judgment. Right? Is that true?
I don't understand your question, Your Honor.
Okay. I thought it was pretty clear. But my point is this: if you don't have evidence, then, for example, the quote there, a jury is permitted wide latitude in awarding tort damages, and the jury's findings will be upheld if supported by substantial evidence, period, close quote. There's no evidence to the contrary in this case. So what happens under those circumstances?
What happens under those circumstances, Your Honor, we're able to cross-examine our expert and reveal to the jury that his opinions regarding care is incorrect in terms of the expense.
Okay.
That's under Williams, and we're allowed to do that, Your Honor.
And you had a chance to cross-examine him in his deposition, right?
Correct.
Okay. That's kind of my point, you know? And the thing about, if you read Williams and it talks about cross-examination, sometimes I wonder why that was thrown in there, because they don't tie it up. They just say cross-examination. And I understand that. But anyway, go ahead, because I look at it this way. Now is the time to create issues of material fact to go to the jury. The jury doesn't, I mean, because my point is this, and this is correct, if supported by substantial evidence, and we know what that means. That means sufficient evidence, not overwhelming, you know, enough to make a question of fact in front of the jury. And my point is this, we have no substantial evidence in this case to oppose the call of the question as far as the motion is concerned.
Well, our position is, Your Honor, is that Dr. Hudson didn't meet the standards of Hallmark because his opinions weren't supported, and that was addressed in his deposition. His expertise is not in studying as to, providing opinions as to the cause of past or future care. There's no background to it. He's a liver expert. He doesn't do calculations such as that. He provided no testimony in his report or otherwise or in the papers before you what those bases are. He just simply comes to a conclusory statement, and that doesn't meet Hallmark.
Okay, sir, I understand.
Thank you, sir.
Briefly, Your Honor, there is no motion that has been filed by the defendants to strike Dr. Hudson as an expert with regard to the reasonableness and necessity of medical expenses. They have one on the psychological stuff. But again, this isn't a case of causation, and counsel spent 95% of his time up there re-arguing causation. If we're going to do that in every motion, we won't even get to the motions for summary judgment today. My understanding, the court has ruled on causation, and so I don't quite understand why that's being re-argued. Defendants have submitted no evidence, no affidavits, no deposition testimony, nothing to refute Dr. Hudson's opinions here. And under Nevada law is clear on this. Motions for summary judgment, the opposing party cannot just come forward with ifs and buts and maybes. You have to come back with evidence and affidavits and deposition testimony actually establishing a material issue of fact. They have done none of that here, Your Honor. The motion should be granted.
All right, this is what I'm going to do regarding the motion. And it's important to point out the failure to have a defense expert in this matter on this specific issue is problematic in that there's no material issue of fact right now. And so in light of that, and you know, and this is important, you know, we have, when you come to issues regarding reasonableness and necessity of medical treatment, as far as reasonableness is concerned, you can have a person with a high school education that's familiar with CPT codes, that's a biller in the medical office, that can opine on that issue. It's not really a high standard or threshold, and that's kind of my point. Without an expert creating a dispute as to a material fact, I'm going to grant the motion. So, what's next? That was a little quicker. Was it a little quicker?
13 minutes.
13 minutes. Okay, we're doing better.
I think I was total in my argument, including rebuttal, less than 5, Judge.
I understand. We're making some progress. What's next? Where do we go next?
I believe it would be the real water defense motions for summary judgment on strong analyses, which I believe can be argued jointly.
Okay.
But I'll leave that up to them.
And what page is that on? That's on page. And I do appreciate, I'll tell you, this is a joint status report.
On the joint status report, there's towards the bottom of page 6.
Thank you, ma'am. Oh, okay, so we're at, between line 8 and 9, real water defendant's motion for partial summary judgment regarding Carol Ann Strong's claim, is that it?
Yes, Your Honor.
And the Kathleen Dossius, Your Honor.
Oh, yeah, that'll be next, and then there's one more after that. Okay, let's go to that one.
Thank you, Your Honor. Your Honor, I guess these motions can somewhat be argued together, both Strong and gaseous, but let's just start with Strong. And this is really gonna reveal the problem we have with the prior court's orders, but I'll go ahead and just lay it out. It's disputed that Strong drank real water, Your Honor. So it's gonna be real difficult to establish causation when she didn't drink the water, much less that her damages are caused by drinking the water that she didn't drink, much less that the expert saying that she was damaged. Well, they don't even say it in her particular case. Let's go through it.
And which one are we talking about? I just wanna make sure.
Strong, Your Honor.
Okay, I'm with you. Just wanna make sure.
So, Ms. Strong was very specific, establishing how she came into contact with the real water. Very specific, unlike a lot of the other plaintiffs, quite frankly. She actually established and testified the where, the when, the how, the why, and with whom she purchased this water. She said very specifically that she bought it at Walgreens, that there would be bank statements supporting it, there would be credit card statements confirming the bank statements, the date that she was bought it, the people that were with her or with him to find out, and we've given you the exhibits to attach to review. Walgreens doesn't sell real water. Bank statements show that real water, it does not show real water was purchased. In fact, the credit card statements show that she purchased other waters, not real water. It's completely been debunked, and that's what happens when you send out mass notices to everybody and to various doctors. If you have a delivery element, you think you drink real water, then you could be a plaintiff. That's what happened in Ms. Strong's case, because she was told by some doctor about this. So that's what she claims. She claims that she had a stroke. So now we've got someone who never drank water. Now they're claiming a stroke for $130,000. Again, showing you how this got out of control. Now they want to back off. Well, we're not claiming the stroke. Well, that wasn't what they were claiming when they brought the claim, Your Honor. They cannot create questions of fact by presenting Ms. Strong's then conflicting testimony, conflicting stories. Oh, well, maybe I didn't buy it there. I bought it somewhere else. Well, we can't go running around. Evidence is over. She told us where the water was purchased very specifically, and we disproved it. So the plaintiff's claimed medical testimony is not there to establish causation now, is it? Based upon her testimony, she didn't drink real water, Your Honor. Then they throw sort of a Hail Mary to Dr. Sands, who's a psychiatrist. I think he's a psychiatrist out of New York. But he's going to reproduce this by saying perhaps you drank it somewhere else. Well, Your Honor, those aren't the facts, those aren't the sworn testimony. And there are no questions of fact to throw out Strong's claim in its entirety. Same thing with Casillas, which is even actually worse. Casillas, Your Honor, if it's okay to argue that motion as well,
Go ahead.
she's with Strong. It's the same credit card backup that they had for Casillas. She claims that she has liver injury. Your Honor, again, they filed a motion that was branded as the causation of all these plaintiffs. Well, shoot, Casillas doesn't even have any medical records, Your Honor. They should have presented that to you to make that ruling. Casillas, Hudson doesn't even back Casillas up. The Hudson, the rubber stamp expert that they have, who has a 100% I find in favor of you on liver damage related to real water, he doesn't even mention Casillas. I thought they had a burden to bring in some medical experts to support their claims of liver injury. Hudson doesn't do it. Sands doesn't do it. They don't even reference her in their report. Strong and Casillas, they should have dropped that case from the beginning. And it's actually doing them a favor to grant summary judgment because they won't screw up all the other decent cases that they have. These cases are horrible. They don't support what they claim. And for that reason, Your Honor, we need to grant summary judgment on these two folks. Thank you.
Thank you, sir. Ma'am.
Good morning, Your Honor.
I guess we need to get back to actually what the request of the motion was rather than re-arguing the past ones. But really, if we boil it down here, defendants move for partial motion for summary judgment on 3 issues. 1, the consumption and purchase of real water. 2, Ms. Strong's stroke and cognitive issues, not her liver injuries. And 3, Ms. Gossius' miscarriage and acute liver injury, not her acute gastrointestinal distress. As to issue 1, there's a clear dispute of material facts that plaintiff purchased and consumed real water. Real water even admits it in the reply saying, hey, don't look at some evidence, look at this other evidence, and that's why summary judgment should be granted. Carolyn Strong and Kathleen Gossius lived in California and took a trip to Las Vegas. At her deposition, which is clearly within the discovery period, Carolyn Strong testified that she recalled stopping by a convenience store to purchase water, recalling the distinctive blue bottled branding of real water.
And the testimony's on page 4.
Correct. And Shane, on our opposition, page 4. And it's right there in her deposition. I don't think there's anything else that needs to be established as far as a question of fact. There's clearly a question of fact as she testified to it at her deposition. Now, and to the extent they're trying to bring up credibility or anything like that, that's not for this court to decide on the summary judgment. That's an issue of fact for the jury. Regardless, and then as far as Ms. Gossius, they didn't depose her in the discovery period. So she had to put forth a declaration in which she set forth that when they were driving in from Las Vegas, they stopped at this convenience store, bought 2 gallons, as was her pattern and practice to do, especially on trips, because you don't want to buy the expensive hotel water. And they filled it up in their reusable jugs and drank it throughout their trip. There's clearly an issue of fact on purchase and consumption. It's right there on page 4, the declaration and the deposition testimony. On issue 2, which is Ms. Strong's cognitive issues. Now, defense kind of flew past this and said Dr. Sands, but Dr. Sands is plaintiff's neuropsychologist. He tested Ms. Strong and determined that she, along with the other plaintiffs, are at risk of cognitive decline due to their consumption of hydrazine, their hepatic encephalopathy, and their related liver failures. He cites to a number of studies that demonstrate that with liver fibrosis and even very, very low levels of hepatic encephalopathy, you get cognitive issues and cognitive decline that has been tested and studied in numerous reports. And that's all cited and was disclosed in the discovery period as well. So that expert testimony creates a clear issue of fact on Ms. Strong's cognitive issues. And as we've already said, plaintiffs are not intending to argue that Ms. Strong suffered a stroke that was caused by real water at the time of trial. The same thing is related to Ms. Gossius' miscarriage. We're not suggesting that those were caused by real water at the time of trial. So as far as their very targeted partial summary judgment request, as there's clearly a question and issue of fact as far as consumption, as demonstrated by the clear testimony. There is clear issues on the cognitive issues because of the expert testimony. And that's all they moved for. So, Your Honor, I believe that summary judgment is not warranted in that capacity.
What about the cognitive issues?
So the cognitive issues are what Dr. Sands testified, and I believe on page 14 of our opposition, Dr. Sands stated that there was a cognitive decline, and based on multiple studies, that he tested Ms. Strong and testified at his deposition, as well as produced in his report, that based on liver failure, consumption of hydrazine, and liver fibrosis, there's a strong risk of cognitive decline and cognitive issues associated with their injuries, and that is part of his report. So there's expert testimony on that in order to create an issue of fact, which is unrebutted.
And that's Dr. Sands?
Correct. And so as to this targeted issue, Your Honor, as far as this, summary judgment is not warranted on their consumption or purchase. As to her Ms. Strong's cognitive issues, and that's, and again, Ms. Gossius, it's only as to her miscarriage that we're giving up in the acute liver injury, but nothing, they did not move for summary judgment on anything else related to her case. So based on that, we think it should be denied. Thank you.
Thank you.
Well, I guess you can't deny the motion if they're conceding that most of the points are valid. Claims of stroke and miscarriages, etc. We're alive and we filed our motion. But that being said, Your Honor, let's start with Strong. They failed to produce any record that Strong was ever diagnosed with hepatic encephalopathy. That's not there. She pointed to her cognitive symptoms and simply repeated those to Dr. Sands. Dr. Sands doesn't offer any causation opinions regarding her cognitive injury claims. Indeed, if you note in their motion, they were careful to exclude any expert opinions regarding Ms. Strong and her actual symptoms. Those weren't presented to you, Your Honor. They gave some experts excerpts as related to Dr. Sands, how he reached that opinion, but in other words, he just gave a brief factual and medical chronology, Your Honor. He doesn't even state that real water consumption causes the neurological deficits. So they give him a list of stuff, he repeats those in his report. That isn't causation, it's nothing.
But
They don't have an expert.
Here's my question for you, is it slightly different than that? Because
Sure.
I'm looking at page 14, and it's specifically regarding Dr. Sands.
Mhm.
And it appears to me from his report, he states the following, and it deals with fibrosis and or scarring of the liver. And my point is this, you have a liver fibrosis, and over time, it appears to me he's saying, look, it can have a impact on cognitive abilities down the road. Is that what he says in his report?
I think what he says is that there's nothing in his report that states anything to a reasonable degree of medical or psychiatric probability at all, Your Honor. Basically, he's just repeating, gives a brief factual.
But see, here's my point, and this is important. Number one, the reports don't come in. Number two, the reports are here to put you on notice as to what potentially the theories of causation might be in this case. And it appears to me that what he's doing is he's looking here, and there's medical peer-reviewed articles linking cognitive decline in individuals who've had liver failure. And that's really and truly what the whole issue is, as far as the case is concerned. And, I mean, if that's his opinion and his deposition wasn't taken, I mean, you can test it at the time he testifies, but it appears to me that that's what this is being offered for.
Well, Your Honor, if it's a report and it's not evidence, why are we relying upon it? Where's his affidavit, where's his deposition? Are we switching that burden to me, to my clients?
Yeah, but I mean, ultimately, it's what you're saying. You're saying, look, prove a negative. It's your burden to come forward with testimony that Dr. Sands is wrong. You could have taken his deposition. That wasn't taken. I'm not blaming you. I know you got involved in a case like. I'm not blaming you for that at all. But my point is this: it's kind of like an open issue right now. And a real simple example, you have a med-mal case, and there's a report prepared, and discovery's done, and in the report, the doctor who's from the same or substantially similar specialty opines a deviation from standard of care. The fact you didn't take his deposition doesn't mean that would be right for a summary judgment motion. That's going to trial on that specific issue, that discrete issue. So my question is this: we have a Dr. Sands, and he has a report that says, there's medical peer-reviewed articles linking cognitive decline in individuals who suffered liver failure.
Right, he says that in the report. He
Right.
doesn't link it to her, and he doesn't state that she did. So, would it be incumbent upon, when we make a motion for summary judgment, saying that their reports of Dr. Sands don't meet the requirements of establishing a neurological deficit from consuming real water, and it doesn't state it in his report. Doesn't link it to her. He just makes a generalized statement. They haven't met that burden. I can't challenge, and Your Honor, whether we brought
Well,
it
you
to
could
the
have
case.
challenged him by taking his deposition.
Your Honor, again, if the court is making the position that the.
I never have positions. Haven't I said that a lot? I don't take positions. I'm not an advocate for anybody. I have questions regarding what the appropriate burden of proof might be, what the standard is under the law. But I
Yeah.
never take positions.
And I apologize, Your Honor, but if the standard is that you have to have a report that at least establishes from a legal perspective that the medical expert is making an opinion, I would assume that would be in the report. It isn't in this report. They said that Dr. Sands established that Mrs. Strong suffered neurological damage as a result of drinking real water. It doesn't say that in his report. This is something that can happen. That's not a reasonable degree of medical probability. Additionally, if it's okay if I can segue to gaseous.
Yeah, you can.
There are no medical records on gaseous. They produce no records or medical testimony regarding her future care, her past care, because there's no records to review. She's produced no evidence that she consumed real water that hasn't been completely disproven. They didn't address that. They didn't address that when they came up here in their reply. It just isn't there, Your Honor. Dr. Hudson doesn't even mention her, nor does Sands. He's a mystery plaintiff. I think we met our burden there, Your Honor, that they did not. And for that reason, we'd ask you to grant our motion for summary judgment.
And I have it says, did Ms. Strong have testimony regarding cognitive symptoms?
Excuse me, Your Honor?
Did Ms. Strong have any testimony regarding cognitive symptoms?
She may have testified to that, Your Honor.
Yes, Your Honor, and they had no expert to suggest otherwise.
No, go ahead, sir. I'm listening.
So, and all your questions are obviously the most important, Your Honor, but then we move on to, keep in mind is that Ms. Strong has testified where she got the water that's been disproven. So we gloss over that all they will, but that's happened. Can't create questions of fact by giving different sworn testimonies. But segueing to the gaseous, there's nothing there, Your Honor. No medical records, past, present, etc. Nothing support any future damage claim. They have a future damage claim in here, Your Honor, with no medical support for it.
Now, what is their future damage claim?
Gosh, I believe it was like $300,000, Your Honor.
No, I mean, what's it based on?
It's a good question, Your Honor. I guess her belief that she's got some type of liver ailment. But of course, it's sandwiched in with her other issues related to miscarriages and other unrelated issues.
And the miscarriage, that's off the table, right?
Well, I guess it is now, Your Honor. It wasn't when we filed our motion. So, on those very specific points, Your Honor, we ask you to grant our motion as it relates to the strong and deceased claims. Thank you.
All right, couple of points. I just wanted to make sure I got the right portion of the briefing. Regarding the consumption, I'm looking at the testimony of Ms. Strong, and I think it's set forth on page 4 of the opposition. And looking here, she testifies as follows, quote, "So if I understood your answer now, they brought a type of alkaline water at that convenience store, question mark. Yeah, it was in a blue bottle, I remember that. And here's my point. Whether that's true or not, that's ultimately up to the jury to decide. Right? I don't make that decision unless this was a bench trial and then I could size them up. And so when it goes to the consumption and or purchased issue, I'm going to deny that. Regarding cognitive issues, and I don't know how this expert's gonna be utilized at trial. And to make sure I have that with some sort of particularity here, we have testimony, no, I'm sorry, we have a report regarding potential cognitive issues as it relates to the consumption of, as it pertains to an issue regarding a damaged liver or a cirrhotic liver. And that's really what that's focusing on. And whether that's true or not, I don't know. But there's a report out there, and as my recollection upon review, he said these were peer reviewed. We'll find out. But his deposition wasn't taken, right?
They didn't ask any questions on that issue.
On that issue, okay. Well, I'm gonna deny it based upon the fact that they didn't ask questions on that specific issue. Whether that ultimately goes to the jury or not, that's another day. But, and I guess the miscarriage is out, right?
Correct, Your Honor.
Okay, well, we did learn something.
As well as the stroke.
As well as a stroke.
Correct.
All right. So I guess granted in part, denied in part. Granted as to miscarriage and claimed stroke. How's that? So where do we go next?
I believe there's one more and there's straight on the table, which is real water's defendants.
All right. And which one was that again? That's
Lisa King, on myasthenia gravis, Your Honor.
okay.
Would you like us to proceed, Your Honor?
Absolutely, and I want to make sure, and that would be real water defendant's motion for partial summary judgment regarding Lisa King's myasthenia gravis as a result of consuming real water.
That's correct, Your Honor. Myasthenia gravis is not a liver ailment. There's no evidence that she has the condition after all discovery was completed. She was initially misdiagnosed by Dr. Mahija. I apologize for butchering that, M-A-H-A-J-A-N, in May of 2019, as noted by when she went to the Mayo Clinic on October 3 of 2019, Dr. Rose. It was again noted that she did not have the condition. She was diagnosed by Dr. Ross again on 10/19/2019. And yet a third time on October 31, 2019 at the Mayo Clinic. Not content with Mayo Clinic's opinions, then she went to Quest Diagnostic on November 17, 2019, circulated back to Dr. Mahajan on January 6, 2020, who adopted the 11/7/19 findings that she didn't have MG. Still, she went off to Dr. Gish at Loma Linda and was found negative for MG in October of 2020. Incredibly, she went back to Dr. Mahajan in December of 22, and she again tested negative for MG. Dr. Hudson simply adopted the initial wrong diagnosis by Dr. Mahajan, which Dr. Mahajan then retracted, in his opinion, his being Dr. Hodson's position, that she suffered from this condition. So based upon the clear medical background and submission to the court, this particular damage that Ms. King alleges should be dismissed as a matter of law. Thank you.
Thank you, sir.
Your Honor, defendant's reply proves this issue is not appropriate for summary judgment because it is replete with disputed facts regarding Lisa King's myasthenia diagnosis and its causation. I'm going to refer to myasthenia gravis as just MG throughout my argument here and any other arguments today or tomorrow regarding this issue. Defendants claim that King's diagnosis was retracted and she lacks qualified expert testimony to connect her MG diagnosis to real water. This claim ignores two critical facts, Your Honor. First, King's treating neurologist, Dr. Mahajan, who diagnosed her with MG has confirmed that diagnosis and treated her for MG over the past 5 years continuously. Second, both of King's medical experts opine to a reasonable degree of medical probability that she has MG and that her MG was caused by real water. Dr. Mahajan diagnosed King with MG in May 2019 after she began experiencing muscle tremors. Since then, she has seen him for her MG condition over 40 times. She has been hospitalized 3 times for MG flare-ups and received more than 9 rounds of IVIG therapy for her MG. Defendants rely on a single record from the Mayo Clinic to support this argument, and they do not disclose to Your Honor the full context of that record. For example, that the actual, they don't give you the blood test, and they don't show you that actually the record says you should be retested since you recently were tested positive for MG. The record does not confirm that she does not have MG, and they have no expert to actually say what Mr. Johnson is trying to say this record says. Defendants rely on the fact that when King saw Dr. Mahajan after returning, so the record does not confirm that Lisa King does not have MG. Defendants rely on the fact that when King saw Dr. Mahajan after returning from Mayo Clinic, his diagnostic code stated rule out MG. However, in 2022, after Lisa was hospitalized for an MG flare-up, Dr. Mahajan again diagnosed her with MG, demonstrating he did not rule it out. He maintained that diagnosis in every record thereafter. And as I told you, he's seen her 40 times for this condition since over the past 5 years, since she was first diagnosed with it. Next, defendants challenge whether King's MG is seronegative because Mahajan's records say possible seronegative MG. This condition occurs when a patient exhibits symptoms of a disease, but their blood lacks detectable antibodies associated with the disease. Defendants, again, have no expert to opine regarding diagnostic testing required to diagnose seronegative MG or whether King's MG is seronegative. Their only medical expert with respect to Lisa King, Dr. Alsina, their causation expert in this case, their one and only causation expert in this case, admitted clearly in his deposition that he is not qualified to opine on MG and is not offering any opinions regarding MG with respect to Ms. King. Further, Ms. King has 2 medical experts, Dr. Hudson and Dr. Hirschfeld, that opine on her MG diagnosis and causally relate it to real water. Next, defendants erroneously contend that only a neurologist is qualified to opine on MG. However, physicians in many other specialties regularly diagnose, treat, and research MG, which is illustrated by the article on autoimmune hepatitis and myasthenia gravis cited in our brief, which was authored by internists, not...
And Mr. Egley, I don't want to cut you off, but there's a distinction between opining on standard of care versus causation.
Exactly.
And for example, a general practitioner can diagnose a herniated disc at L4-5.
That's correct.
That doesn't mean he can do the surgery.
That's absolutely... But the point is, I'm trying to get to, Judge, is Ms. King's treating physician who diagnosed her MG, Dr. Mahajan, is a neurologist. That's his specialty. So, and Drs. Hirschfeld and Dr. Hudson both have clinical experience treating patients with MG and are qualified to opine on MG. Defendants have no evidence to dispute Dr. Hirschfeld's and Dr. Hudson's qualifications to opine on MG and no experts to contradict their opinions. that King has MG and that it was caused by real water. Lastly, defendants raise a new argument in their reply asserting that Drs. Hirschfeld and Dr. Hudson do not meet the assistance requirement under Hallmark. This argument was not raised in their motion and should not be entertained. The first time it comes up is in their reply. Nonetheless, both Ms. King's experts meet the assistance requirement as they base their opinions on their review of King's records, the available research on the neurological effects of hydrazine. All the studies show hydrazine causes not only liver damage, but neurological damage as well. Myasthenia gravis is a neurological disease, which was caused by this hydrazine. And they also rely on their the neurological effects of hydrazine and their extensive clinical experience treating patients with MG. Their experience, education, and research renders their opinions more than sufficiently reliable to be admissible, and they clearly meet the assistance requirement, and thus defendant's motion should be denied summarily.
All right.
Thank you, Your Honor. If anything was in the reply that wasn't in the opposition, it was in response, and to the motion was in response to the opposition. But moving on to what the point here is that we've, MG has been abandoned numerous times. There's no testing that confirms it. Counsel didn't address that. He just keeps talking about what his doctor's going to say. All the tests say he doesn't have it. But really what the basis of the argument is, they recognize that MG has not been confirmed to exist, support the diagnosis as a possible. So what they did in the opposition, really, Your Honor, is they shifted to this, seronegative MG. Seronegative MG is someone who has this medical condition, but the required indicators on diagnostic testing aren't proven. Her MG isn't proven on diagnostic testing. So then they shift and they go, oh, you're right, but she has seronegative myasthenia gravis. Yeah, but there's not going to be any tests to show that. So, however, the medical records, Your Honor, there's not a single treating physician that has conclusively diagnosed her as suffering from seronegative MG, the SNMG. It isn't there. Dr. Mahajan's medical records indicate SNMG, but at each turn he always indicates the condition as a possible. That's not a reasonable degree of anything. That's just some illusory, maybe, if, ands, buts that counsel's referenced before. There is no MG diagnosis because it hasn't been confirmed, and the seronegativity MG, as they call it, isn't even included in any of the reports. And for that reason, it doesn't meet the standard of Hallmark because it cannot be tested. And there's no basis for it. Thank you, Your Honor.
All right. And I just want to make sure I'm clear as far as the current status of the evidence, because it appears to me that Dr. Hudson and Dr. Hirschfeld has opined on this specific issue. Is that correct?
They have, Your Honor.
Well, our argument still remains, Your Honor, is they don't have that expertise.
Okay. Well, I will handle it this way. When you're talking about expertise, you're not really talking about the assistance requirement. You're talking about the qualifications requirement. That's really what you're focusing on. Secondly, when it comes to, and that's why I made the comment I made before, there's a difference between diagnosis, because you look at it through this lens. Your ordinary family practitioner, he's the gatekeeper, because many times they're the first line of defense when it comes to diagnosis. That doesn't mean they might not, they will treat the underlying ailment. For example, they're not going to perform a laminectomy at L4-5, but they can diagnose, right? And there's a difference between diagnosis versus standard of care, and that's why I brought that up. That's not much, and I think what happens, lawyers sometimes go down this track where they're saying, well, he's a neurologist, so he can't opine on this specific issue. Well, doctors when it comes to diagnosing, they all can diagnose. The issue comes down to whether they're gonna ultimately perform that surgery or treat, that's another thing. And so I'm looking at it from this perspective. We have Dr. Hudson and Dr. Hirschfield, that's their opinion, and they weren't deposed, were they?
Hirschfield was not, Hudson was.
Yeah, but I mean, there's nothing in the evidence.
But they.
To the contrary.
They did not ask Dr. Hudson anything about MG. Is that-
Yeah, well, that's my point. There's nothing in the evidence to the contrary.
That's correct.
Yeah, and so based upon that, and understand, I'm not a doctor, I'm not here to sit and weigh and balance and who said what in the medical records. At the end of the day, when we deal specifically with issues like this, I always look for testimony. And I'm gonna deny the motion.
Thank you.
This issue will go to the jury. Unless, of course, you cross-examine on the stand and they pull back.
Well, I would point out that the court has already ruled on causation.
No, I got it, but I'm just saying.
And they have no causation expert to refute Dr. Hirschfeld on MG. They have no causation to refute Dr. Hirschfeld or Dr. Hudson on this issue. Their only causation expert is Dr. Alsina, and he stated specifically under oath in his deposition, he is not qualified to give an opinion about MG or its cause and will not be making any opinions. So Dr. Hudson and Dr. Hirschfeld's opinions that it was caused by real water is unrefuted. They have no evidence otherwise. So in that line, Your Honor, the
Well, I
MG,
understand,
the causation should be granted on MG as well as all the other causation. I assumed when you ruled on that motion, when you said causation, I thought it was for everybody's injuries. Maybe I'm wrong, but in this case, if that's not the case, I'm making the motion right now that it should include Lisa King's diagnosis of MG, because they have zero evidence to oppose that. They have no experts, no affidavits, nothing. And this one rogue record they're talking about is one tiny record from the Mayo Clinic against a mountain of records from her treatment.
Yeah, if I could have the final word on my motion, it is funny, is there's no evidence, except, well, maybe some tiny evidence, maybe some, no, there's a whole mountain of evidence from Mayo Clinic, she doesn't have the condition. That's medical evidence.
Yeah, there is not a mountain of evidence for Mayo Clinic, Your Honor. That's just nonsense.
I mean, ultimately, as it relates to Hudson and Hirschfield, there's no expert opposing their opinions in this case,
That's correct.
right?
It's contrary to the medical records, Your Honor, from Mayo.
Well, the medical records from Mayo won't be testifying in this case. You need an expert.
Yeah.
Right, and those experts will have to explain how those reports are inaccurate.
Well, it's my recollection. Was it Hirschfield, his deposition was taken?
Hudson was taken,
okay.
wasn't asked about MG. Hirschfeld was not taken.
Yeah, right, and it's, if you want to create issues of material fact, that should happen during discovery, during the deposition time period. I mean, it's really that simple. We have Hudson and Hirschfield, I'm gonna grant the motion.
Thank you, Your Honor.
I'm sorry, Your Honor, which motion?
I mean, I'm sorry. I'm gonna, what's the call of the question again, thank you?
It's defendant's motion for summary judgment, partial summary judgment, as to plaintiff Lisa King's allegations of developing myasthenia gravis as a result of consuming real water products. And
I'm gonna deny that motion.
and then,
It appears to me we have unrefuted testimony regarding causation in this case as it relates to MJ.
and so I'm just trying to clarify that.
That would come under the prior causation.
So causation's established for that as well. Thank you, Your Honor.
All right, Your Honor, just so I know, since I guess there was a motion within a motion there, is the court's ruling on the first motion, and that made the court's ruling on the first motion in this case, that all of the plaintiffs and all of their claimed injuries were caused by consumption of real water.
Yes,
Okay, thank you.
yes, yes.
Well, claimed injuries that are supported by medical expert testimony, which they are.
Yes. That'll be
She
for-
conceded on some of these earlier.
That will be reflected in the order,
Right. Okay.
with particularity.
All right, thank you.
There's actually one more motion for partial summary judgment, which was not addressed in the, joint status report. And that is docket number 269, defendant Nevada Beverage Company's motion for partial summary judgment on punitive damages.
So
That's
that is,
moot.
that's
Thank
moot.
you.
And that could be into the moot section,
Yeah.
I don't know. Take a quick 10 minutes? Take 10 minutes.
All right.
All right, we can go back on the record.
We are on the record.
Okay, what's next up?
Judge, I think motion eliminating number 1 for plaintiffs would be the next one. Judge, I'd like to address 2 of them. I think they're related. Motion to eliminate number 1, which is to include evidence or reference that Andrea coordinates AIH was triggered by anything other than real water. And also number 7, which is to preclude Dr. Tanner from testifying about speculative alternative causes of the AIH. Dr. Tanner, if you remember.
And that's number 12, is that what you said?
7, 1 and 7. Dr. Tanner, if you remember, was involved in the previous trial. He was the one that wanted to give a could have been opinion. He didn't have an opinion to degree of medical probability. In the previous trial, you excluded him. So the factual pattern here, we had 3 women in the fall of 2018. They were all drinking retail bottles. One of them was Leila Clay, she's 6-year-old. One of them was Lisa King, I think she was 28 or so at the time. And then we had Mrs. Bourdonnais, who was 40 at the time. 3 different women, all drinking real water retail bottles, and they all got AIH at the same time. We have Dr. Singh, our statistician, who calculates the odds of that at 7.6 billion to 1. And so what we have here is the defense wants to have Dr. Tanner come in and say, could have been this, could have been that, could have been idiopathic. I know the court's already ruled on causation, but I have a fear that, at least when they cross-examine Dr. Hudson, they're going to try to get into this could have been stuff. So I think these motions are still operative. Under Morsicato, they have to accept the plaintiff's theory of causation as plausible. In this case, we have an interesting dichotomy because we have Dr. Alsina, their expert, he's the real water expert, testifying that it is plausible that hydrazine can trigger AIH. And that's his deposition question. So hydrazine, without regards to what source it comes from real water, whatever, can be a trigger of autoimmune, correct? Answer, yes. Okay, so he accepts the plausibility, but he does not have an alternative causation for Nick. So what they've done is, instead of using their own expert, instead of dancing with the girl they brought, they want to run and hire the Nevada Beverage, or present testimony from the Nevada Beverage expert. That's Dr. Tanner. But we have a procedural problem with that because they didn't properly designate Dr. Tanner. But the more important point is, again, it's could have been testimony when he clearly does not accept the proposition that hydrazine is a trigger for AIH. So that is why he's got to give an opinion to a specific cause to a reasonable degree of medical probability for Bourdonnais. He doesn't do it. He just says it could have been this, could have been that. I don't know what it is. But that opinion should be out of the case under the plausibility standard for Williams and Morsicato. And in Morsicato, Your Honor, that was our office's case. That's the same mistake that was made therein. They let Dr. Schenck come in and say, well, Morsicato, it could have been this, could have been that, could have been anything other than.
Because that was Judge Earl, right?
Yeah, that was Judge Earl, who was a great judge, in my opinion.
Yeah, he was. I mean,
Your Honor,
I tried my first case with him.
Even great judges make a mistake here and there. Okay, and remember the way that happened, Mr. Jones had Dr. Schenck on the stand, And Judge Earl told him basically, well, you can't say could have been, could have been, could have been. You got to say, well, and he kind of allowed the guy to rehabilitate himself. And that was the problem with the Morse County guy. You know, it's a shame that 15 years or so after Morse County, we have the same problem yet again with Dr. Tanner. But that's why both of these motions should be granted. And again, one is evidence or argument. They shouldn't be allowed to suggest these alternative causes that they have no support for to Dr. Hudson during the testimony. And 7 is specifically to preclude Dr. Tanner from testifying about alternative causes. Thank you, Reverend.
Thank you, sir.
Mayor, Your Honor?
Yes, you may.
Your Honor, if it's okay, you and counsel may have to split this if we're gonna argue those motions as one, because my partner prepared the Tanner motion. But that being said, our opposition is let's talk about Dr. Hudson and this business about triggering. Dr. Hudson testified, and his deposition was taken, that as it relates to autoimmune hepatitis liver disease and how it gets triggered. And his position is, no, I think the wording is the same. I think a trigger it's a little more accurate because it then says that, well, you've got this, and then there was something else that caused the disease to occur. He's talking about Ms. Bordenave. And it's our position is that this was not, her condition was not a drug-induced liver ailment. Instead, it is idiopathic, and there could be any number of other reasons. That's why they keep talking about it could have been this, that, etc. Then Dr. Hudson goes on to testify, these patients, again we're talking about Bordenave, be predisposed to autoimmune hepatitis or autoimmune disease, and it can be triggered by hydrazine in real water. His problem is, Your Honor, is that his testimony, Dr. Hudson's testimony, where he tries to clarify his conclusions regarding hydrazine being a trigger, predisposes Ms. Bordenave to be predisposed to AIH. But he admitted he did not know if she was, if the plaintiffs were predisposed to it. This simply makes a comment that you can be predisposed to it like an alcoholic, I think was his reference is, well, you don't know who can, how people can react to alcohol. You could have a sip and it would greatly affect you, versus you could drink a gallon. I'm paraphrasing here that it wouldn't. Well, that's certainly unreliable, and that's not a sound medical evidence. What's worse, Dr. Hudson admitted that, you know, in this particular case is that those are assumptions. That, you know, well, it may trigger it because they may be predisposed. Well, how do you determine someone's predisposed? He doesn't have an answer to that. It's just his way of somehow getting around. There's not a science to back it up. So that's how we address Dr. Hudson. Now, I can go into great detail, and it may be redundant, but I would like to address Dr. Tanner, and then it gives okay to turn it over to counsel. Is Dr. Tanner reviewed Bordenave's medical records and her deposition testimony, as well as numerous other reports and articles. As all that foundation, his deposition was taken. Informing his opinions, he did testify with a reasonable degree of medical probability as to his opinions, because I asked him the question. He used his medical expertise in gastroenterology, liver and pancreatic disease, and his focus in epidemiology. He conclusively determined, 1, there's no association with AIH with real water and hydrazine. 2, as it relates to Bordenave, her disease occurred before the identified epidemiological window associated with real water and acute hepatitis. That's the 2020 outbreak. And that Bordenave never consumed the water from 5-gallon jugs associated with the cases of acute hepatitis. And then during his deposition, sworn testimony, he expressed and confirmed that hydrazine is not associated with cases of AIH, and that none of the drugs that she was taking were associated with AIH. Therefore, he directly contradicts with medical testimony her proposed causation. When proffering his opinion, Dr. Tanner did not speculate as to other possible causes. Didn't need to, because it's not that one. Relying upon his review and analysis of case reports and negative findings on drug liver toxicity databases, Dr. Tenner identified the most likely cause for Ms. Bourdonnais' condition, given the timing, the lab findings, the presentation, the response to steroids, autoimmune hepatitis, is a far more likely etiology than acute hepatitis that she suffered in 2018, almost 2 years prior to the outbreak. So for that reason, we believe that the motion should be denied, and if it's okay, I'd like to turn it over to my co-counsel.
And that's fine.
Thank you, Your Honor. Most of the issues addressing just the nature of Dr. Tenner's testimony were covered by Mr. Johnson, so I'll just point out that in the reply brief, there was an argument that Real Water shouldn't be allowed to call Dr. Tenner at all. Obviously, we didn't have an opportunity to brief that, but the question in calling another party's expert at trial is whether there is any potential for unfair surprise, and that's from the McClendon v. Collins case and the Sampson v. State case. Both of those are Nevada cases on point, and the question of unfair surprise is a pretty clear one. He was deposed. Everyone knows what his testimony consists of. Everyone had an opportunity to question him on those issues. And he was designated as a potential expert in Real Water 16.1s pursuant to NRCP 16.1A2, and Real Water's expert disclosures indicated that defendants reserve the right to call any expert witnesses identified by any other party. So there is no unfair surprise. It is not improper to allow a party to call an expert that they didn't retain. That testimony is still competent. It's not prejudicial, or not unduly prejudicial, and there is no danger of unfair surprise. Thank you.
What about Dr. Tenner? That's the basis for his opinion.
So that was addressed in part by Mr. Johnson just moments ago, so I'm happy to speak on that a little bit more. The basis for his opinion is that he determined, one, that there is no association of AIH with Real Water or hydrazine consumption. Plaintiff Bourdonnais' disease occurred before the identified epidemiological window associated with Real Water and acute hepatitis, plus his own expertise in gastroenterology, liver and pancreatic disease, and his focus on epidemiology. Just to elaborate a little bit more on that point, Your Honor, even plaintiff's own expert, Dr. Hudson, testified there is no existing study that supports the theory of hydrazine as a trigger for AIH. Real Water's expert, Dr. Alsina, testified similarly, stating there is no peer-reviewed study or other authority that identified hydrazine as a cause of AIH. And Dr. Tenner insisted that, based on plaintiff Bourdonnais' specific medical history in his own training and expertise, her AIH would be idiopathic and not drug-induced. Thank you, Your Honor.
Judge, again, I need to point out that Dr. Alsina is their expert. He is the hepatologist that Real Water hired to study the Bourdonnais case. Dr. Tenner is Nevada Beverage's expert. They're trying to throw out the plausibility testimony of their own expert, which I read to you, which is that hydrazine is a possible trigger, and then they're trying to run to this gastroenterologist. He's not a hepatologist, he's a gastroenterologist. He's hired by Nevada Beverage. He says it's not plausible. That's the whole basis of his opinion, that it has to be, could have been something else, okay? That it's not plausible. That is the, so there's two problems with that. First of all, they chose Dr. Alsina. He testified on the key point, the plausibility, in agreement with Dr. Hudson. They don't like that, okay, but they're stuck with that. They can't get an expert from another party to contradict their own expert, which is what they're doing, but assuming they could, we still have the same problem with Dr. Tenner we had in the past trials. Since he doesn't accept the plausibility theory, he's got to give a specific alternative cause to a reasonable degree of medical certainty. Did you hear anything? You didn't hear anything. There's no other alternative cause. They have nothing. They want him to say, oh, could have been this, could have been that, could have been that. We just
But
don't.
under plausibility theory, he still has to accept plaintiffs like.
He's got to
Causation.
accept plaintiff's causation theory, and he doesn't do it. He says that hydrazine is not a trigger for AIH. And that's despite the science. We have, we cited articles from the 5 different leading AIH experts in the world that all say that hydralazine, which metabolizes hydrazine in the blood, hydralazine is an AIH trigger. And Dr. Alsina, when I showed him the article, he goes, oh yeah, I agree with that. Okay, so their response is, forget the science, forget our expert's opinion, there's not a clinical study. Okay, well, of course there's not a clinical study. We can't be given
I don't want to cut you off, Mr. Kemp, but I do have a recollection of the history of this case.
Right.
And it's my recollection that potentially why they don't have a study such as this, because no one expected hydrazine to ever be in water.
Well, not only that, but you can't feed people rocket fuel and study what happens.
Well, that's
that
kind
would
of my
be unethical,
point. No one
right?
ever did that test.
You know,
I mean,
even the federal government with the liberties they take confine themselves to monkeys and baboons and guinea pigs and stuff. Even they didn't feed it to people. But that's what defendants are requiring when their own expert admits it's a trigger. You know, forget the science. The guy they hired says it's a trigger. Dr. Tenner doesn't, though.
but I mean, in essence, what they want is two experts.
They contradict each other.
But I mean, once they designated Alsina to opine on causation issues, he gives his opinion, how can they run the Tenner?
They can't, Your Honor, and especially the way they did it, okay? They didn't do it the way it's been done in the litigation, which is a specific deposition of the expert by name. And the reason that that's been the practice here is, we had so many defendants for a while because of all these retailers. They all had different experts.
Right.
And some of them were antagonistic to the real water liability position. For example, UNFW, their 2 experts, RevCheck, and another one just went to town on the Henderson plant. So that's why you can't just designate, all the defense experts, because you'd be designating an expert against yourself. You have to say specifically who you designate. They didn't do that, Your Honor. They just had some footnote saying, we reserve the right to call any other expert we want. Okay? They don't have Dr. Tanner's name listed as a designated expert in their expert report designations. So that is the first problem here. Procedurally, they didn't really designate him. They're just trying to grasp him at the last minute because they don't like their own expert. And that's wrong. But the more important point is the plausibility point. You just can't let a guy do could have been, especially with their expert, their real expert, their hepatologist says it is plausible. And so for those reasons, Your Honor, motion names number 1 and 7 should both be granted.
And for the record, I just want to make sure I'm clear, plaintiff's motion in limine number 1, preclude argument, evidence, or reference for plaintiff Andrea Bourdonnais. AIH was triggered by anything other than real water. That's the call to question, right?
Yes, Your Honor.
Okay, I'm gonna grant that one. And then moving on to number 7. Preclude Dr. Tenner from testifying about speculative alternative causes of autoimmune hepatitis suffered by Bourdonnais. I'm gonna grant that one too.
Thank you, Your Honor.
Where do we go next? We have 15 minutes.
The next one on the joint status report is plaintiff's motion limine number 5. I believe that there's now been a stipulation as to that, so I think it could be easily granted and just resolved up.
Is that the pre-admit Eurofins retail size bottle?
Correct, Your Honor.
That's correct, Your Honor. We've stipulated that.
Okay, so stipulated, pre-admitted. Then what's next?
Yeah, sure.
So that would be plaintiff's motion limine number 6, preclude real water expert Dr. Robin from speculating that Bonnar Bonnar Diaz pathology report states no nodules when it actually is nodules. And that's docket 262, if that helps, Your Honor.
Yeah, I have.
Motion number 6602. Okay, Under Dr. Robbins, you may recall, was the pathologist at the last trial who wouldn't give me back my cornea for a while. I don't know if you remember that episode. The jury told us later that that was one of the highlights of the trial. So, we're not trying to exclude Dr. Robbins. What we are trying to exclude is, number one, there's a medical record, and this is it. Can you pop up the, this is the pathology report for Bonnar Diaz. And if you take a look, farther down, Shane, the nodule line. There we go. Right there where he says, quote, regenerative nodules are seen. Okay, this is the independent pathologist. This is before anybody knew anything about real water. November 21st, 2020. Again, the plaintiff is Bonnar Diaz. So he says he sees regenerative nodules in this slide. Okay, this is consistent with our expert's opinion. And what Dr. Robbins, their expert, wants to testify is he wants to say that this is a mistake, that it should really be read, no regenerative nodules. He wants to rewrite and change the medical record 100%. They didn't, Robbins didn't talk to the treating pathologist. They didn't depose the treating pathologist. They didn't depose anyone in the pathology department. There's not one scintilla of evidence that this was a mistake, and they claim that there's some expert methodology that allows their defendant expert to say, oh, this guy made a mistake, he really agrees with me. Well, Your Honor, Dr. Robin is a pathologist. He's not a psychic, okay? So all we are asking in this motion's first part is he shouldn't be allowed to tell the jury that there's some mistake in this expert report. They shouldn't be allowed to argue this pathology report. They shouldn't be allowed to argue to the jury that there's some mistake. I mean, it's not good for them. I can see that the independent pathologist found regenerative nodules because that's an indication of serious injury. But it's right here in the report. They can't just wipe out parts of the medical records they want by having their experts say, oh, we don't like that. Let's put a no there. Okay? And so that's the first part of the motion. The second part of the motion, Shane, can I have the quote from Dr. Robbins' expert report on virgin fibrosis? In his expert report, he's got, okay, I think the expert report, I think it's for that. Let's start here. See the quote there, note the appearance of bridging fibrosis? That comes directly from his expert report. That is his finding that he puts next to this is his report. This is Dr. Robbins' expert report. You see the bridging at this point, Your Honor, you're a pathologist. You see the blue there, that's the bridging fibrosis. Okay.
I remember the testimony specifically regarding this issue at the prior trials.
So in his expert report, he says, note the appearance of bridging fibrosis. Now, when we take his deposition, go back to the deposition quote, Shane, from the clock. It's in the text you had before. In his deposition, I asked him, okay, well, there's bridging fibrosis, right? And he goes, oh, no, there's not bridging fibrosis. There's really a longitudinal section through a portal tract. Okay, and basically that means the slide wasn't cut right, Your Honor, so it shows something that's not there. That is not in his expert report, this longitudinal section. So he conceded bridging fibrosis in the report. when we take his deposition, he wants to say no bridging fibrosis, just like he wanted to rewrite the medical record to say that there was no regenerative nodule seen. You know, you can't just flip-flop the opinion 180 degrees, okay? I mean, it's pretty clear what he said. And I think a light bulb went on in someone's head that, oh, if Vanya Diaz has regenerative nodules and bridging fibrosis, she's got stage 4 cirrhosis, and she might need a liver transplant soon. So this is a really bad case for us. So at some point before his deposition, the light bulb went on, and so that's why they did all these gyrations to insert the no there and to flip-flop on his opinion. And you just can't do that, Your Honor. And I think the real prejudice to us was that if he had come out in the beginning of his expert report and said, oh, it's not bridging fibrosis, it's a longitudinal section, rather than saying the exact opposite, we could have had the slide recut to prove this definitively one way or the other, okay? He deprived us of that right of doing that. We could have had a rebuttal testimony on this point. So I think he should be stuck with this opinion. But those are the two issues that are raised by this motion. One, can they rewrite medical reports by adding no's to any findings that aren't good for them? And two, can he flip-flop on his opinion? So I think the motion should be granted in both parts, certainly the first part.
Your Honor, the history of this matter is fairly simple. If you take a look at plaintiff's exhibit number 2, it's the pathology report. It's actually the first document that was put up in the screen. This is a medical report from 2020 for plaintiff Vanya Diaz. It's a Dr. Yumiako's report, and it objectively, without question, contains Scrivener's errors. That is not up for debate whatsoever. If you look at the bottom of the page, 3 lines from the end of that document, it says, the above findings, again, this is an image of her liver. It says, the above findings show features of resolving dermatitis. I do not believe that the issue that Ms. Diaz is bringing before this court relates to inflammation of her skin. This obviously was not a skin biopsy. That's a typo. There's clearly typographical errors in this document. And if plaintiff's argument is to be adopted, that we have to take the document as what it literally says and not read into the errors that exist in it, then they have to accept that this was a biopsy of her skin and not of her liver. We're not making that argument because it doesn't make sense, and it wouldn't be in good faith, that'd be meritless. That's essentially the argument that they're presenting before you right now. 2 lines before this dermatitis typo, the report states, no significant fibrosis is present, regenerative nodules are seen. In Dr. Robbins' report, he writes clearly and unambiguously that he reviewed the very same liver biopsy slide that Dr. Yumiako reviewed, and he concludes, first, there was no fibrosis. So, exact same conclusion as Dr. Yumiako. And just to digress a moment, it was stated during the argument that, they need to be put on notice that his opinion was that there was no fibrosis, and that wasn't in his report. It is. It's Dr. Robbins' report, page 5, disclosed as Robin 00015, quote, there was no fibrosis. That's his opinion in the body of this report. This isn't a trick. No one's deceiving the plaintiffs or trying to change testimony at the 11th hour. It's always been his position, there is no fibrosis. Next, he writes, Dr. Robin writes, I observed no evidence of regenerative nodules. So, here, for the first time, we do have a conflict between Dr. Robin's observations and Dr. Yumiako's report. What Dr. Robin does is he concludes that more likely than not, Dr. Yumiako's report contains a second typographical error, just like saying she had resolving dermatitis. In his deposition, he explained this clearly. Question: you think there's a typographical error? Answer: that's because there were no regenerative nodules observed on the pathology of the slides that I reviewed. And there was another typographical error on the report that states the above finding shows features of resolving dermatitis. There was no skin biopsy. The pathologist meant to say, or did say, and the transcriptionist made an error, when in reality, what he meant to say was the above findings show features of resolving hepatitis. Next, he explains that the report's reference to regenerative nodules is a typo. It would be very unusual, this is according to Dr. Robin, his depo, it'd be very unusual to see a regenerative nodule on a liver from an individual who had acute liver injury from a toxin or a drug to develop regenerative nodules without having fibrosis. There's no evidence of chronic liver disease, and there would be no reason for the liver to develop regenerative nodules. So not only is he explaining, look, I looked at the biopsy, it's not there. Also, his findings wouldn't make any sense if he actually said that there were regenerative nodules seen, because he immediately before it said there was no fibrosis. He said you wouldn't have those two things side by side. That's why he assumes it's a typo. He's not trying to change his conclusions. He's explaining how it's possible that you could have no significant fibrosis present and then say, but regenerative nodules are seen. Saying you wouldn't have those two findings side by side. And when you look at the fact that he said there was resolving dermatitis, looks like it was a Scrivener's error. He's not trying to change anyone's testimony. He's relying on his interpretation of the slides that he personally saw. Again, his report is absolutely clear. Quote, I observed no evidence of regenerative nodules, close quote. He's never changed his opinion on that. Second issue is that plaintiff takes issue with the fact that one of the exhibits in his report, not his report, not the body of the report, which I just quoted to you, which is direct and clear, no regenerative nodules, but that in an exhibit, he says, note the appearance of bridging fibrosis. What he says in his depo is, quote, I meant that some less experienced pathologists may interpret this as bridging fibrosis when, in reality, it is a longitudinal section through a portal tract. So, is it possible that they can cross-examine him on this point and try to impeach him? Sure. But to exclude the testimony, the methodology he went through, and the rationale for why, that's completely inappropriate. He looked at the records, he looked at the slides, he was direct and concise in his findings, and those have never changed. He absolutely made clear that he was never stating that there was bridging fibrosis.
How can he speculate as to whether something was a typo or not if that wasn't his report, if he wasn't the author of the report?
Because again, it's clearly a typo in the next line where he says resolving dermatitis.
Well, but as far as his ultimate opinion, yeah, I mean, that might be inconsistent, but how can we say what he put in his report as it related to the key issue in this case was a typo?
Well, again, if we have to accept the literal words that are on the report and not explain what's behind it and the medicine that would be behind it, then they would have to accept that this was a...
here's my point. Maybe they can disagree. That's one thing, but to say it's a typo is another thing.
Okay, well, even if he doesn't use the word typo, he can say that when you do not have significant fibrosis present, you would not have regenerative nodules. That's his medical conclusion. And he would actually articulate that even a rookie pathologist would understand that, so it's really impossible for this to be anything other than a typo, other than really impugning the skill and capability of the physician that
But how do we know
originally
it was a
this.
typo? And that's kind of my point. I mean, he can disagree potentially, but he can't come to some sort of conclusion that it was a typo.
But again, he can explain his methodology and why he disregards that conclusion, just like we would all disagree and understand that this was not a dermatological slide.
What about his prior opinion that's somewhat mirrored what was set forth in the report?
What prior opinion is that?
Didn't he have a prior opinion where he put in, what did he put in his report?
The report that we're talking about here
No,
today.
I'm talking about your expert's report. What opinion did he put in his report?
He put in his report, I observed no evidence of regenerative nodules, close quote. That has always been his opinion. That was the disclosed report, page 5. He's never changed his opinion. He didn't say in the exhibit that there are regenerative nodules. He was saying that someone could look at that and make that conclusion, but they'd be wrong and explain why. He has never changed his opinion. His initial report, in the body of the report, quote, I observed no evidence of regenerative nodules. This wasn't a 180. This isn't a changing of opinions. This isn't some sleight of hand. This has been his opinion from the moment his opinion was disclosed. If there are no further questions, Your Honor.
Not at this time.
Thank you.
Thank you.
Is that last answer to your question was kind of curveball? The portion of the report we were addressing was his part that said, note the appearance of bridging fibrosis, unquote. We weren't talking about his saying that there was no regenerative nodules. Dr. Robin, we're not asking that that be precluded. He can say there's no regenerative nodules till he's blue in the face. He can't just say, but he can't say that there was a mistake on the underlying pathology report, and I'm speculating that there was a Scribner's error, so the underlying pathologist agreed with me. That's the first point, okay? The second point is the bridging fibrosis. What he said in the report was, note the appearance of bridging fibrosis. It's right there, Your Honor, it's clear as day. Okay, so I confronted him with that, and he said, oh, what I really meant was longitudinal sections.
So is that a Scribner's error?
Your Honor, I'm sorry, but I have to interject. That is the exhibit to his report, his actual report, quote, there was no fibrosis. He's saying someone could look at that and see fibrosis, but his report, quote, there was no fibrosis, page 5.
Okay.
He explains why he said use the word appearance, because it's not there.
Judge,
This wasn't a changing of opinions.
It got so bad in his deposition that I confronted him with this, and he said, well, what I really meant is 95% of the pathologists in the world who don't have the experience, 95% he said, would call this bridging fibrosis. But it's really not bridging fibrosis, it's really a longitudinal section mistake, which he didn't say in the report. So, again, we are not trying to preclude him from giving his opinion that there's no regenerative nodules on the slide. We're just trying to get away from the Scribner's error. And on the second point, I think he should be stuck with his opinion. Note the appearance of fibrosis. I mean, true, we could use that during cross-examination and really beat him over the head with it, but he's flip-flopping. And by doing that, by changing it to this longitudinal section, like I've said, we could have had the slides recut to completely disprove this, and you know, then I don't know what they'd come with to try to flip it again. But he deprived us of the right of doing that by putting clearly that it's the appearance of bridging fibrosis. So he should be stuck with that opinion, Your Honor.
All right, and we're on motion to limine number 6, is that right?
Yes, sir.
I'm going to grant it as to speculating as to whether there's a Scribner's error or not. The other issue I'm going to think about, because I think we have two points, right? One point he says in his report, but then in that slide portion you showed me, it was contradictory. I want to make sure I understand what's going on.
Okay, thank you.
So I want
Yes,
to
Your
look
Honor,
at that.
and that is briefed in the opposition, so you can definitely take a look at that.
Yeah, I want to take a look.
Yes.
That's a different issue.
Thank you.
Okay, it's lunchtime. Right?
Yes.
So how many did we get done this morning?
Not many.
Now, in our window, we haven't gone into the ones that have already been ruled upon yet, so those should move quicker. These have all been new and specific. to this
How many
case.
more new ones do we have? We got 11 done? Well, that's actually pretty good, 11 done.
11 new ones, so.
Yeah.
even
How
better.
many more new ones do we have?
Not many. I can recount and get you a total number after the break.
Yeah, 120.
129.
All rise.
Thank you, ladies and gentlemen. I'll leave you at five after one. You guys know. Thank you.
Problem solved.
My back hurts.
So we have the technical issues taken care of, Tracy? Everything's fine?
Yeah, we don't all have to work that.
Well, we'll do it another day. Just turn it.
Thanks, Ken.
We're on the record.
That's what I said. You get them. All right. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Robert Egglet on behalf of the plaintiff's, Your Honor.
Will Kemp for plaintiffs. Can I do title for the plaintiffs?
Brianna Slitzler for plaintiffs.
Eric Pepper, move
Sorry. Brad Johnson, Tyler Watson, Michael Esposito, Pat.
You obviously slow getting up there. Are you okay, man?
Eric Freeman on behalf of Real Water.
Your Honor, the next motion we're going to do is plaintiff's motion limit number 10 to strike Dr. Alcina's causation opinions.
All right.
Just let me know.
I'll let you know when I'm ready, Mr. Egglet. Got so much on my desk right now.
You have a pile there, Judge.
Oh, yeah. I have, we have 3 of these cards.
10.
Number 10.
I think you need a valet just to hand you those books, Judge.
Yeah, normally I have my law clerk, but she's working on something else. All right.
Thank you, Your Honor. Your Honor, plaintiffs seek an order striking Dr. Alcina, the defendant's expert, Dr. Alcina's causation opinions under Williams. Dr. Alcina's causation opinions fail to meet the Williams standard because they are purely speculative and unsupported by medical evidence. His own deposition testimony confirms this. Under Williams, medical expert testimony, as this court is fully aware, about causation must avoid speculation, and their testimony must be supported by competent medical research. Williams prohibits defense experts from engaging in speculation about possible causes. Dr. Alcina's opinions fail the standard in 3 ways. First, regarding Lisa King, Dr. Alcina explicitly admitted in his deposition that he is not qualified to offer any opinions about what caused Ms. King's myasthenia gravis, which I will refer to again as MG throughout this motion. Second, for plaintiff Vanya Diaz, Dr. Alcina speculated about dozens of disorders that may or may not need to be excluded, but he could not identify even a single one of these disorders as an actual alternative cause to a reasonable degree of medical probability. At his deposition, when he was asked if he had any other causes besides real water, and his direct answer was none other, sir. Third, for the remaining plaintiffs, Dr. Alcina's opinions about unidentified viruses and potentially hepatotoxic supplements are classic examples of the kind of speculation Williams prohibits. He offers no medical literature in support of these possibilities being actual alternative causes. Dr. Alcina's own deposition testimony undermines any suggestion that his alternative causation theories rise above speculation. For multiple plaintiffs, he admitted real water was the likely cause and he had no other alternative explanation. For Lisa King, he testified he was not disagreeing with Dr. Hudson's opinion that real water caused her autoimmune hepatitis. For Vanya Diaz, he admitted he had no other cause besides real water. For Van Buren, he stated there were no other confounders. For Nicole Chang, he agreed hydrazine from real water was the more likely cause. For Cheryl Nally, he confirmed real water was the only potential cause. Real water argues this is merely about plaintiff's burden of proof. But that misses the point here, Your Honor. While plaintiffs bear the burden of proving causation, that does not absolve defense experts from the Williams requirement that their alternative causation opinions must be more than speculation. Dr. Alcina's alternative causation theories are precisely what Williams prohibits: unsupported speculation about theoretical possibilities without medical foundation. The motion should be granted in its entirety, Your Honor.
Thank you, sir.
Your Honor, based on that argument, I'm not entirely clear on what plaintiffs seek to exclude. Dr. Alcina goes through numerous plaintiffs and their medical background, identifies potential causes, and concludes with all of them that he thinks hydrazine is the most likely. He never provides an alternative causation theory. He talks about things that could have caused it, rules them out, or says he can't determine, but ultimately concludes across the board that he thinks the most likely cause was hydrazine. For the life of me, really don't know what they want excluded. He doesn't provide an alternative causation theory. Thank you, Your Honor.
Thank you.
Well, we want him excluded from the trial from testifying because his testimony is a waste of time. If he's not offering some legitimate alternative causation on behalf of defendants, we certainly don't need to call him in our case. We already have experts that give us that. So the motion should be granted, Your Honor.
Right, and our issue is that he's going to talk about their future prognosis and how they're going to, what their medical future looks like moving forward. He doesn't provide an alternative causation theory. We don't dispute that issue.
Well, yeah, I mean, if they're limiting their testimony, his testimony to that, that's fine. But he cannot talk about causation, Your Honor.
Well, I think they agrees on that.
Okay,
Yeah, he doesn't have an alternative causation theory.
Okay. Motion's granted.
thank you.
So next up will be,
So, Your Honor, there's a number of motions that have been previously determined by this court. If Your Honor is ready to rule on those, we can do those and just try to move along, or if you want to have us submit them on the papers, I think you decide.
what is left?
There's several motions left.
No, I understand that, but what is,
So, the issue that is coming up that we were discussing during the break is that there were a series of motions we believed did not need to have oral argument that the court.
I saw that, yeah.
Yes, and now there is a discussion about either just providing you with that list, which I think we did in the status report.
You did, there was a list, let me make sure, I know I have that, but let me see if I got a lot going on here.
Yeah, it's section 2, motion subject to limited argument / to be submitted on the papers. Starting
Yes.
on page 6.
Right.
And so, Your Honor, our position on the defense side is we do have unique arguments that we've raised that were not raised by prior counsel in prior trials. We still don't believe that there needs to be oral argument on this issue. It seems now that plaintiffs want to present some limited argument, to which we would obviously object, because that's not what we stipulated to. If this court is inclined to have more argument on more motions, and we're not even able to get through the ones that we've designated for argument, we'd at least request that those be moved to tomorrow, so that we compare oral argument, considering we stipulated not to arguing those before this court.
All right. What is left that we need to argue?
Do you want a number?
I mean,
Looks like there's,
Plaintiffs go first. Their motions. What do y'all want to argue?
Mr. Bevan?
Well, Your Honor, there are several motions that are the same exact motions that were filed in the Brown case that have been ruled upon, either granted or denied by you. Our understanding was that in the absence of any change in the law, which there has been none, that those prior orders were not going to change. So with the ones that Ms. Whistler was referencing, we think we could go through them one by one, let you know if you're going to have any thought on changing your order, and if so, we would submit those on the briefs and you can review them further if you'd like. Alternatively, if you're not going to change your prior decision on those, then you can at least let us know now so we can prepare the order so the court doesn't have to.
All right.
And so we have the rulings before opening statements with,
Oh, I
without
mean,
burning
of
the
course,
court.
I think he should have the rulings before opening statement. And here was my thought, because I don't mind saying this, we did prepare my court clerk. We have a matrix of all cases from the, let me pull here. Yeah, we have all my decisions from the Gallagher matter, and this goes back to July 26th, 2023, 24th, and so on and so on. And then we also have all my decisions in the Brown matter. and I have listed here along with docket numbers specifically what I decided in those cases. And so it seems to me, I'll take a look at what's left and then read it. And if I feel that there's been no change in the law or there's nothing uniquely different as far as the facts are concerned, I can make a decision on that. But is there something specific you want argued today?
Yeah, there's a number, we can go through that.
Your Honor, there's plaintiff's motion in number MIL 13, number 34, number 35.
Why would I not
37.
allow jury notebooks?
I think the,
If lawyers ask for that, I can't remember.
It's more the specifics than, they make a slight opposition that's kind of silly in the beginning, but I don't think that's their biggest contention. It's over the actual exhibits and we can argue that now if you want.
Let's go to that now.
That's me.
I can't say no.
Yeah, that's true. These aren't very big.
So, Your Honor, this is plaintiff's motion to allow jury notebooks and motion limiting number 13 to pre-admit plaintiff's exhibits related to the jury notebooks.
For the record, I don't mind saying it, I'll permit jury notebooks if requested. I remember going back 20 years, that was kind of a modern trend, and lawyers stopped doing it, but if I can't remember of any point where there's been a request that I've denied jury notebooks.
So I won't waste time, Your Honor, on arguing for having a jury notebook, because I think it's clear that the judge is going to allow that, and I'll go to the issue of the actual exhibits here. So through this motion, plaintiffs move to pre-admit 4 exhibits they seek to include within the notebook. And what we suggested in the motion was 4 exhibits for the plaintiff's side and 4 exhibits for the defense side. Defendants oppose the pre-admission of these exhibits, claiming they lack foundation and authentication. Well, with respect to the first exhibit, it's the photograph of the power supply, and it's up on the screen here. It's sufficiently authenticated as it was taken by the Southern Nevada Health Department in the course of their investigation of real water, and it was produced in response to a FOIA request, Your Honor. The second exhibit is the FDA concentrate testing exhibit. This exhibit is self-authenticating, and even defendants concede this point. However, defendants seek to add irrelevant and non-probative test results from the FDA's investigation, such as the pH and chlorine levels. And defendants' request for additional documents should be denied, as they will likely confuse the jury. Third exhibit is the Southern Nevada Health Department form regarding Lisa King. And this document is sufficiently authenticated, as the form clearly identifies itself as a Southern Nevada Health District record, and again, it was produced by the Health District in response to a FOIA request. This document is relevant and highly probative, as it demonstrates that King's autoimmune hepatitis diagnosis and exposure to real water was reported to the health department here. The fourth exhibit is the micro photograph of Vanya Diaz's biopsy slide, which came from defendant's expert Howard Robbins' report. Since the photo came from defendant's own defendant's report, defendant's objections based on authenticity are really quite disingenuous. So, therefore, the plaintiff's proposed exhibits should be pre-admitted here. Now, in their opposition, defendants propose 4 of their own exhibits, which are really 7 exhibits, which all contain evidentiary deficiencies. First, defendants seek to use the wet lab water testing results to suggest that real water proactively tested, but there is no testimony to lay the required foundation for this exhibit, and the sole purpose of this evidence is to mislead the jury and to confuse the issues, which just isn't allowed under our rules, Your Honor. Next, defendants seek to include Nevada Beverages distribution documents along with Strong and Garcia's credit card statements as a single exhibit. But upon examination, there is no indication that this is in fact a Nevada Beverage document or that it details distribution. And the combination of credit card statements of two different plaintiffs as a single exhibit is overly prejudicial and should not be allowed. So defendants actually, the second exhibit actually has 3 exhibits in it instead of 1. The third exhibit, or group of exhibits they are requesting, is the discovery questionnaires of Carolyn Strong and Kathleen Garcia's. And there are again 2 documents within a single exhibit. So this proposed exhibit is actually 2 exhibits. And these lengthy fact sheets would be entirely duplicative and cumulative of oral testimony at trial and should not be admitted. I mean, they can use the documents at trial to impeach the witness or cross-examine the witness, but the document should not come into evidence. We don't put interrogatories into evidence. We don't put expert reports into evidence, Your Honor. As for the final exhibit, defendants seek to include...
And I want to make sure the fact sheet, is that something that was prepared by at the request or of the special master? How did that come, just from a historical
Yeah, Your Honor, the special master made, there was at the very beginning of the case, there was a standard fact sheet to be imposed to each plaintiff, and this is their response to the standard fact sheet.
And for their final exhibit, they seek to include an incomplete excerpt of King's medical records from the Mayo Clinic related to her MG diagnosis. And we've already talked about this one exhibit that is misleading, confusing, and doesn't accurately reflect Ms. King's diagnosis or condition of MG. And this has been addressed in the prior motions today. King's MG diagnosis has been confirmed by her treating physicians and expert witnesses. And to be clear, this single medical record does not confirm that King lacks MG. In fact, the record recommends that she get retested because she recently tested positive. And also, the very blood test the record refers to confirms and says, quote, that a negative result does not exclude autoimmune myasthenia gravis. In the inclusion of only this record would imply that the Mayo record is more probative than King's medical record, medical experts' opinions, and the hundreds of pages of records diagnosing and treating King's for MG. And so if this court is even inclined to include defendant's Mayo Clinic record in the jury notebook, then plaintiffs will request that King's complete medical records related to her MG be included and not the excerpt proposed by defendants, which is taken completely out of context, doesn't prove anything, and they don't have an expert to say what it says anyway. In sum, plaintiff's motion to pre-admit exhibits should be granted, and the count of defendants' proposed 4 exhibits is actually 7, so they should, pare them down to 4. And so while the defendants should be permitted to use 4 exhibits that are appropriate here as well, the exhibits as proposed by defendants are irrelevant, lack probative value, and are unduly prejudicial. And the defendant's request for 4 exhibits, which is actually 7, they request should be denied, Your Honor. Thank you.
Thank you. Mr. Kerr.
Thank you, Your Honor. As it relates to the first item that plaintiffs wish to include, we do not object to the inclusion of headshots and names of plaintiffs, but we do object to the inclusion of Stephan Bonnar. He has been settled out. Offer of judgment was accepted. He is no longer a party to this litigation. We have no objection to including the power supply photograph. Regarding the FDA concentrate testing, what plaintiffs want to include is a page of the testing report that shows 2 positive samples for hydrazine, but they exclude the remainder of the report, which shows that there were many more samples that were tested. In fact, there were 21 samples. So, to the extent they want to include that 2 samples came back with hydrazine, we would like to include the number of samples that were collected with the 19 negatives. As it relates to the SNHD form for Lisa King, this document is going to mislead the jury. First of all, the SNHD report concludes that King, quote, does not meet the screening criteria, close quote. So introducing it as evidence to support her claim is improper. Also, the document references pet illnesses, it's hearsay.
When you say screening criteria, what do you mean by that?
For falling under the real water investigation, when they screened a potential person for getting sick through hydrazine from real water, she was not in the criteria. I believe it was due to the timing of when her illness manifested. And then just going back to that SNHD document, it has the reference to pet illness, which again is prejudicial, it's hearsay, and it is subject to a pending motion in limine. Regarding the slide for Vanya Diaz, that's from Dr. Robbins' report with Dr. Robbins' notations. Expert reports are not admissible. It's improper. In fact, Mr. Eglitz said that when he was up here. We don't admit expert reports. Well, if we don't admit expert reports, he shouldn't be allowed to put a picture of our expert's report up in his opening statement or in a jury notebook. It's also subject to the motion that we already heard, that you've taken under advisement, where his report clearly states, quote, no evidence of bridging fibrosis. So doing the apparent bridging fibrosis is misleading and prejudicial, certainly is going to confuse and mislead the jury. As it relates to the items that defendants would like to include, first of all, there's no legal basis for plaintiffs to limit how many documents or items we're allowed to put in. They keep saying they only wanted 4. We actually went through 5 that they want. We're not quibbling with that. I don't know why the number seems to be specific or important, but there's certainly no basis in law to say if we have something we want included that it has to be limited to the 4 that they've suggested. The first item is the wet lab results from January 22nd, 2021. First of all, plaintiffs stipulated to the admission of this document in the Brown trial, so I'm not sure why they're objecting to it now. It was in the notebook last time you did this. As plaintiffs' first argument is almost...
Well, you know why, right? I mean, when you think about it, and I understand the Brown trial, but there's certain areas that you haven't agreed to that were admitted in the Brown trial. But my point is this, that you're right, doesn't matter.
Thank you, Your Honor.
Yeah, I mean, you're right. Go ahead.
As it relates to, I'm sorry, if you don't need any more argument on wet labs.
No. I don't want to stop you.
Okay. Yeah, we would just point out that the court has looked back to what has been done previously. This has been previously admitted. We would ask that it be included here. As it relates to the Walgreens purchase records, Strong testified to these purchases in her depot. As it relates to the banking records, plaintiff themselves disclosed these records. There's deposition testimony verifying that these are their personal banking account records that verify their purchases. The fact sheets under NRCP 33C, these type of discovery responses can be used, quote, to the extent allowed by Nevada law of evidence. There's no specific evidentiary objection to including them. If there's any specific item contained in those fact sheets that should be redacted, we're certainly open to that. But we get to point out that their positions as it relates to where they purchased this water and how they consumed it is inconsistent with the facts of this case. And then finally, King treatment records, they can certainly argue that there's a broader picture, but it is an admissible record. It has proper foundation, it's been disclosed, and we would like to include it. Thank you, Your Honor.
Thank you, sir.
So, let me start at where he finished off with the King record. That has been argued extensively, Your Honor, earlier today in a previous motion. And I think that you understand what they're doing here. This is one document. They have no medical expert to talk about it or authenticate it. and it is misleading to the jury because this one document, according to them, and it's incomplete because it does include the blood test where I pointed out that the document says, quote, "A negative result does not exclude autoimmune myasthenia gravis." So, and she's been treating for this condition for the last 5 years with her neurologist, who they claim is the only expert who can diagnose it, what they're wrong about. And we have 2 experts saying she has this. So if they want that document in, then all of her medical records with respect to MG, because then the exhibit's incomplete, the evidence is incomplete, and it's just something they want to cherry pick and put in there, and that's just not appropriate here when we're talking about joint or admitted exhibits into this notebook. Next thing, this issue with they're saying about the concentrate samples. Counsel misunderstands. There was only 3 concentrate samples actually done. What he's talking about of all these other samples, there's like 1,100 pages, Judge. So you're going to have a huge binder. I don't know if one binder can hold 1,100 pages. Are of 21 water samples, not concentrate samples, water samples. Samples in various bottles that were done. And by the way, in other plaintiffs' cases, not these plaintiffs. So there are only 3 concentrate samples that were performed in this case. The rest of them he's talking about are not concentrate samples. They are 21 bottled water samples. So that, that is just not appropriate. And, they seem to be confusing. I heard Mr. Johnson in an early motion talking about, well, they drank this concentrate. Nobody drank concentrate, Your Honor. People drank the water that the concentrate was put into
Well, I understand, I remember the mixing room,
Yes.
right?
So
I remember the fact.
maybe Blaine inhaled it while he was in there, but to our knowledge, no one drank it. And with respect to the Diaz biopsy, all we're talking about doing is using the photograph of that biopsy as an exhibit here. So unless the court has any questions, with that said, I think our motion. And look, if we're going to do 7 exhibits on each side, okay, then we're going to be presenting 3 more. But we think 4 is a reasonable number. And if you're going to allow them to put this Mayo Clinic, this one part record for the Mayo Clinic that they propose, incomplete record, then it's going to require all of Lisa King's medical records with respect to MG in there, which again is going to make this quite lengthy, the exhibits in this notebook, as opposed to what I think has been proposed and probably used in prior trials. So unless there's any other questions, Your Honor, I'll sit down.
Well, and to the extent, if I could just clarify one point, Your Honor.
Yes, sir.
If they're willing to remove the written statements from our expert and it's merely the image, we have no objection to
Okay.
the image of the biopsy.
That's all we want. That's fine.
Okay, so what's left?
Oh, and the only other point I
But
was
wait a
going to
minute,
make is
I mean,
that.
is our motion, we
No,
gonna have?
I understand
No,
that,
I
he's
just want-
stipulating on that, I just want to make sure.
I was
that-
trying to find
You
Is there
see on
any-
something else too?
Well, I was just going to say, it's
There,
not
I'm
1,100
I'm
pages.
going there,
We
exactly.
want I think 4 pages from the
No, it's not,
SNHD.
it's not testing from concentrate, it's water testing.
No, I appreciate that. I'm just saying you produced 2 pages of that report, we want 4.
And it's testing for clients that aren't in this case.
Anyway, so I guess we have no common ground as far as the number. I mean, typically what happens, and I hate looking at it this way, but for example, if the plaintiff gets 4, the defense gets 4. If the plaintiff gets 6, the defense gets 6. So, you want me to say each side gets 5? I mean, what do you want? I mean, I'm trying to move this along, because I'll take a look in more detail at the issues.
Well, Your Honor, I would say they do have 5, not 4. we're fine with that. We're also fine with excluding the Lisa King document.
Okay, that's
They're
kind
they're
of,
counting the cover page of the plaintiff's photos, I guess, as an exhibit, so.
before, and make sure I have this clear, because, are you a little confused, Tori?
No, what did
I
you-
am.
The Mayo, okay, and they agreed to take the Mayo Clinic, document out, I understand.
All right. Okay, number one, yes, there'll be jury notebooks. A, number of exhibits. We're at 4. Is 4 sufficient?
Yes, Your Honor.
Okay. So make sure, you got that, Tori?
Yep.
Next up, there's an agreement regarding the film, right? Or the
Yes,
slide?
Slide, Diaz slide.
Without the text.
Right,
Without
excluding
text.
Dr.
Yeah,
Rod's
just the
notations.
photo, just the image.
You getting this, Tori? Okay, with that, what's left? I just wanna make sure I know.
The number of documents included in the FDA concentrate testing.
We have 2.
I'm gonna say this again, those are not concentrate testing documents, they're water testing documents that they wanna put in, okay? We're proposing, the concentrate water testing here. It's 2 different things, and they're regarding plaintiffs that aren't in this case.
And you're, I just wanna make sure I'm
It's not- I
clear.
don't know why we're allowing them to add to, why we would allow them to add to our.
I'm not
exhibit.
allowing,
Yeah.
I'm just trying to make sure I
Yeah.
understand. You know exactly where I'm going. I wanna make sure I have certainty before I move on to the next issue. So, let's go back again. The defense wants FDA concentrate testing, is that it?
We just want a couple of extra pages from the same document they're including to show that there were 21 testing that took place on various bottles, whether it was the ready-to-drink or the 5-gallon bottles. They're both listed on the document. And it shows that out of the 21, 2 of which are concentrate and the rest are not, that the other 19 did not have positive tests.
Again, all we're proposing is the concentrate, because that's what's relevant here. The 21 bottles they're talking about are of bottled water. They're 2 different things, Judge.
I understand. Now, that's why I kept drilling down. I want to make sure I understand what was going on factually. One side is saying concentrate, the other is saying retail bottles.
Right.
Correct. And
Okay.
as Mr. Eglett identified, none of the plaintiffs drank the concentrate. They drank from the product that was actually put to market. We think the testing results of the product that was actually put in market is also relevant, and we should be able to reference that in opening, just like they're gonna reference the concentrate.
Well, then, they should be proposing that as their own exhibit. It shouldn't be included in our exhibit. It's 2 different things, Judge. It's not relevant to each other. The water bottle testing and the concentrate are 2 different things.
Yeah, Judge, and the real problem is, first of all, it's 21 other plaintiffs. Second of all, the test run was a screening test. It was a GCMS screening test. It wasn't the sensitivity level of the Eurofins test. So those 21 bottles didn't register positive on the screening test because it wasn't sensitive. There was so much in the concentrate that they did register positive on the screening test. So it's really kind of,
Apples and oranges.
yeah, it's very misleading what they're trying to do, because they're trying to put an exhibit that wouldn't be, it doesn't matter whose real water bottle it is, it's not gonna pass the screening test because of the sensitivity. So that's why none of the experts have talked about it. They don't have a toxicologist on it. We do have a toxicologist. We didn't designate him as a witness, but he could explain all that if need be. But that's why this report shouldn't come in. Or, excuse me, these bottled water tests, these other plaintiffs should not come in.
And I want to make sure when we talk about the water bottle testing, I just want to make sure I'm clear on this, because are you saying that there's no foundation as it relates to the water bottle testing?
Yeah, well, there's no foundation, because what happened, I know a couple of them were our plaintiffs, so what happened is the FDA, anyone who was in the Southern Nevada Health District report, the FDA solicited water samples from them if they had any. So they gave water samples, and then the FDA took them back and did screening tests on them. So the screening test, the sensitivity is not such that it, even if there had been, and there was hydrogen there, it wouldn't have detected it. So they didn't get a positive reading on it. But that's really irrelevant, because first of all, it's different plaintiffs. Second of all, the test isn't designed to look for that.
And also, I think we're.
Wait, Mr. Egley. And I was thinking that, Mr. Kemp, you're saying the test at issue regarding the water bottle testing or screening wasn't even designed or in place to detect hydrazine.
If there had been enough hydrazine in the bottle, it theoretically could have caught it, okay? But given the dilution ratio, that's exactly this is the whole Wicked Witch of the West concept. Hydrazine degrades over time, but when they filter.
Well, I remember the testimony on that issue.
So what they're trying to do is they're trying to say, oh, look, this proves that there was no hydrazine in the bottles. That's not what it proves, and they don't have, first of all, they don't even have a test expert to establish this point. We do, and since they didn't raise it, we didn't designate him as an expert. But that's why this issue shouldn't come in.
But the bigger picture, Your Honor, is the only purpose for this exhibit showing, oh, some of the bottles didn't test positive that they want to put in is for causation or liability. That has already been established, Judge. That is the only purpose there can be for that document, those documents, is to be able to argue either causation or liability, and those issues have left the barn.
All right, I got it. Anything else from the defense on this issue?
Well, it was interesting to hear them say that there's no foundation for the FDA report. Obviously, we're not even taking that position, but it's a portion of the report that they want to include. Or they want to include 2 pages of it. We want to include the rest to show how many items were actually tested. It does go to something more than causation. It goes to how dangerous this product was. It's going to go to the question of whether there was a conscious disregard for the health and safety of the public. It's going to explain how much of this product.
But don't we have to, I mean, I don't know if that's necessarily true, because I remember in the 2 prior trials, and what was the gentleman's name who was the managing and speaking agent on behalf of Real Water, and we had one of their employees, and it's been some time, that went to him and said, look, this stuff's coming back bad, we need to take this off the shelves and do whatever it was. I remember the
head of sales, Mr. Randolph, yes.
Yes.
And Blaine Jones, who was the 30B6, testified that that conversation didn't happen. So those conflicting testimony, and it certainly wasn't the corporate representative who was saying that that conversation ever took place.
Again, Your Honor.
And lastly, just one second, Mr. Egley. Lastly, we don't have, the defense doesn't have an expert as it relates to the water bottle screening at all. Is that correct?
Correct. We're looking at the FDA report, just like they are. This is for the jury to receive during opening.
I understand. I'm keeping the water bottle screening out.
Well, just for the record, we do know how dangerous the product it was, contrary to counsel's statement, because the motion's been granted. It was unreasonably dangerous.
Well, I mean, at the end of the day, that's what 402A is, right? A defective
That's right.
product and reasonably dangerous. That's my understanding of the 402A, right? And the consumer
Mine
expectation.
as well, Your Honor.
Yes.
Your Honor, just for a point of clarification, so are you stating that the FDA exhibit?
No, I can tell you what I'm stating. I'm
Okay.
stating we're not comparing apples to oranges. there's a difference between the concentration testing and the water bottle testing.
Right,
And they're not the same.
but when you're saying it's out, are you saying it's out in the case or out as an exhibit for the jury notebook?
Yeah, it's out of the jury notebook.
Not in a jury notebook, okay.
Thank you for clarifying that. And maybe we'll get to that later, I don't know. But jury notebook. And the thing about it is, I mean, the water bottle testing, and this case is coming back to me as far as all the little details. But it appears to me that potentially the water, in essence, and this is how I take it, whatever testing they were performing at that time when they were conducting the water bottle testing wouldn't be sensitive enough necessarily to determine what the levels are. It was like a pre-screening, right? But at the end of the day, I remember this case, they had the secret concentration room, and it's my recollection, no one was given access to that room. But at the end of the day, where the concentrate was, I guess the formula for this concentrate, at the end of the day, that's where they discovered the high levels of hydrazine. And just as important too, it's my understanding that hydrazine over time dissipates. Right?
Degrades, your.
Degrades, okay. And that's my recollection. But I want to drill down again. What else is left on this? Because when I go back and look, I want to make sure I understand.
I think we've covered it all.
I think our 4 exhibits are covered.
Our 4 exhibits are certainly covered.
Right, what, from the defense, have I missed anything?
Well, I haven't heard you issue a ruling on any of the items that we wanted included, other than your initial indication that the wet lab results would be coming in.
And that's why I keep coming back, I want to make sure what's left. I've ruled as far as the water bottle. What else is left?
I don't know that that's accurate that you said the wet lab is coming in. We certainly didn't stipulate to it.
No, I just believe that was his indication during the argument. So one of the items that we presented.
I didn't hear that, so I mean, I don't know if Your Honor remembers that.
I'm trying to drill down so I make sure I get everything.
So, Your Honor, the wet labs testing was the testing that Real Water performed. They sent it out on December 14th, 2020, got the results back on January 21st, 2021. That was previously an exhibit to the jury notebook in the Brown trial.
And it was non-targeted testing, and they have no testimony to lay required foundation for the document. As he said, it's a Real Water document.
No, it's a wet lab document. It's an independent third party that.
Requested by Real Water.
Correct.
Non-targeted testing and no witness to lay the foundation, required foundation. They do not have one. At least not one identified.
Is that true? No witness?
No, we will be calling Real Water employees to testify.
Okay, that's not somebody from wet lab. Real Water employee is not an expert in this, and they can't authenticate this.
Is that true?
No, they can absolutely authenticate that these are the results that they received when they were requested the testing.
That doesn't lay the foundation for the
Mr.
document.
Eglin, I understand. You gotta have somebody from wet labs come in.
Then we will subpoena someone from wet labs. even
They're
though
not
we're
on their
still
witness
doing-
list, Your Honor.
I believe we did put a 30B6 for them, or a
Wait, we
COR.
won't, whether you subpoenaed them or not, or whether they're designated or not, that's another issue.
All right.
I don't have that motion pending in front of me, right, regarding, but I do, I'll make it really straightforward for you. Maybe you will have somebody from wet labs, maybe you won't, but the bottom line is, I think we probably need somebody from them. Because I don't think this can be authenticated as far as the contents of the wet lab report as it relates to anyone from Real Water.
Well, it's
So-
already an admitted exhibit in your prior trial, Your Honor.
I understand. Well, if that's the case then, why am I hearing any argument? I'll just rule like I ruled in the prior trial.
That's been consistent so far today, Your
But
Honor.
I'm just saying, if I'm gonna follow that logic, right? Because I guess in the prior trial, there was no objection to it.
And just what happens is Mr. O'Do had thousands of these things. You know, he had testing reports, because remember they had to do the bacteria test every quarter. So he wanted to introduce boxes of these things. And finally, he just wore us down and we stipulated the wet labs. That's what happened last
And
time.
Your Honor, you hit the nail on the head. we weren't able to reach a stipulation on a lot of things because we worked together with Real Waters Council. Mr. Adu equally stipulated to things, and that we were able to make it work. And that hasn't been the case so far in this case. If council is interested in talking about ways that we can, you know, relieve each other of the burden of some of these foundational witnesses, then we're open to that. But so far, they have not done that, and there's no foundation.
Well, and not that it's the issue that's here, but we've stipulated to numerous exhibits that you guys are bringing in, and you've stipulated to 0 so far. But I understand that's not what this motion is, but I'm at least gonna correct that.
Your exhibits are relevant to this case.
Anyway, we don't have to go there, because we have been doing fine. At the end of the day, because I don't mind telling everyone this, we have our matrix, and if you want me to, I can go back and start just ruling this the way I ruled in the prior case, because I have everything lined up, don't we, Tori?
Yep.
But I wanted to give everyone a chance to, you know, if there's something new to argue. But anyway.
The next document is.
Wait.
I'm
I gotta
sorry,
go on
Judge.
that one. As far as wet labs is concerned, it won't be in the notebook. I'm not ruling whether or not that comes in or not. We'll find out if there's a witness been identified and so on and so on. For foundational. That's not in front of me. What's the next one, sir?
The Nevada beverage distribution documents, which they group the Strong and Garcia credit card statements in with, so it's actually 3 exhibits. But there's no indication that this is in fact a Nevada beverage document or that it details distribution. So there's no foundation for it right now.
Didn't we
On
have
its
a
face, it
similar
doesn't show any of
issue?
that.
Didn't we have a similar issue in one of the prior cases too regarding the
Big
credit card?
spreadsheets,
I got a good memory, don't I?
and that's what the first exhibit appears to be. Or first exhibit out of the 3 proposed.
The Nevada beverage is alleged distribution document.
I remember that.
So, and like I said, there's nothing indicating it's even a Nevada beverage document on it.
What do we have in that regard?
These were documents disclosed by Nevada Beverage during discovery, Your Honor.
Doesn't mean it's a Nevada beverage document kept within the course of their regular business.
Okay, I just want to take them. And that's Nevada beverage distribution documents and Strong Garcia's credit card statements?
Yeah. Like I said, it's, you know, those are actually 3 different exhibits, not one.
And I want to make sure I'm clear in this regard. Nevada beverage, they're no longer a party to this case, are they?
They're not.
Okay. And for the record, that's confidential DEF 0000017, is that the one?
Yes, Your Honor.
And what testimony do we have, for example, as the customer ID, transaction numbers, transaction date, start time, end time, and all that?
We have none.
I'm not aware of any, Your Honor.
Okay. All right. I think we need that type of information as a baseline, so I'm gonna keep it out for now.
The next one, Your Honor, is the discovery questionnaires of Carolyn Strong and Kathleen Garcia. Again, these are 2 separate exhibits. I don't want to belabor the fact, but these are fact sheets. You know, just like interrogatories, I don't believe that's appropriate for an exhibit in the trial jury notebook. I mean, okay, we're gonna put their, full deposition transcripts in there. I mean, they certainly entitled to use these fact sheets during their cross-examination of these plaintiffs to refresh their memory or to impeach them, but to have them put them in, number one, it's duplicative what's gonna happen in their testimony. And so it's just, unless it's being used to refresh their memory or impeach them like interrogatories and deposition transcripts are used for, it's not appropriate here.
And
Yeah, there's also references to things in these fact sheets that have been or will be excluded because, like, personal bankruptcies and things like that by these plaintiffs, Your Honor. Things that are totally irrelevant to this case.
I got it. And I want to make sure I understand, like, for example, the plaintiff's fact sheet that we're talking about, and I guess I understood why they were being used. They were being used by the special master. I assume Floyd Hill had everyone fill these out. Is that basically it?
Yes, Your Honor.
And for what purpose would the fact sheet be utilized for? I just want to make sure I'm clear.
Your Honor, we have multiple plaintiffs in this case that claim that they purchased real water, drank it, and got sick, and we can establish that that story is a fabrication. To the extent they're going to put on their case in opening, we would like to be able to do the same. To the extent they're going to use exhibits in front of the jury in a jury notebook during opening, we would like to do the same.
Okay, but they still didn't answer my question when it comes to the fact sheets.
It identifies where they purchased the real water, or where they claim to have purchased the real water from a store that doesn't actually sell it. Your Honor, I agree, there are aspects of it that are not necessary, some that might be subject to redaction, but I think that same thing is true for the SNHD report, which we talked about before, which has hearsay in it, references to pets getting sick.
Well, I think we'll ultimately get there, but I've made rulings regarding whether or not, in the other cases, for example, it's my recollection that when it came to hydrazine, we had testing with animals and specifically dogs. Right, and there was testimony about dogs getting sick in one of, or maybe both prior trials, because they fed their dog real water, right?
Right, but without any type of competent well, and we'll argue that later, but without competent testimony to say that these specific pets actually did sustain some type of injury from the hydrazine, that would be speculative and prejudicial.
Well,
But again, Your Honor.
I guess it depends. I mean, there's ways to look at it, but it's my recollection we had, didn't we have the gentleman they considered Mr. Hydrazine or something like that to testify at one of the trials? He's like the world's renowned expert on hydrazine.
Yeah, Dr. Nasham, Your Honor.
Not, yes.
I mean, we had it in the Southern Red Health report had pets. You had Casey Akins, the one who made this for Bad Batch. His pet got sick. You had Mr. Desitel, who had a dog die or get sick, I can't remember which. I mean, it's on the CDC slide that dogs and pets got sick. You know, the notion that there's no evidence that dogs and pets got sick, I think is mistaken.
What I'm gonna do is this,
May I just?
So finish up,
Your
Mr.
Honor. If counsel has a reasonable expectation, based on the facts and the law, that he's going to get these fact sheets into evidence, whether it's in this form or a redacted form, then I suppose he is permitted to do it and present them in his opening statement at his peril if it doesn't happen. But it doesn't mean they should be in the jury notebook. It's not necessary. The jury notebook is certainly not comprehensive of what each side anticipates or will be using in their opening statement as exhibits. I will tell you, between Mr. Kemp and I think we've probably done at least 24 mass torts. And I'm not talking about just the in-state mass torts. I'm talking about mass torts across the country. Both of us have appeared on plaintiff steering committees. And I have never, in any case, any one of these mass torts, I think Mr. Kemp will tell you as well, seen, because we've used fact sheets in every one of those cases, has seen fact sheets admitted into evidence.
Right. Just looking here.
Yeah, it's the same rule when you do a deposition, because you use the prior existing statement, you don't make it deposition.
You don't,
I know what she's gonna, gentlemen, I can anticipate what you're gonna say. You're gonna say, Judge, interrogatories don't come in, depositions don't come in.
deposition training,
Yeah.
you impeach the witness, you don't put the
I understand.
deposition into evidence.
I'm gonna, as far as the fact sheet's concerned, I'm gonna treat that like any other discovery device or mechanism, interrogatories, because you're filling this out under oath, and no question they can be questioned on it, but we won't put it in the notebook.
And the last one, Your Honor, they've agreed to withdraw, and that was the Mayo Clinic on Lisa King.
That was a little tedious, but that would have saved time, going back. What's next?
Your Honor, I think you can do plaintiff's motion limine number 12 to designate Blaine Jones as the managing speaking agent. I think that's next on the list.
So to clarify, the previous motion, it was granted in part and denied in part.
Yes.
So are we skipping, plaintiff's motion in limines 11 and 12?
Yeah, I think 11 would be
11,
next.
we can do 11 next.
Yeah.
Okay. So that's docket 227.
Your Honor, I'll be quick with this one. In the previous case, you denied this motion. I think what's good for the goose is good for the gander, but we're taking the position that you should stick to the prior rulings if there hasn't been any.
And for the record, which one are we talking about, sir?
Plaintiff's motion to eliminate number 11 to pre-instruct the jury.
And tell me why. I know what I ruled before, but why? And you're right, there's no general rule regarding pre-instruction, but go ahead, sir.
Well, Your Honor, if you're inclined to change your ruling from the prior case, our suggestion would be that we give the standard stock instructions on product liability that were included in the motion and submit on that.
Okay.
Thank you.
Sir?
Afternoon, Your Honor. I'm not sure if we just stipulated to denying this motion, Eric?
I think we did.
We're just saying that was the previous ruling.
Okay, because Judge Kishner in the Hundredson motion, or in the Hundredson trial, also denied the motion, so I think that would be consistent. I told you I'd keep this to 30 seconds or less, Your Honor. I'm going to try and do that. This is not about whether or not pre-admission generally is acceptable. However, counsel's representation that these are stock instructions is absolutely inaccurate. A lot of these instructions contain argument. They make material changes to the stock instructions that are available, and in some cases even change the legal standard. Now, there's a reason that we settle jury instructions before closing, and so we can use them in argument. And so the real water defendants here simply take a position that we're not necessarily against the theory pre-admitting certain jury instructions, but in this particular case, these particular instructions need to be worked out. They need to be settled before closing, and any applicable instructions will be provided then.
For opening, you mean?
Sorry, what did I say?
Closing.
Oh, sorry. Anyhow, point being, Your Honor, I think at this point it's premature, not to mention with other rulings in this case, I think some of these instructions have to go by the wayside anyways. So at the end of the day, I think denial of this motion is appropriate, and if you have any questions, I'd be happy to answer them, but I think my 30 seconds are up.
Thank you, sir. Mr. Peppermint, anything you want to add, sir? Because I don't mind telling you this, and I've kind of evolved over the years when it comes to pre-instruction. I have permitted it, but it has to be a scenario where where I have 100% certainty that I would use the exact same instruction, you know, after the evidence is established in foreclosing. And for example, like in a simple premise case, we can sometimes, you know, pre-instruct and so on and so on.
And Your Honor, I think that's even the case law that plaintiffs cited, kind of make that same point. The Westover case, which is from California, kind of goes in the same direction, so I think that's probably the appropriate approach.
Yeah, I mean, because one of the things you don't want to have is, you know, I mean, yeah, at the end of the day, after the evidence is heard, then you can have some really specialized instructions, but before the evidence is completed. Here's a good example. Preponderance of the evidence.
Yeah.
Right? I mean, that is an instruction I give in every case. Mr. Pepper?
No, Your Honor, I don't think I have anything else to add.
Okay. I'll say this, if you can agree, I have no problem with re-instructing. Just as important, simple issues like maybe preponderance of the evidence, things like that, you know, because it really makes sense because, for example, juries sometimes don't understand what the standard is. You know, that's a civil case, not a criminal case, and so on and so on.
And so, Your Honor, just to be clear, we are denying this motion, but we're leaving open the opportunity to pre-admit other instructions to the stipulation of the parties.
Oh, absolutely.
Perfect.
All right.
Now would be plaintiff's motion limine number 12, to designate Blaine Jones as the managing agent.
Oh, okay, that's where we wanted to go. Mr. Blaine Jones, right?
Yes, Your Honor, we've argued this before, and the court allowed him to be designated as a managing speaking agent. And the principal point, if you recall, is that at the time of his deposition, both depositions, he was still an officer of the company. And if you recall, we have attached here the Wyoming Secretary of State website mentioning him. They don't deny he was still an officer. So under the rules, we can use his deposition anytime, any purpose. That's 32A3. So he should be designated managing speaking agent.
All right, let's hear the opposition.
Well, Your Honor, the deposition, first one was taken January 23rd, 2023. Second deposition cited to was February 23rd, 2023. 2 weeks later, he files suit against his own company. Another time that is actually important here is that Real Water filed Chapter 7 2 years before that on August 19th, 2021. The purpose of a corporate designation, the purpose of allowing someone to be treated as a speaking agent for the company is because the company has decided that that is the person that can speak on the company's behalf. This is not a body of law that's intended to be weaponized by somebody who now has an adverse position against the company. And you won't find case law that says that somebody who is now suing their former company or suing, you know, or contemplating suing, because I'm anticipating you're going to hear an argument for the other side that in his deposition he said he wasn't sure at the point he made this statement, but this deposition testimony is clearly from an adversarial party. And to allow the plaintiffs to get up and talk to a jury and point to him as a speaking agent or a managing agent for the company is at best disingenuous, and at worst, it's a falsification of the posture of the case that will confuse the jury and prejudice them against Real Water. It's bizarre to me that we are looking at this. I mean, they refer to this as a PMK. First of all, as Your Honor knows, there is no such thing as a PMK in Nevada, which is why the purpose of a corporate designee designation is so important here. This is not merely somebody that worked for the company and has knowledge and can speak from that position of authority. What they're effectively relying on is a body of case law that says this is the person the company has designated to speak on its behalf. Clearly that's not the case here. Even if there was a 30B6 deposition taken, statements that he makes in his individual capacity when he knows that he is contemplating an adversarial position against Real Water cannot be considered the testimony of a managing or a speaking agent of that company in Nevada. And so, Your Honor, I think the timing of this is exceptionally important. I think the purpose of the rule and the purpose of the underlying case law is incredibly important here. And I think that there is an extreme risk, based on what we've seen in the trial transcripts of the prior trials, that this is going to be weaponized in a way that dramatically misrepresents not only his comments, but Real Water's corporate position. And if we really want to follow the spirit of NRCP 1, if we really want a trial on the merits that's fair and equitable to both sides, we cannot allow somebody to imply to the jury that this is a position that Real Water took themselves, and that everything that this gentleman said in an adversarial position is being said on behalf of the company. Now, a trial, if they want to elicit certain testimony and ask him about his personal beliefs and his personal feelings, obviously that's their right. If one of these gentlemen get called, I think Blaine is on the list, but I could be wrong. But at the end of the day, Your Honor, it is easily a step too far to apply a speaking or a managing agent designation to somebody that sued the company 2 weeks later.
What was his position at Real Water? Wasn't he a director or something like that?
President.
President.
Correct. At the time Real Water was operating, Your Honor, yes.
So he was the president,
Vice President.
vice president?
Yeah, correct. Yeah, and that's exactly right, Your Honor. We're talking about several years after the position ended. Are we now going to say that anybody, that somebody who sues their former employer can set their own damages cap? That they can come back and make statements that are clearly adverse to the best interest of the company, and that company's bound by those statements because at one point they employed the individual?
But I mean, there's a difference
He
between
didn't just employ
employment.
the individual, this is the owner and president of the company's son.
Right, oh, I remember who he is, I do.
Yeah.
I do, I remember him.
And I'm not sure that the biological connection has any import to this case, Your Honor. The fact remains, he gave this deposition testimony while he was while he was in the process of signing plaintiff's counsel up to represent him as a plaintiff.
We're not plaintiffs.
2 weeks later, he gets, is it Christian? Christian?
Yeah.
Okay, my
We don't
apologies.
represent him.
My apologies, I misspoke.
And you don't
Several times
know.
over.
You know, are we doing one horse, one rider here, or no? Are we just throwing that out the window?
Well, we all represent different plaintiffs here. so
In joint motions, counsel.
We're in a.
Yeah, we're not arguing
Wait,
each other.
wait,
We're
we-
presenting an argument to you.
Yeah, absolutely, and we've done real well today on that, so, we'll get back on track.
Point being, Your Honor, the gentleman provided testimony several years after he was a vice president of this company. He did so knowing that he believed he had damages in place. He did so a couple of weeks before he filed suit. This is not what this rule, this is not what this
But
body of
who
law is
did
intended to
he
do.
sue?
He's a plaintiff in which of the Real Water cases, Doug? Do we know?
The question is who did he sue, and it's Real Water and AffinityLifestyles.com.
Thank you.
In Milwaukee and Hannah too.
And Milwaukee, Hannah?
I mean, he didn't sue his employer, did
He sued Affinity, he sued Real Water.
he? Interesting. All right, but go ahead.
Well, Your Honor, I think that's exactly the point. We have a party that is by rule adversarial by state, and we're asking him to somehow bind the company with his biased testimony? That makes no sense. That's not what this body of law is intended to be. That's not what the rule is there for. And so, Your Honor, we would submit that, you know, his testimony obviously will likely get brought in to the extent it's, you know, beneficial for the plaintiffs to do so. They're free to, within the scope of the rules, get this testimony in. But as far as telling the jury that he's a managing agent for the company, that's beyond the pale.
I mean, so if he wasn't the managing agent on behalf of the company, who was he?
At the time he was giving that deposition, Your Honor, I think that's an entirely different question. But if we're talking about an entity that has a trustee in place.
Yeah, but I mean, at the time, wasn't he the individual where I think there was one of his employees came to him and said, look, you're having all these problems out there, and we should do a recall or something. And he said no.
That's correct. So, Your Honor, that's testimony that can come out at trial. That doesn't mean that his deposition testimony 2 years later can be treated as a corporate designee agent for the company.
But why not? Because we're talking about his conduct and actions that occurred while he was in the position as president for the company.
Not with all the testimony, Your Honor. That's not, I mean, you're gonna hear more testimony on this $10 million figure later, I'm sure, or more argument on this $10 million figure later.
When
But,
you say $10 million figure, I don't know what you mean by that.
well, let me quote from this opposition. Specifically, we cited to this in our introduction. Mr. Kemp, okay, you wouldn't go through this again if I gave you $10 million. Would
Oh, I
you,
remember.
Mr. Jones? No.
Absolutely, I remember that, but go ahead.
So now we're in a position where it's Real Water's corporate position that $10 million is somehow a damages figure that needs to be kept in mind for each of these plaintiffs? That Real Water somehow endorsed the idea that this is how much in damages should be awarded? Because that's what they presented in the past trials.
Well, I think the bodily injury portion would be personal to him. You know, that's kind of how I see that. But, I mean, the question was asked, and he said, I would do this for $10 million, I remember that.
Without objection.
And for him as an individual, Your Honor, not as the speaking agent of the company. And so what they're asking this court to do is effectively bless the opportunity to tell the jury, yeah, Real Water's vice president said, as the speaking agent of the company, these injuries are worth not less than $10 million. That is wildly inappropriate and misleading to the jury.
But he said that. How's it wildly inappropriate and misleading? That's what he said.
He said he would not go through it for $10 million, Your Honor. And I don't want to parse hairs about the context of the statement, but the question here is not if he personally believed that in his individual capacity, as Your Honor was just leading towards. The question is whether or not that is corporate designee testimony, whether that is something that he said as a managing agent of the company. That's where the distinction needs to be drawn. If he individually believes his injuries should be set at $10 million, that's a matter for another case. I believe, as Mr. Eglett said, when we were talking about motion to eliminate, I want to say number 10, but I can go back and clarify. Eglett's comment was, this is about plaintiffs that are not in the case. Well, Mr. Jones' testimony as to his personal damages are about a plaintiff that's not in this case too. And so if it's good for the goose, it's good for the gander.
I don't believe in what's good for the goose is good for the gander. I don't mind telling everyone that. I don't believe that. That's not a legal basis for an objection.
We're arguing the $10 million motion now. I'd rather argue that when we get to it. The issue here is whether or not under 32A3, his testimony can be used at any time for any purpose. And that rule specifically says an adverse party may use for any purpose the deposition of a party or anyone who, when deposed at the time of the deposition, was the party's officer, director, managing agent, or designee under Rule 30b-6. Okay, in the first deposition, he was the designee under Rule 30b-6 and the vice president. In the second deposition, he was still the vice president, and that's not disputed. He was the that's why I referenced the Wyoming Secretary of State's listing. He was the vice president. So the court's previous ruling was that or means or doesn't mean and since he was the vice president.
It's disjunctive, not conjunctive, I get it.
Right, and so that's why his testimony falls within 32A3. And counsel keeps saying, oh, he can't be the PMK because he's testifying against the interest of his the company. Well, technically, that's not true. If you remember, all the plaintiffs in here have agreed to give up their right to any of the assets of the company, every single one of them. They're going only against the insurance company. So it may be in the adverse interest of the insurance company, but it's certainly not the adverse interest of the Real Water Company. But the key point is that when he testified, it's undisputed that he was the vice president of Real Water, both times. And that's why this rule is satisfied, and that's why the motion should be granted.
Your Honor, as a point of clarification, it's my understanding that he stopped being vice president of the company in, what, April 2020?
Yeah.
So I'm struggling to understand, even if he's listed on the Secretary of State somewhere, that's not,
Even if he's listed on the, Even if he's listed on the Secretary of State, you're going to listen to that.
That would
Okay.
that would easily be the first time that a corporate listing was left unupdated. I have plenty of clients that we have to hound them about that too. But regardless, yeah,
Real water.
we have an entity in BK, Your Honor, that's filed Chapter 7 2 years before had a trustee appointed.
When you file chapter.
None of this matters.
When you file Chapter 7.
I'm going to stick with my prior
Thank
decision
you.
on this. He was the vice president at the time of his deposition. Let's move on to the next one. It was granted. Where do we go next?
I believe it's plaintiff's motion limiting number 15.
It's 229.
Your Honor, I'm just gonna use a restroom.
We need a break.
No, I don't need, unless they need a break, I'm just gonna use it.
You guys fine with that? Maria, are you okay?
Okay.
All right. Mr. Peppermint.
Your Honor, this was granted in Brown. It was granted in the Gallagher case. It was granted in the other two trials. The reason that it was previously granted is because the law is very clear on this. NRS 41.033 provides that an inspection does not warrant or ensure the absence of hazard, a deficiency, or other matter in a private building, structure, or facility. That's what we're trying to preclude here, this argument that because the Southern Nevada Health District permitted real water and they had been on the site, that should not be construed as some argument that there was no hazards or deficiencies on the premises. Very clear application of that rule. The second part of this motion is to preclude argument that they can delegate their obligations for the safety of the product. That is the clear rule from Allison v. Merck that the quote, a manufacturer cannot be relieved of ultimate responsibility for assuring that its unsafe product is dispensed with the proper warning. That's the simple relief here. This hasn't been an issue. Prior counsel for Real Water has never made this argument, but given the new counsel, we think that the same order that was entered before, these types of arguments are inappropriate, they're contrary to clear Nevada law, and they should be.
All right.
Your Honor, this is one of the two issues that I advised the court at the beginning of the hearing that I wanted to kind of get into the law a little bit on. First of all, NRS 41.033 is a statute that provides immunity to state actors. I don't know if the court's found any cases applying this particular standard to civil cases. Product liability cases, I did not see any. The statute's inapplicable as a standard here, and fundamentally I don't understand why it's been applied to date. However, looking at Merck stands for the proposition that compliance with government regulations is not a complete defense to liability. And that's the key phrase, complete defense. That's not what Real Water is arguing. That's not what Real Water wants the opportunity to present to the jury. Real Water is not going to stand up and say, well, we hit the government minimums here, here, and here, so we can't be held liable. However,
So what are they going to say?
well, that's kind of where Geyer comes in. Because Justice Breyer of the United States Supreme Court specifically said,
How old is that? Nevada follows the consumer expectation test when it comes to restating the courts. And,
right there, Your Honor.
and Breyer has been around for a long time, but we're talking about Nevada products liability now.
sure, and Your Honor, Geyer was 2000.
Okay, go ahead then.
So it's, I wouldn't say it's brand new, but it is somewhat recent. Justice Breyer in the Geyer matter said that even though compliance was not a complete defense, it was at least relevant to negate charges, and this is where the quote starts, negate charges of negligence and defective design. That's Geyer 529 U.S. at 892. Now getting into Nevada law, Your Honor, based on Geyer. The radar decision that's cited in the opposition. The radar decision dealt with this specific motion. And the federal Nevada court specifically found that even if,
So that's not really a Nevada case then?
well, it's Nevada federal, Your Honor.
No, it's not a Nevada case, right? It's not, I mean, it's not, it wasn't published by our Court of Appeals and or Nevada Supreme Court.
But federal case law on decisions like this can be persuasive, Your Honor.
And was this the Ninth Circuit or?
Let me pull up, actually, I think I've got radar up on my screen, Your Honor, but no, it looks like a district court case, 795
I don't
F
listen to
1149.
district courts. I don't mind telling you that, I don't.
Sure, then let's go to Wyeth, Your Honor.
Yes.
So Wyeth stands for the same proposition that we found in Merck as to the complete defense. That's what these cases stand for, is you cannot assert a complete defense to liability based on compliance with FDA or with government regulations. None of this stands for the proposition that this needs to be excluded at trial. Now, the Nevada Supreme Court.
Then how would it be relevant at the time of trial?
Well,
The reason why I asked this question, because this issue used to come up from time to time in construction defect, Chapter 40 cases, and they would try to use it as a defense. Oh, the inspector came out from the county. Well, that's not a defense.
It can be part of a defense, Your Honor.
No, it's not a defense. It's
Here in
not.
product liability, Robinson.
Wait a second. I'm sorry. I was talking about, first of all, construction defect, and it wasn't a defense.
Okay, my apologies, Your Honor.
But go ahead, I'm listening.
And Your Honor, I don't do construction defense work, so I would have to defer to your experience there. However, Robinson is a Nevada Supreme Court case. Radar is a Nevada Federal District Court case. Geyer is a U.S. Supreme Court case. All of these cases.
What is the Nevada, tell me what the Nevada Supreme Court says, because I always listen to them.
Let me find Robinson, Your Honor. Let's see here.
And the reason why I say that's important, number one, when it comes to other judges and unpublished decisions, I don't listen to them. I don't like saying that. Secondly, when it comes to Breyer and the U.S. Supreme Court, I respect them on issues regarding federal question, of course, and interpretation of the U.S. Constitution. But products liability law varies from state to state. For example, our Nevada Supreme Court said we're not going to follow the restatement third of torts as it relates to defective products. We're going to follow the consumer expectation test.
Yes, and
And
certain
so-
aspects of the second restatement.
Yeah, exactly. But go ahead. I want you to tell me what's going on in Nevada.
Well, Your Honor, and I framed up this argument on starting on page 5 of the opposition based upon Your Honor's approach in this case of doing, I think what you called it was a survey of Nevada law on the topic. And we'll get to that when we get into the
And
Krause decision.
I'm actually on page 5. What do you want me to follow you on?
Second paragraph. In actions alleging strict liability and breach of implied warranty claims such as here, courts recognize statutory regulatory compliance. I am a fast talker, Your Honor. I apologize.
But I'm with you. You're right at line 17, I think.
1718, Your Honor, and then the reference to the Nevada Supreme Court in Robinson versus GGC Inc. That's 107 Nevada 135, which then cites to the Faw case out of Washington, states that regulatory standards are admissible as evidence of product safety. When you take that and you look at the U.S. Supreme Court case, when you look at and I understand we cite to the third restatement of torts here, Your Honor, but this goes off of the Robinson case. There are admissible bases for using testimony and evidence of compliance with regulations. Breyer goes so far as to say, in the Geist matter, that can even go to punitive damages. Now we're talking about whether or not compliance indicates that there was a state of mind, oppressive, malicious. And then as a secondary measure, if there are punitive damages awarded, this kind of evidence goes to what the state of mind was for the purpose of determining the value of punitive damages. And this is the subject of a couple of the motions in limine at issue here today, Your Honor. But the fact remains that this is a straw man argument that the court has been provided by plaintiff's counsel. Plaintiff's counsel gets up and says, it's not a complete defense. We don't want them to say it's a complete defense. You have to kick all of this out. You have to exclude all of this evidence. Well, that's not the case. There's an area in the middle. Real water defendants are not going to come in and assert a complete liability defense for many reasons, based upon compliance with FDA or any other regulation. But that absolutely, under Nevada law, under federal law, under U.S. Supreme Court guidance, does not mean that this is inadmissible in any way.
Here's my question, and it really comes down to this, because as far as this case is concerned, it's my recollection, part of the real water production process utilized these titanium tubing that was purchased from Russia, right? Isn't
Yes.
that what happened?
Yeah.
And I mean, I don't know for sure, but it appears to me that potentially it might have been used or at some point in the rocket testing, because I'm trying to figure out where hydrazine came from, right? We know hydrazine is a rocket propellant, rocket fuel, whatever it might be. But here's my point. Where is there any compliance that this specific testing procedure is somehow compliant with the government? And what I mean by that is this: utilization of these Russian-based titanium tubes. They weren't tested, right?
Your Honor, can I ask a question of the court as far as this line of inquiry goes?
Yeah.
How does the result of that particular question for that particular fact?
It goes to the very heart. You're trying to say there's government compliance. Compliance with what?
Well, and that's it, Your Honor. They did testing. And this wouldn't be an issue for the plaintiffs if there wasn't information out there that they didn't want to see come in, because it does show that real water was trying.
Did they test their processes?
They did test their product. As far as testing the titanium tubes, no, I don't know.
Did they test their processes?
No, Your Honor.
When you say I guess I'm struggling to understand when you say processes.
What I'm saying is this, because I remember this from the prior two trials, that apparently it was pretty inexpensive to go out and have the water tested by utilizing their processes, both with their concentrate and also the finished product. And it was my recollection, it was only like a couple $100 or something like that. And so here they have a new process in place where they're using, and understand, I don't think no other bottled water manufacturer in the world has used these Russian-based titanium tubes in order to produce alkaline water for human consumption. And so, if that's the case, then there should have been some sort of government testing of this process, and that didn't happen,
But
right?
Your Honor, that's the plaintiff's argument. Is they're saying that we were supposed to do, and I'm going to misstate this so if you don't mind me reading, non-targeted GCMS testing. That comes up in a variety of the motions. That is the plaintiff's argument. The defense argument is that they were doing testing. We have as an exhibit to this opposition, the
They
Southern
weren't
Nevada
doing
Health
the right
District.
type of testing, were they?
But that's a factual conclusion, Your Honor.
Well, no, ultimately, there was hydrazine in the water.
Correct, Your Honor. But
And
that
that's
doesn't.
something, from a consumer expectation perspective, there shouldn't be hydrazine in water. It's rocket fuel.
And from a consumer the consumer expectations test, Your Honor, I believe that goes to whether or not the product was defective, which I believe has been ruled on. Is that correct?
Well, I mean, I can probably take judicial notice that hydrazine should not be in water.
Well, I believe that was the subject of the first motion for summary judgment today, Your Honor.
Right.
But that still leaves the issue of damages, whether or not punitive damages should be awarded. If so, how much? And so to the extent that this information, like Justice Breyer noted, discusses their intent, their state of mind, whether or not it was willful or oppressive, to what extent, if the jury has to weigh how much to give in punitive damages, this is where it becomes a step too far. Merck does not stand for the proposition that this is inadmissible or irrelevant information. Nevada law has said this is admissible, this is relevant, just not as a complete defense. And I think that's where the court needs to split the hair.
Well, here's my question for you, and this would be like in all pharmaceutical cases. When they have a drug come online, they test specifically for that new drug, for that new process, right? And so here we have a new manufacturing process, and there's no evidence that Real Water conducted any testing for this new process utilizing titanium tubing bought from an unknown source, that's my recollection, from Russia.
And Your Honor, there's a difference between ignorance to what kind of testing should have been done and malice.
Well, there's conscious disregard too.
And if the court's making a finding
I'm
that
not
there was
making a
conscious
finding on
disregard.
that, I'm just dealing with this motion in limine. I'm just focusing on what the underlying facts are.
But Your Honor, that illustrates the point. You are sitting here discussing whether or not this evidence goes to the question of conscious disregard. That's left for the jury. If we have to have a conversation.
That's not what I did. We just went down that road.
Okay.
Ultimately, what we're talking about is whether evidence of compliance with governing law, regulations, or industry standards is admissible. And my point is this, where do we have that evidence? Especially when it comes to a new product, a new manufacturing process, right? Because I don't think there's been any other water manufacturers in the world that utilize titanium tubing from Russia as part of their manufacturing process.
Well, Your Honor, as far as the law goes, as to admissibility, Robinson in the Nevada Supreme Court, Radar in the federal court, Geyer, the U.S. Supreme Court, have all recognized that this is information that can be relevant in products liability cases and should be admissible. They've determined, along with Merck.
But there's no compliance. Where's the compliance?
That's a finding of fact, Your
No,
Honor.
that's evidence of compliance. Testing this specific product, where's the compliance?
Exhibit B to the opposition, Your Honor, shows Southern Nevada Health District inspections. Now, whether or not it's compliance with the standard of care that Your Honor believes is necessary, that's fine. But this is a broader question than that. This is not the moment where we determine whether or not the testing that was done, whether or not the inspections that were completed, whether that be government or internal, were proper. The question is, do we let the jury hear what happened?
Well, the bottom line is this, there was no testing or inspections regarding the processes that were utilized in this case.
Your Honor, at this point, I think we're weighing the evidence.
I'm not weighing evidence, this is a fact, there was no testing done. Now tell me if I'm wrong or not. Wasn't there testimony in the last two trials that the type of testing involving some broad spectrum analysis, I can't remember what the term of art, would have easily detected hydrazine?
Yeah. Non-targeted
GCMS.
Thank you, sir.
Right.
Yes.
I just don't remember the term of art, Mr. Kemp, but I remember.
Gas chromatograph, mass spectrometry,
It was like $200, right? Something like that?
100 to 200.
Exactly.
I agree with you, Your Honor. That probably should have been done, but that's beside the point. The issue is there were
No,
steps taken.
here's your real point, and it's very important. There was no government compliance because there was no testing of the processes in place.
So if I understand Your Honor's position,
I don't have a position.
okay.
That's my observation. I mean, because at the end of the day, this new process that was utilized in this case as it relates to producing a product for human consumption, there was no testing of the byproduct as a result of using this titanium rod from Russia.
There was no non-targeted GMCS testing.
Right.
Okay. Just want to make sure we're specific on
GCMS.
GCM.
Yes. In the limited amount of time I've had to digest the 4 trials in all this case, I've not memorized all the terms of art yet either, Your Honor. So.
Yeah, no, and you're fine. But that's my point, right? I mean, it was a new process. In fact, I remember the gentleman that promoted this process, he was drinking the water and got sick too.
Mr. Marlowe.
Mr. Marlowe, right?
Okay. So this motion is specifically asking whether or not any evidence of any government compliance, testing, or anything along those lines can be admitted or excluded.
Well, my point is this, they didn't test for this.
Under that set of testing, no, Your Honor, they didn't. And so there wouldn't be evidence brought in the first place for that. But that doesn't mean that we should be excluding all the efforts they did take in their investigative process. That doesn't mean that we shouldn't be excluding whether or not they met minimum requirements required by the FDA or the Southern Nevada Health District. That's the determining factor here, Your Honor. We're not worried about whether or not the non-targeted testing was done.
Here's my question for you.
Not a dispute.
If you have a new water production process and you're bringing new water to the market, it seems to me that regardless of what the process might be, and what I mean by that is you're not doing reverse osmosis or any of those typical, you're doing something different using titanium rods as part of your manufacturing process. You don't think that with this new process, maybe we should do some broadband, whatever the letters are Mr. Kemp is referring to, testing for less than $200 to determine exactly what's in the water? Because at the end of the day, we're talking about human consumption, which is a really important item.
And Your Honor, I'm not personally taking the position it's not. But I'm looking at the last order where it says, whether an entity such as Real Water has passed an inspection or not with a local agency is not relevant. That was the previous order of this court, and that's what I'm trying to say. Under the variety of case law that I've provided today, I don't believe that that's true, and I don't believe that is supported by Nevada law. I don't believe that's supported by federal law. I don't believe that that's consistent with what Justice Breyer said. And further, if we're relying on NRS 41033, we're relying on a statute that has absolutely nothing to do with product liability or civil suits. It stands purely to immunize state actors. That's the subsection of the Nevada statutes it's in. So if we're talking about whether or not the non-targeted testing should have been done, you know what? Probably. But if we're talking about this particular ruling for this particular motion, I think the body of law before this court makes it clear that while these inspections that were previously excluded in other trials cannot act as a complete defense to liability, that much is undisputed. That's Merck, that's Robinson, that's Radar. Those same cases acknowledge that this is relevant information. It's just not a complete defense. And so I would ask Your Honor to reconsider the prior rulings here as far as excluding this information and uphold the aspect of it that we cannot, real water defendants cannot argue that it's complete defense. That's fine. But let's not throw the baby out with the bathwater. Let's limit the ruling on this motion to what the law actually says. And that's all we're asking.
Thank you, sir.
Your Honor, I just want to make 3 quick points. First is this whole argument about whether it's a partial defense or a complete defense is totally irrelevant because Your Honor granted summary judgment as to liability. So all this is a moot point because there is no defense to liability. There's summary judgment establishing liability. Second point is, and Your Honor, your exact question is exactly what I had written down before you said it. Compliance with what? They don't identify any applicable standards or rules or regulations that they complied with. In fact, we know they didn't comply with it. Even with when the Southern Nevada Health District was investigating, they hid the concentrate making operation. They did not include it on the flow chart that was given to the Southern Nevada Health District. It was in the locked room that no one was allowed to go into, that only Blaine Jones went to make the concentrate. So this suggestion that the Southern Nevada Health District blessed the concentrate making process is totally wrong. It's irrelevant, and even if there was some marginal relevance, which there isn't, it would be far more prejudicial than probative because it's just confusing the issues. Finally, the third point I want to make is where Mr. Esposito ended on, which how he referenced your order, your prior order, which said evidence of permits or permitting inspections is irrelevant in this case, and he said, oh no, it is relevant. You should allow us to make these types of arguments that the fact that we received a permit from the Southern Nevada Health District is evidence of the product safety or things in that regard. Shane, can you pull up the reply, page 3 on this motion, please? 15. Contrary to Mr. Esposito's argument to the court just now, this is the paragraph from their motion to eliminate number 3, which is not being argued because we agreed on it. Quote, the permit status of any of the 3 real water facilities over the years does not have any relevance in this case. The permit status of the real water facilities is irrelevant to the creation of hydrazine and how hydrazine got in the water. The permit status does not make any material issue in this case more or less probable. The status of the permitting is irrelevant and unduly prejudicial. We agree on this. That's exactly the point of our motion. So for those reasons, we'd ask that it be granted.
And for the record, this is plaintiff's motion eliminating number 15, is that correct?
Yes.
Okay. And I've heard this motion before, and I'm going to grant the motion. Because ultimately, this compliance is not a defense. It's not. And this is a products liability case. it's my recollection, no one was using titanium tubes that were purchased for the utilization of manufacturing water for human consumption. Anyway, it's a break time.
Yes, yes.
Take 15.
Yes, sure. Thank you.
All right. Thank you. Okay, we can go back on the record, and where did we leave off?
I believe the next one is, motion limine number 16.
Number 15?
1616.
Okay, thank you.
Your Honor, I think this motion was conflated with the prior motion, number 15. They're similar. This one is motion in limine to preclude defendants from arguing or inferring that violations of law or regulations are relevant to compensatory or punitive liability. I'll just try to be brief because I do think a lot of this ground was plowed in the last motion. Number one, it's not relevant. This type of argument or evidence isn't relevant because summary judgment was entered as to liability. And even if it wasn't, we're talking about the consumer expectations test, whether a product is more dangerous than would be expected by the consumer with ordinary knowledge, whether a product manufacturer complies with every applicable regulation there is or violates every applicable regulation there is. That's not relevant to the consumer expectation test on compensatory liability.
At the end of the day, the question is the restatement of torts 402A, defective product unreasonably dangerous.
Correct, Your Honor.
That's the thrust, that's the focus.
Yes, and not only is that the thrust, but it's also been resolved. So I think that portion of the motion, consistent with the last one, 15, is done. By the way, Your Honor granted this motion in the Brown trial as well. As to punitive damages, it's also not relevant. I'll just raise the same question we did last time. Compliance with what? What are they arguing that they complied with that is relevant? Specifically here, our punitive damages claims based on 4 prongs. It's the failure to have any quality assurance in place, the failure to investigate product complaints that they received, and the conscious disregard of those complaints, the failure to do non-targeted GCMS testing, which isn't a mandate by law. It's something that they should have done in response to either any of the complaints or before introducing their product to the market. And then the lack of recall, where you have the vice president of sales going into the office of the vice president twice saying, hey, I know multiple people who got liver failure from drinking this water. Blaine, you got liver failure from drinking this water. The water's the only connection between any of you. We're getting, a deluge of complaints, people calling in, getting sick, water tastes funny. You got to do a recall. The answer is no. There's no applicable laws that say they complied with anything related to these claims. Any argument about the compliance with non-existent or inapplicable laws is irrelevant and unduly prejudicial because it just risks confusion of the issues and misleading the jury. And consistent with your prior order in Brown and then the most recent ruling on 15, we'd ask this motion be granted as well.
Okay, thank you, sir.
Your Honor, do you want me to go through everything we just went through on the last motion?
I want you to do whatever makes you comfortable, sir.
This will be very quick, Your Honor. As far as the liability side goes, I think we can dispense with any argument on that point given the MSJ, so I'd like to just focus on punitives. The other side relies on 3 cases in their motion, Bailey, Blacker, and Wyeth, to support the motion. One is a federal court case and one is a state court case out of Pennsylvania, and if I understand the court's inclination correctly, those out of jurisdiction opinions should not be influencing the decision or the court's analysis in this case as opposed to Nevada law. So I'll go directly to Wyeth. Wyeth, as we discussed, stands for the fact that evidence of compliance with federal regulations is admissible. It just states the evidence does not automatically preclude punitive damages. Now, this is important because the court went out of its way to cite to the case of Grice v. Dayton-Hudson Court, and that's at 468 of the opinion, Your Honor, on page 10. And the Nevada Supreme Court included the parenthetical, and I'm going to read it to you. Determining that compliance with the Flammable Fabrics Act of 1953, while relevant to the issue of punitive damages, does not preclude a punitive damages award as a matter of law. And that's what we've been saying this whole time, Your Honor. There's a distinction between whether or not it's relevant to the issue of punitive damages and whether or not it precludes such an award from being awarded in the first place. So, Your Honor, to the extent that they're seeking to exclude this testimony under any circumstances, that's not what the Nevada Supreme Court was trying to communicate in Wyeth. There would be no reason to utilize that specific parenthetical, that specific citation, if not to distinguish between the rule that you cannot preclude liability with this information, this evidence, and the fact that it is otherwise clearly relevant to the issue of punitive damages. So that's the Nevada Supreme Court's position. That's in black and white. That's for the court's review today. Now to the argument that, well, it doesn't matter anyways because they didn't do this or they didn't do that. These are specific factual allegations that need to go to a jury, Your Honor. The fact remains that the mindset of the company, whether or not they knew they were in violation of any regulations, any laws, what steps they took, what steps they didn't, these are all factors that a jury needs to weigh. You heard opposing counsel say that the non-targeted testing was not a federal, it was not a regulatory requirement, and that's true. But at the end of the day, and you're going to hear this repeatedly over the course of many of these motions, real water's state of mind, real water's understanding, real water's intent is all very important here. And if Wyeth says that compliance with regulations, attempts to comply with regulations, knowing or unknowingly violating laws, this information is relevant to punitive damages, it just can't preclude the same. We would ask the court to follow that particular guidance from the Nevada Supreme Court. If the court has any questions, we'd be happy to answer.
I do. As far as Wyeth is concerned, what FDA regulations were they referring to?
Wyeth was referring to compliant with FDA requirements for labeling and testing its drugs. The argument from Wyeth was that because it complied with those specific FDA regulations, and I'm quoting here, the imposition of punitive damages is negated. This was a black and white argument in Wyeth. Wyeth was saying we can't have a punitive damages award against us because we were compliant with the bare minimum. Now, the Nevada Supreme Court came back and cited a host of case laws that effectively, when it's summarized, says, yes, the FDA compliance here sets a minimum standard, but in certain circumstances, and Merck, the other case we talked about today, goes to the same point. In certain circumstances, for example, in a failure to warn context, if you have knowledge that your product could be harmful, then you may have to go above FDA standards. And so when the Nevada Supreme Court's going through all of this case law, they end with the citation that distinguishes between recognizing, and I'm quoting again, that while relevant to the issue of punitive damages, and they're talking about compliance with the Flammable Fabrics Act for this case in 1980, it does not preclude a punitive damages award. The entire point of Wyeth is that this information, while relevant, does not act as a bar to a punitive damages claim. So Plaintiffs' Counsel is asking this court to effectively disagree with the Wyeth decision in the guise of relying upon it.
Well, here's my question, because Wyeth involves FDA regulations for labeling, which is pretty specific, and also drug testing. And that's why I asked the prior question before, because those two issues would be specifically germane to whether or not there was appropriate drug testing or whether the labeling was appropriate. It ultimately resolves in, or can ultimately result in whether you have a defective product unreasonably dangerous under the Restatement of Torts 402A.
Correct.
That's one thing. But And that's why I asked the question again, what specifically are we talking about from a compliance perspective? Because what happened in Wyatt and what happened in other cases involving drugs appears to me to be a much different factual scenario than what happened at Real Water.
Well, and Your Honor, that kind of goes to my point. If this testimony comes up at trial, the court is well within its purview to limit testimony that it believes goes outside the bounds of relevant based on any particular compliance or testing that's proffered. But that doesn't mean that at this stage, we should go against the Nevada Supreme Court and issue a broad ban on this topic in total.
Well, actually, I look at it slightly different, because you look at the FDA regulation for labeling or drug testing. And in Wyatt, there might be issues regarding compliance with them. And that didn't automatically insulate the defendant from punitive damage. I get that, but we're talking about what testing are we referring to that would have determined or disclosed whether there was hydrazine in the water being sold by Real?
And that is a targeted question about testing that was not required as a regulatory measure, Your Honor. And that's something where, again, if at trial you feel like it goes too far for that specific question, then that can be an objection that's ruled on. But for right now, and if we want to go beyond Wyeth, Your Honor, in the specific scope, if the court is looking at Wyeth and saying, well, both sides use this case, but I don't really think it's relevant here, let's go to Robinson. Robinson specifically states, and this is at 142 or 107 Nevada 142, co-citation 808 P2D 526. The Nevada Supreme Court instructs that the jury should be permitted to hear, and I'm quoting here, hear all the evidence relating to the course of conduct of both the industry and the particular manufacturer. Now, in Robinson, the issue was more germane to the issue of liability than it was to punitive damages. But the Nevada Supreme Court has routinely, through these cases, identified that there is relevance attached to either the implications of federal regulations, attempts to comply with federal regulations, testing done pursuant to federal regulations. I mean, the specific facts can differ based on the case, of course, Your Honor. But the general premise is the same. And I don't know that the Nevada Supreme Court in Wyeth was specifically concerned about the fact that it was a failure to warn labeling case when it discussed the propriety of allowing a company to avoid all punitive damages by meeting the minimum federal regulatory requirements. The type of claim did not come into that part of the analysis. The specific FDA regulation was not analyzed in Wyeth as part of that analysis. It was effectively more of a policy issue, where the court said, yes, federal compliance, regardless of whether or not, I hate that word, regardless of whether or not the statute is based on labeling or production or safety, the Nevada Supreme Court said that this information is relevant to the issue of punitive damages, but it's a step too far to allow companies to insulate themselves from punitives by meeting a minimum standard if they know their product probably needs more. And so we'll inevitably come up to the jury, right? Did Real Water need more than the minimum standards imposed by government regulation? And that's fine. That's a question that needs to be asked. But again, under Robinson, under Wyeth, the factual basis for the regulation at issue was not part of the analysis of the Nevada Supreme Court. What was at issue was broader than that. And that is, the courts understood that regardless of the type of compliance, regardless of the type of measure that was required, regardless of what the standard was, a company's attempt to meet those requirements or disregard for those requirements, as the case may be, absolutely informs the question of punitive damages. And so all we're asking Your Honor to do is allow Real Water to introduce, as appropriate, information that can show the jury that at the very least there was an effort here. It may not have been the non-targeted testing. It may not be what this court or prior juries or opposing counsel believe was the appropriate testing or appropriate compliance or even the appropriate steps with internal reporting. But none of that is at issue here. The issue is simple. can the jury hear argument that the Nevada Supreme Court has gone out of its way to cite to as definitely being relevant to the issue of punitive damages. And so we would ask that the court deny the motion in that regard in accordance with Wyeth and Robinson. And as Robinson states, allow the jury to hear all the evidence relating to the course of conduct of both the industry and the particular manufacturer.
What government testing and or regulation would have made a determination that it was hydrazine in the water being sold by Real Water?
Your Honor, I don't know of any authority that would require that evidence to be presented in that manner. The question of whether or not specifically hydrazine could be detected is beside the point when the purpose of this is to show whether or not certain requirements would be met.
Because what you're saying, this is what's unique about this case. Rocket fuel should never be in drinking water, period. Should not be there. And so my question is this: what governmental regulations or local testing would have disclosed that, or they would have been required to undergo? Because it's my understanding that simply because they complied with it, that's not it. That wouldn't have disclosed hydrazine in the water, because at the end of the day, the root cause was the production procedures utilized by Real Water to make the product.
Sure.
What they did, you know, they did something different than any other company selling drinkable water to the public, because nobody else had hydrazine in their water. And this is I remember some of the testimony, because this is what's unique about this. There's no expectation that hydrazine should be in water. And that's my recollection of the testimony. It's one of those things that this should not happen. And so, for example, if you follow your line of argument, okay, they complied, but the government would have never disclosed or determined that hydrazine was in the water. And part of it was the process that they were using. And that was the net root cause of the problem here, was the fact that there was hydrazine in the water. And it appears to me that the source potentially might have been the titanium rocket tubes that were used in this case.
Your Honor, are you familiar with the idiom Hamlin's razor?
No, go ahead and tell me. I'll listen. Maybe I am. But
Hamlin's razor states, never mistake for malice what can be adequately explained by one's ignorance. And the realistic side of this is just that. What you're talking about isn't necessarily willful, malicious, oppressive conduct. Real Water is entitled, or should be entitled, excuse me, to get up and say, when they were receiving some of these complaints, they didn't know about hydrazine. This was not something they knew to test for. This was not something they knew to do. But they were trying their best, as the argument may go, to comply with what they needed to comply with. They're getting certain complaints of, I think it was styrofoam or dirt in the water, or certain things like that.
well, you had the red oily substance
Sure.
and a lot of different things. I remember that.
And I don't think, I mean, based on your Honor's own comments about, you know, getting this titanium tube from Russia, I don't think anybody's here saying these were, you know, these were individuals with a medical background that would specifically know that these end complaints should have been traced to hydrazine. I mean, we've got doctors' reports that show that they didn't
Here's
know.
my question though, and this ultimately goes to a defective product and reasonably dangerous. At the end of the day, they have a new manufacturing process, right, that no one else uses. And if they're going to use a new process, shouldn't they have testing for the new process?
And Your Honor, if a jury's weighing whether or not to award punitive damages, that's a question that can be argued by plaintiff's counsel. But that's also something that can be, we should be able to argue against. We're not worried about liability here. We're not worried about the consumer expectation test. We're not worried about whether or not the product was defective. Your Honor has made that ruling. But when it comes to punitive damages, when it comes to the question of whether or not this rises to the level where punitive should be awarded, and if it is, how much? In accordance with Wyeth, this evidence is relevant. It just can't act as a complete bar. And so, Your Honor, if we can move past the liability issue, and we can focus solely on what a jury is entitled to hear to weigh the import of the action or inaction of Real Water and its employees. This is absolutely part of that conversation. And for that reason, I would say specifically with the liability issue off the table, this motion should not be granted because it is inconsistent with Nevada law.
Thank you, sir. Mr. Peppermint.
Your Honor, if I can steal an analogy from Mr. Kemp, just because you have a driver's license, that isn't a defense to a drunk driving charge. There's no relationship between being granted the license and the conduct that is at issue. And that's the same thing here. There's no relationship. They haven't identified one law or regulation that they supposedly complied with that is relevant to any fact or issue that is of consequence in this case. If they had...
And the reason for that is real simple. Under any set of circumstances, there shouldn't be hydrazine in drinking water.
Exactly, Your
Because I
Honor.
remember the testimony, it was so unexpected that, but here's the thing, that 200, it's my recollection, a $200 test would have discovered that.
Yes, and that's the issue. There's no regulation that they complied with that says if you're getting reports of oily substances and fishy smells and people getting sick off your water, that you don't have to do a GCMS test. There's nothing that insulates them from that type of conduct. There's no law or regulation that they complied with that insulates them from refusing to do a recall when you know people are getting sick, when you yourself, as the vice president of the company, got sick. Those are the specific allegations and facts at issue in this case, and they have yet to identify what specifically they are talking about from a compliance perspective. And, Your Honor, I'm left with the impression that they're being purposefully vague on this because they want to manufacture some arguments that their product was certified by the FDA or the Southern Nevada Health District or in compliance with certain rules or regulations, when that is just not the factual scenario. There's no evidence to suggest that. In fact, Shane, if you could just briefly pull up page 6 of our reply. I mean, the FDA observations of the facility in the establishment inspection report put to bed any notion that they were even complying with anything. You didn't have a written food safety plan. Your hazard analysis did not identify a known or reasonably foreseeable hazard that required preventative control, and on and on and on. Yes, they did some testing, bacterial testing periodically, but they did not even do that enough. So any arguments that they were complying with these inapplicable regulations or irrelevant regulations is not relevant in this case based on the facts and issues in this case, and it's unfairly prejudicial and again consistent with your order in Brown and the last motion, which is similar. We ask that this one be granted as well.
And we're on motion and limiting number 16, is that correct?
That was 16.
Correct, Your Honor.
Okay. And for the record, we're talking about plaintiff's motion and limiting number 16 to preclude defendants from arguing or inferring that violation of law or regulations are relevant to compensatory or punitive liability. And I mean, I've heard this motion before. I see no need at this point to deviate from my prior decisions in this case on this specific issue. So I'm going to grant the motion. So where do we go next?
Motion 17, Your Honor.
And Your Honor, I believe that this could be fairly quick based on the prior decisions that I've had in this case. by plaintiff's motion, we sought to exclude references by Dr. Alsina or arguments or references included in the medical records that kombucha could have caused plaintiff's acute liver injury. As has been discussed earlier today, Dr. Alsina could not state to a reasonable degree of medical probability that that was the case. He opined that more likely than not real water was the cause, but despite this, based on their opposition, the real water defendants still seek to include these references and entirely speculative, and concedingly, as they even admit, speculative opinions in the medical records in order to show the jury, quote, a holistic picture of how issues of real water were being investigated and evaluated by treating physicians, even if those processes did not result in opinions on alternate theories of causation, unquote. Now, what they're trying to do is they're trying to say, yeah, they're not alternative theories of causation. There's no support for them. They're speculative. We didn't even disclose the treating physicians, but the references in the medical record that are completely unsupported, are overly prejudicial, and not probative in any capacity should still remain. And their argument is entirely misplaced, as physicians or the plaintiffs in the action had no notice or knowledge that real water was the cause of their injuries when they were being treated. They were being treated in 2020 when knowledge wasn't even provided. The FDA and the CDC did not come out until March of 2021. So that was months after the plaintiff's treatments. The treating physicians weren't aware that real water should have been even included in the diagnostic considerations. So any references to all speculative theories should be entirely redacted and removed from the medical records because they're overly prejudicial and not relevant and not purported. So while even the defendants admit that they are not alternative theories of causation and there's no support for them, they're speculative, they're relevant, and hold no probative values, and these baseless theories must be redacted from the medical records.
Thank you, ma'am. And we'll hear the opposition.
Very briefly, Your Honor. Start by going back to what Counselor Watson said at the beginning of today, Your Honor. There is no specific alternative theory of causation being presented. The entire premise of the motion, the speculative testimony that they rely upon, doesn't exist. The fact is, though, that these are medical records that are admissible. And we've had a lot of conversation recently about, well, they didn't do non-targeted testing. They should have known that, how else would you test for hydrazine in the water? The entire point here, and I think that these medical records speak to this, is that at that time, an opposing counsel just noted this, no one knew that that was supposedly an issue. And so we have serious concerns about the fact that plaintiffs are trying to exclude any and all evidence that this was a developing understanding of the problem. It's that simple. This is admissible medical records. These were observations made by medical professionals during the course of diagnosis. It doesn't need to be specialized. Your Honor talked about the fact that diagnosing a condition is a little more fundamental than...
Well, when I talked about that, I want to make sure the record's clear. We're talking about the distinction, for example, between a neurosurgeon and a general practitioner.
Correct.
I mean, at the end of the day, a GP can diagnose. That doesn't mean he can perform the surgery.
Correct, Your Honor, and that's exactly my point. We're not talking about causation here. We're talking about a lay knowledge or a GP knowledge, if we're going to the doctors, about what this could be.
But could doesn't get it done. I mean, really, could doesn't get it done. This is a medical causation. If there's, for example, the kratom issue,
Sure.
How is it relevant unless a medical professional specifically tees it up as an independent alternative causation?
It's not a causation argument, Your Honor. This is not a causation argument.
If it's not a causation argument, then it's out.
It's a knowledge issue.
No.
We're not going to permit the jury to hear that a medical diagnostic result was that it could be, at the time, hydrazine was not identified potential source of the harm.
Coulda is not the standard. Right, more likely true than not. So reasonably of medical probability. That goes back to what Prabhu versus Levine and all the whole litany of cases back in the 80s.
If we're trying to establish causation, yes. But if what we're trying to show the jury is what the knowledge base was of the time of these professionals.
How's that relevant?
It's relevant because for the issue of punitive damages, Your Honor. It's relevant when it ties into the issue of what Real Water was doing at the time, what the plaintiffs or the parties knew at the time. This is establishing a holistic view of what the world looked like when this was going on. Nobody is sitting here saying, oh, well, the kombucha was an what's the phrase? Alternative theory of causation. That's the misleading part. We're not saying this is not an issue of causation. This speaks to a damages issue entirely separate from causation. And that's the problem, Your Honor. Now, this is really a minor point to begin with. I mean, at the end of the day, there's obviously more material issues for the jury to consider, but that doesn't mean that this specific admissible medical record should be redacted because some of the information isn't entirely favorable to the plaintiff. And with that, Your Honor, if you have any questions, I'd be happy to answer them.
I don't, sir. Thank you.
And very, very, very briefly, Your Honor, because I think we are at the same point, is the holistic view is Real Water knew that it had several customer complaints. Real Water knew that its vice president of sales connected the outbreak and connected illnesses, but Real Water didn't tell anyone. Real Water concealed that information. So Real Water's concealing of information and failure to investigate any of this does not have any bearing or relevance on what the treating physicians knew. The treating physicians didn't know that Real Water contained, or the water bottled product that their plaintiffs were consuming or their patients were consuming had rocket fuel in it. It wasn't in their diagnosis differential. It wasn't considered. So anything related to this, it's not relevant to punitive damages. It's a causation argument, which this court has already determined. It's not relevant, it's not probative, and it shouldn't be in the medical records. Thank you.
And it's important to point out, just because something is set forth in medical records doesn't stand for the proposition it's automatically admissible at the time of trial. It doesn't. And looking at this, let me go back to the call. We're on number 17, is that correct?
Yes, Your Honor.
And we're dealing specifically with plaintiff's motion limiting number 17 to exclude the alternative causation theory regarding the purported terrible teas, kratom, and kombucha for lack of supporting evidence. And here's my point. Unless we have expert testimony to a reasonable degree of medical probability as it relates to independent alternative causation and or under plausibility theory, that didn't come in. Granting the motion.
Thank you.
We're going to jump and we're going to do plaintiff's motion limiting at 34, 35, and 36. So we're going to jump forward a little bit if you need to change binders.
Are you doing them all at the same time or separately?
We're going to do them separately, but I'm just going to do these next three.
I'm sorry, what numbers are they?
34, 35, and 36.
It's 266.
Okay, I'm at 34.
All right. Your plaintiff, Lisa King, seeks to exclude any evidence or argument at trial related to her bankruptcy and prior lawsuits. Defendants agree that they will not introduce any testimony or evidence of Lisa King's bankruptcy or the lawsuit related to a business venture unless for impeachment purposes, which I'm not really sure what that means, but the contested prior lawsuits relate to, first, a motor vehicle accident in 2008 injuring her spine, another motor vehicle accident injuring her spine in 2016, and a neck injury due to falling overhead luggage on a Southwest flight in 2013. Regarding King's lawsuit related to motor vehicle accidents and the Southwest luggage accidents, defendants contend that they should be permitted to introduce them at trial. Defendants point to King's deposition and discovery responses where she provides lay testimony as to her symptomology, not medical causation testimony. Such evidence does not overcome defendants' admissibility deficits for an independent causation theory. Any evidence of a prior injury, medical condition, or pre-existing condition is only admissible under Giglio if the defendant presents competent evidence showing a causal connection between the prior injury, medical condition, or pre-existing condition.
And I don't mind saying this, Mr. Egler, for the record, Giglio dealt with really two discrete issues. And in that case, she was making a claim for a lumbar injury. However, it was a specific lumbar injury to the disc,
Right.
at a disc level, it was a herniation. And she had a pre-existing history of a facet injury.
Facet injury.
And
Two
I
different
excluded,
things.
I excluded the facet injury.
I know, Your Honor, you remember I was the trial lawyer
I
on
know,
the case.
but it's important because that's an important case.
Yes.
It really is, because it stands for the proposition, you can even have this two separate discrete injuries to the lumbar spine, and notwithstanding that fact, one might not come in because it's not the same level of injury.
Right. And so further, it is well settled, as a court as well, under Williams, that causation of injury and damages must be established by medical expert testimony to a reasonable degree of medical probability. Defendants' medical experts do not offer any opinions regarding any of King's prior accidents or injuries, nor do they causally relate them to any of her conditions at issue here as required by Nevada law. Simply because these unrelated medical conditions were disclosed during discovery does not mean they are admissible at trial, and the prior lawsuits and related injuries are more prejudicial than probative and show no probative value of King's prior lawsuits that outweighs the prejudice and confusion their admission will cause. The motion should be granted.
And for the record, we're on number
This is 34, Your Honor.
34. Okay.
Your Honor, Ms. King provided the discovery questionnaire states as relates to what she claims is related to her injury, and leads up until this very point. It's my understanding that plaintiffs could come in and testify as to conditions that they have. She's going to come up and testify she's had back problems, etc. Well, she states in her questionnaire, which we attach to our opposition of Exhibit A, that she has an inability to walk, and her back is freezing up with spasm. That's what she says. That's her position. That's going to be her testimony at trial. Now, obviously, her...
Was she deposed?
I don't know if Ms. King was deposed or not.
She was.
Yes, before my time.
What did she testify to in her deposition?
I don't recall what she testified to, Your Honor. I know what she's I do know what she testified to, because I got it right here. Excuse me, Your Honor. If you go to the next page of our opposition,
And what page are we on?
page 4.
Okay. Let me catch up. All right.
And discovery responses, she specifically says, I have weakness, loss of balance, difficulty walking. You see that at the top. And then in her deposition, she was asked about it, specifically questions, moving to line 14. But are you blaming any of your neck and back issues to consuming real water and the effect that it's had on you? She says, I'm not a doctor. I certainly have pre-existing back and neck issues. She admits it, Your Honor. There was one situation, though, in 2019 to approximately 2022 when my back locked up. And I don't know what else to say about it, but I couldn't move. And it seemed like it was the length of my back. And when I said I couldn't move, if I was there to lay down, I couldn't turn over. And we tried different treatments to figure out how and why. And this is something unique that I never had before. That's what she's testifying to. Back locks up. She's going to come in and talk about how it's affected her neck and back. The question is specifically asked, and establishing a background about her long history of neck and back pains is certainly relevant and subject to cross-examination. Thank you, sir.
Your Honor, the inability to walk, as well as the back freezing up, and weakness, and all of these other clues, slurred speech, and a whole host of other things, are all clear symptoms of her MG. Her treating physicians have related that to her MG and not anything else, and they have no medical evidence or testimony from a medical doctor, expert testimony, linking these to her prior neck or low back injuries. It is not allowed under Giglio or Williams what they're trying to do here, Your Honor, and the motion should be that.
All right. And I haven't heard all the science here, but I'm looking at a response, and she says, quote, and this would be, I guess, this is right after the answer. She says, I'm not a doctor. I certainly have pre-existing neck and back issues. Then she goes to a couple of specific events. Now, one thing for sure, and this is what I don't know, we don't have any testimony that's set forth here from a medical perspective at all supporting a potential defense theory in this regard, that there's somehow an independent alternative cause or something like that that we don't know about. And here's my point. Ultimately, she just told the truth. And whether or not this can be linked up to her back or not, she said, look, I mean, the back condition to her ingestion of hydrazine and whatever problem she might have. She says, I'm not a doctor, and she just discusses her pre-existing back issue, and she set forth one situation. Ultimately, the doc is gonna tie it up or not. That's kind of how I see it, you know, and they have no evidence to the contrary. As it pertains to the call of the question here, let me go back to it again. Plaintiff Lisa King's motion in limine to preclude irrelevant and unduly prejudicial information. I'm gonna grant it. And Giglio and Williams are clearly on point. Potentially it comes in, potentially it doesn't. We'll hear what the medical doctors have to say on that issue.
Thank you, Your Honor. The next is plaintiff's motion in limine number 35.
Unrelated medical history?
Yes, Your Honor.
All right.
So, Your Honor, as a result of consuming real water, Lisa King sustained liver and significant autoimmune injuries, namely autoimmune hepatitis and myasthenia gravis. Any unrelated medical conditions should be excluded at trial. They are not relevant. Defendants have no expert testimony that they're causally related to plaintiff's autoimmune hepatitis or myasthenia gravis, and the probative value is substantially outweighed by the danger of unfair prejudice. These unrelated medical conditions are herpetic Whitlow, elevated liver enzymes from taking Depo-Provera use years ago. That's the drug that's causing brain injuries in women all over the country that I'm handling. Esophagogastroduodenoscopy with biopsies, chronic gastritis without so late in the day for these words, Your Honor. Esophagitis, esophagus, degenerative disc disease in the cervical and lumbar spine from previous motor vehicle accidents, trigger point injections, site-specific cervical and lumbar spine injections, and radiofrequency ablations, which are, of course, for a facet joint, that's a facet joint treatment, Your Honor, from 2020 to 2022, hypertension, chronic obstruction pulmonary disease, allergies and asthma, migraine headaches, and chronic sinusitis. Williams and Giglio established two critical principles that control here. First, evidence of prior medical conditions is only admissible if the defendant presents competent evidence showing a causal connection between those conditions and the injuries at issue. It's not enough to simply point to similar symptoms or speculate about possible connections, which is exactly what the defense attorney, if the court will remember, wanted to do with her back injuries in Giglio. Second, this causal connection must be established by expert medical testimony to a reasonable degree of medical probability. Defendants fail to meet either requirement. Their only medical expert is not offering any opinions linking these prior conditions to King's current injuries. Dr. Alsina testified that real water is the most likely cause of King's autoimmune hepatitis and doesn't disagree with our expert's causation opinion. Further, as I stated before, he has admitted that he is not qualified to provide expert opinions regarding whether Ms. King's MG is or is not related to real water. The defendants try to circumvent these clear legal requirements in 3 ways. First, they argue that because some symptoms of the prior conditions are similar to symptoms from real water exposure, the evidence should be admitted. The exact same argument the defense lawyer made in Giglio, Your Honor. That's precisely the kind of speculation that Giglio, it's late.
Different case.
Giglio and Williams prohibit. Without expert testimony establishing causation, the jury would be left to make improper medical conclusions based on superficial symptom comparisons. Second, they point to King's discovery responses and deposition testimony describing her symptoms, but King is not a medical expert. Her lay descriptions cannot substitute for the expert medical testimony required under Nevada law. Third, they claim some conditions should be admitted for impeachment with no explanation of how these unrelated conditions would properly impeach any relevant testimony. And their argument is nothing more than a backdoor attempt to circumvent the expert testimony requirement under Giglio and Williams. Defendants conflate King's IVIG treatments for MG with completely unrelated radiofrequency ablations for degenerative disc disease from prior accidents. That both involve medical procedures does not make them relevant or admissible. For Epstein-Barr virus, Dr. Alsina explicitly testified that he is not opining that EBVs caused any of King's current conditions, including some literature in his report about Epstein-Barr virus does not equal making a causation conclusion, and Dr. Alsina has admitted he's not qualified to do so at any rate. For the respiratory and gastrointestinal conditions, which are clearly related and caused by MG, defendants have no expert linking these to King's autoimmune conditions. The fact that some symptoms may overlap does not satisfy Nevada's requirement for expert medical testimony on causation. Thus, the court should exclude this irrelevant and prejudicial evidence.
Thank you, sir.
Thanks, Your Honor. Your Honor, it's funny how somehow an admission by a plaintiff, party opponent, as to what their pre-existing medical condition somehow isn't relevant when that same medical condition, symptoms or however you want to define it, are being set forth in this case. She's admitted degenerative disc disease in her cervical and lumbar spine, chronic neck and back pain from previous motor vehicle accidents. She had, as Mr. Eckler stated, trigger point injections, site-specific cervical lumbar spine injections, radiofrequency ablations from 20 to 22. Her complaints relate to her inability to move her neck and back, Your Honor. We have to be able to address that fact. Isn't it true that you have degenerative disc disease? Isn't it true you have degenerative lumbar disc disease and cervical disc disease? Isn't it true you receive treatment for these?
How is that relevant?
Because she's claiming that her neck and back are injured as a result.
What expert do we have here? Because that's a very similar argument that was being made in Giglio. And here's why that's important. She had lumbar pain. Lumbar pain. And she had a pre-existing condition too. And she had facet injections done. And it was actually, it's my recollection, it was at the same level, right? L45S1. And that specific evidence wanted to be introduced by the defense in the case. And one thing the record showed was essentially this, that this was a new injury arising from the lower back, yes, but it was a disc injury and not a facet injury. And that's why it was excluded.
This isn't a new, if I may.
No, but how is this, and here's my point. What expert do you have in this case that's going to opine on those specific issues you're making arguments on, because at the end of the day, if you're gonna offer up independent alternative causation theory, you have to have an expert to do that. Isn't that the current status of the law in Williams? And so, she might have a lot of these issues in her medical records, but if you wanted to point that out and establish that in front of the jury, then an expert would be appropriate.
Okay, Your Honor. So I just want to make sure it's clear on the record that you believe that we have to bring in an expert to confirm what the plaintiff has stated regarding her prior treatment and her prior conditions for this to be admissible.
Well, I'll be more clear, sir. Number one, all pre-existing or prior treatment doesn't come in, it has to be relevant. Secondly, if you want to offer up independent alternative causation theory in front of this jury, you need an expert for that. And it's really that simple. Just because a person has prior history doesn't mean it's relevant. And in Giglio, I excluded the facet injections to the lumbar spine. And what did the Nevada Supreme Court say under those circumstances? That was the appropriate thing to do, because her injury was a disc injury. They might be at the same levels, right? And so, for the record, I'm not saying anything you're saying. I said, where's your expert? Because at the end of the day, unless you have an expert to tie it up, it's not coming in.
And then I'll just repeat my point, Your Honor, is
And then I'll repeat my point. Where's the expert to tie all this up?
I'm saying is I don't need an expert if the plaintiff is admitting that her back is freezing up in spasm, has an inability to walk in this particular case. There's no expert backing that up. That's her testimony.
Well, but her testimony, she said, look, I'm not a doctor. And so I don't know if she's making a claim for that in this case, but what did she say? I'm not a doctor. And so she answered the question as posed. Hey, I had this problem, but I'm not a doctor. What did the doctors say?
What I'm saying is they shouldn't be allowed to come in and say there's anything wrong with her back because it's
What does the
pre-existing.
doctor say? What is the medical expert opinion in this case as it relates to the lower back?
They're claiming, there's no doctor supporting that I know of that's saying that it supports her lower back or her neck. This is her complaint. If she's going to get up on the stand, Your Honor, and make those complaints, we should be able to impeach her with the past history.
There's no impeachment because she agreed in her testimony that she had this, and she said, I'm not a doctor, but I've had these problems. And my point is this, the plaintiff is not, her testimony is not utilized to establish medical causation. You just asked her about her medical problem, and she apparently was truthful, and she discussed that. And here's my point, what did the doctors say? Because plaintiffs will say a lot of things related, unless it's something that would be readily apparent where you didn't have the necessity for expert testimony, like a leg off case or an arm off, I mean, as a result of a motor vehicle accident or something like that. That's one thing. But here, what does her doctor say? Because I went back and I looked at the questions, and the questions, I mean, here we have, I've heard you've testified you're not attributing or blaming your sinus issues on consuming raw water, but you're blaming any of your neck, but are you blaming any of your neck and back issues to consuming raw water and the effect it had on you? Her response answered, I would defer to my physicians. Right? That's what she said.
Yes, Your Honor, and if we continue to read, our point is that she is claiming, that she's deferring to her doctors. If her doctors don't say it, then why are they opposing our motion? The motion is that she's claiming that she has neck and back issues, and we shouldn't bring up the fact that she admitted to having neck and back issues before.
You know what, and here's my point. That analysis was rejected by the Nevada Supreme Court in Giglio. I don't mind saying that, it was. Because there, they actually had a stronger argument. They said, look, judges at this exact same level, she had complaints of lumbar pain going back, and she had these facet injections for lumbar pain. And I remember we had a very rigorous discussion on the record, and I said, wait a second here, what's the injury in this case? Well, it's a disc injury. And you know what? That can generate lumbar pain too. However, it was a different pain source. I still don't know, and it appears to me, she even qualifies it again in her response. I'm not a doctor, I certainly have a pre-existing neck and back issues. But my question for you is this, is real simple. What are the doctors going to claim or say as far as her neck and lower back and those structural components are concerned? What were they opining on? What do they say? How do they tie it up?
They're not tying it up, Your Honor. But if she's gonna come in and say, I've got neck and back problem, and she believes, even though she's not a doctor, that it relates to this real water, then we should be able to impeach her on it.
Well, I don't think there's impeachment because she's agreed that she had, I mean, she didn't fail to disclose that at all, right? So how can it be impeachment?
Well, you impeach it by saying that you had these problems before. They want to prevent me from being able to do that. That's the impeachment.
Well, I still, what do the doctors say? That's my question. I mean, I don't, what do the doctors say from the medical causation perspective?
I'll let Mr. Egler testify.
No, but I mean, we should have testimony on that issue and or a report or something.
So let me just back up here, Judge, and give you an understanding of what the myasthenia gravis causes. First of all, it's a permanent, non-curable condition. She will have this for life. It's not every day she has these issues. They're episodic, they come and go. But the symptoms for myasthenia gravis include, and let me explain what it causes, and the reason it causes muscle pain and weakness is because it attacks, it's a neurological thing that basically attacks the connections between the muscles and the bones. So wherever you have muscles and bones connected, because of this, you can have severe pain and weakness. And so the symptoms can be muscle pain, weakness, as well as closing of the throat and the inability to breathe, tremors, slurred speech, loss of motor control, severe gastrointestinal issues, and on and on and on. The symptoms are severe, they are extensive, and they last a lifetime. Again, not every day. So when she testified about, yes, I have back pain, yes, I have muscle pain, I have weakness, and they asked her about her neck and back, she truthfully admitted, yes, I've had some neck and back procedures. But she never said one way or the other whether those neck or back conditions were related to her prior injuries or they're related to her current conditions of MG. And what did she say? I defer to my physicians on that, Your Honor. They cannot bring this evidence up, even for impeachment purposes, because it's not impeachment. She didn't say anything inconsistent with that, Your Honor. She said, I'll defer to my physicians. The motion should be granted.
And just for the record, I don't mind saying this, I was actually thinking about the myasthenia gravis, and there was a professional athlete that had this problem, and I guess I was right, it was Jim Thorpe.
Yeah,
Believe it or not, I forgot all about that, but I knew there was someone that had it. And but at the end of the day, to me, and this is, I don't mind saying it, this is a fairly easy call. This is giggly all over again. It really and truly is. And at the end of the day, ultimately, if her pre-existing problem is going to come in, we have to have a defense expert to tie it up. And she was forthright and truthful that she discussed it. But it appears to me that, and I don't have the doctor's testimony, but he's going to testify to what the symptoms are as a result of this unfortunate event. You know, and it sounds to me it's not necessarily mechanical in nature. It's systemic.
It's neurological.
Neurological. There you go. That's the best way to say it.
All right, the last one I'm going to do here today, Your Honor, today is plaintiff's MIL 36.
Oh, Brandon. Thank you, Tori. She does a good job of that. Making sure the record's clear. And I'm sorry, Mr. Egger, which one are you on again?
Number 36, this is plaintiff's motion to exclude testimony and argument that plaintiff's treating physicians did not relate their illnesses to real water prior to the recall, Your Honor. So, Your Honor, any argument or evidence that real water was not the cause of plaintiff's injuries because none of their treating physicians connected their symptoms to real water before the product was recalled is irrelevant, will confuse the issues, and will mislead the jury. Although all real water was contaminated with hydrazine and had been making people sick for years, the public was not aware of the danger associated with real water until a large outbreak occurred in 2020. The FDA was notified of the outbreak on March 13, 2021, and real water did not issue a precautionary recall until March 24, 2021. It was not until June 1, 2021 that the FDA announced that real water ceased operations. Each of the plaintiffs had symptoms and began treating for their injuries before the public was made aware of the danger associated with real water through the recall. Plaintiffs King, Bordenave, and Delmar were first hospitalized for their illness in 2018, 3 years before the recall. 9 other plaintiffs became ill and were hospitalized in 2020, before the recall. Before the recall and FDA action, neither plaintiffs nor their treating physicians had any knowledge of the hydrazine in real water that was making the plaintiffs sick. So their failure to connect the plaintiff's injuries to hydrazine is not relevant to causation because they did not have all the information necessary to make such a determination at the time they were treating and diagnosing the plaintiffs. And that's why plaintiffs hired experts to examine all the evidence and offer causation opinions. Without such information, any testimony or argument referencing the fact that the plaintiff's treating physicians did not make such a determination is irrelevant and contrary to the standard for causation testimony under Williams. Now, causation is established, but the problem is the defendants next contend that physicians' ignorance of the danger of consuming real water is somehow relevant to punitive damages here. However, Your Honor, it is real water's knowledge and conscious disregard of all the warnings and issues at issue for punitive damages, not the public's knowledge that is at issue here. NRS 42001 defines conscious disregard as, quote, the knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to act to avoid those consequences. Plaintiff will present evidence of defendant's culpable state of mind through defendant's own conduct. Since punitive damages are focused on defendant's own conduct and culpable state of mind, the treating physician's lack of awareness of hydrazine in real water is not relevant for rebutting the punitive damages claim. And real water should be precluded from introducing evidence or making prejudicial arguments that none of the plaintiff's doctors connected their illness to the consumption of real water before the recall. So how could we have any idea, Your Honor? That is an improper defense to a punitive damages claim here, Your Honor. The motion should be granted.
Thank you, sir.
I believe each and every one of the plaintiffs who went and got medical care at a hospital introduced those records and the expenses related thereto as part of their case in chief. So what plaintiff is arguing, plaintiff's counsel is arguing, and it is argument left from the jury, is that we're going to, I guess, white line out parts of this medical record, which is inappropriate. It's the medical record. They can make all the arguments they want why these doctors didn't find it, but it is the medical records. And the medical records are relevant, and they've made it relevant, and they've made it important. It's, well, they're in hospital for all these weeks, I couldn't find out what's wrong with them. They're not going to bring that up because they have in other cases. They're going to say, hey, the care that they received, we're not making a claim for those medical specials. Well, let's avoid the whole medical treatment aspect of the case in terms of those special damages. They're not in this case. So that's argument. You can't just selectively take out elements of medical records that you feel as don't help your case. Now, as it relates to the punitive damages, we've argued this before, not successfully, but I'll make another opportunity. as simple as this, Your Honor, is if the question that gets to punitive damages, Mr. Eglin is correct. It's what our people knew. There's been no evidence that our people knew anything about hydrazine being in the water. They were drinking it themselves.
Well, I understand that, but they knew people were getting sick from real water.
Right.
And here's my question. I mean, this goes to the red flags that are set forth in the Countrywide case. And it appears to me there were quite a few red flags. You can't look to the doctors, because the doctors, I mean, I remember this case, I do. And I don't remember names, but I remember the testimony. And specifically, I guess one of the world's foremost experts as it relates to hydrazine testified in the last 2 trials. And there's no expectation at all that hydrazine should be in water, right? I mean, that's my recollection as far as the testimony is concerned. It's rocket fuel. And consequently, it was a byproduct of the manufacturing process that was utilized at real water. It was there. It shouldn't have been there. And so I'm trying to figure out what relevance, if any, the medical records have, because when you go see a doctor, he's not going to test you for hydrazine exposure. He's not going to do that. They're going to go ahead and do a regular workup and do what they think is best. But at the end of the day, ultimately, it was determined after the government got involved in this case that hydrazine was the quote culprit. That was the cause. So I'm trying to figure out how that comes in. And just as important too, we can't forget that at the end of the day, there was a lot of testimony in the last couple of trials regarding what real water knew and what they didn't do when this was first brought to their attention. And that appears to me to be the red flags that were set forth in Countrywide. It goes to a conscious disregard. And so I'm trying to figure out why the simple fact that they went to the doctor and the doctor didn't diagnose hydrazine. Heck, the doctor had no expectation that they would be drinking rocket fuel. I mean, nobody knew what hydrazine was.
And neither did my client, Your Honor.
That's not an excuse.
Well, it's an argument that they're making. So if the argument is they're making is that we intentionally put something out on the market and that we were doing it with reckless abandon, then a part of the evidence is that people who are in the business of identifying these type of conditions couldn't figure it out. I heard argument earlier today that if a bottle of water sits out there and starts dissipating, etc., it's not going to show up. They had a difficult time determining what it was. So, Your Honor, my client produced water. It shouldn't have anything in it other than water, right? I understand that fact. But the fact that that mistake was made and how people who are even in the field, medical field, couldn't figure out how it came about because it's never happened before, that has to come in and impact the relevance of whether or not my client acted with reckless disregard.
Well, actually, it's a conscious disregard, number one, under 42.005. Secondly, we're not talking, one thing you didn't address was all the, quote, red flags under Countrywide. Because there were complaints of slimy red substance. What did your client do? Here's a case of free water. There were issues regarding a gasoline smell with the water. What did your client do? Here's another case of free water. There were complaints of people getting sick, right? And what did they do? Here's a case of free water. And that's my recollection as to what the status of the evidence was, and that's probably why the juries reacted the way they did in this case, because it was pretty clear.
Well, Your Honor, if you believe that...
No, it's not what I believe. That's what the testimony was.
Well, Your
I'm
Honor,
just paraphrasing. That's not what I believe, because tell me if I'm wrong or not. That was what the testimony was in this case.
customer service of someone complaining about their water and the responses that give them more water and there's no more complaints would suggest to just about everybody that there's nothing wrong with the water. It happens all the time. One thing, 1 + 1 doesn't equal $10 billion, Your Honor. So by the same token...
Well, but there's more to that, because there was evidence too that one of the, I don't know what his, maybe he was a quality control guy or something like that, but he goes to the president and say, hey man, we got problems with his water. And We have to do something about it. Maybe we should do a recall. And what did your client do?
Hey, then the conversation didn't take place, is what the client said.
Well, we had testimony to that at trial, right? We did.
Your Honor, if we're talking about this case, and we're talking about testimony in this particular instance, and if we're not allowed to present defenses based on what happened in another case, then that's a different issue altogether. Our position is that this is clearly relevant for the reasons stated, and should be admitted. By excluding it, it's very prejudicial to our client. Thank you.
Thank you, sir.
So, Your Honor, again, with respect, I don't even think I even need to argue on the unrelated conditions, but with the respect to this is with respect to the defense's contemplated arguments that since, hey, the medical doctors didn't know, how can we be expected to know? Well, the doctors, the medical treating doctors, didn't have a duty to investigate the many, many complaints that actually started in 2008, their first year of production of this so-called drinking water, and continued on and on. It had multiple different types of complaints, including somebody who was hospitalized for liver injury. And when they stopped drinking the water, their liver got better. And they received an email on this and still didn't investigate, didn't test it, didn't do anything about it. And the doctors didn't have a duty to test the water, to find out what was in the water. So trying to compare what the doctors knew and what they knew is apples to oranges. It is the real water, the manufacturer of this product that has those duties to investigate and test, not the doctors, who don't even have access necessarily to the water. And if real water would have had, they say, well, real water, they wouldn't have had a difficult time with this if they had taken the complaints seriously and actually investigated it and tested it. That's the point. So to somehow compare their knowledge and actions to the doctor's knowledge and actions is ludicrous here, Your Honor, and is not an appropriate argument.
All right. And I guess we're on number 36, is that correct?
Yes, Your Honor.
And that's plaintiff's motion amendment number 36 to exclude testimony. An argument that plaintiffs treating physicians did not relate their illness to real water prior to the recall. And I don't think the doctors in this case were in the business of testing water. They're in the business of treating patients and doing their best at dealing with their ailments and so on. And I don't see the relevance. I really and truly don't. You're trying to equate a treating physician to a product manufacturer that has totally different duties and responsibilities pursuant to the restatement of torts 402A. Anyway, and I don't see how it's relevant at all. I'm going to grant the motion. Can we get one more done today or not?
Yes, Your Honor, we have a quickie.
Number 18, Your Honor.
Your Honor, 18 is the motion to preclude evidence that Blaine Jones is a plaintiff. And if you recall, in past trials, I allowed the defendant to choose which way this motion would be resolved. And if you recall, like for example, in the Gallagher case, Mr. O'Doon didn't want it to be known that Blaine Jones was a plaintiff. And then Hannah wanted it in, and then Milwaukee was going back and forth, and so we didn't get the final vote for a couple days. And then finally they decided not to submit that issue to the jury. So, and it's a Hobbesian choice here, because if the jury is told that he's a plaintiff, then I'll be allowed to say, hey, this problem is so bad that the guy making the water sued the company. I'll be allowed to say that conscious disregard, even the vice president has alleged in a complaint that there's conscious disregard. So those are the benefits to me if it comes in. The benefits to them is they're gonna try to minimize the $10 million testimony. That's it. So I will live with whatever they want, okay? And I wanna make that clear on the record, because I don't want this issue to be an issue on appeal. So whatever they want, if they want it in that he's a plaintiff, great. I'm gonna do what I just said I'm gonna do. If they want it out, I won't do that. So their choice, fine with me.
Your Honor, I'm confident the issue will be an issue on appeal because our problem is with the $10 million testimony. But as it relates to this particular motion, we do want the fact that he is a plaintiff to come in to the extent you do not grant our motion that will be heard in all likelihood tomorrow, which is Real Waters MIL number 4 to exclude that $10 million testimony. So for our purposes, we want the fact that he is a plaintiff to come in, and that would address plaintiff's motion in limine number 18 and Real Waters motion in limine number 5. That's also consistent with the order that was entered in Gallagher. Thank you, Your Honor.
All right.
Well, Your Honor, five's completely different, Your Honor.
Yeah.
5 is they want the whole Consiglio Blaine Jones complaint in, and there's a zillion reasons that should be.
Fair. To the extent that they're stipulating, or that the order will be that he is a plaintiff in a case against Real Water, we don't need the complaint entered. That would render that moot if we are simply allowed to mention that he is a claimant bringing the same claims.
And Your Honor, the only problem I have with this is, from what I'm hearing, is it's contingent on the ruling on the next motion. They don't want to say you can tell them it's plaintiff unless we lose the next one, then they're going to pull it back. So, I mean, I think they should make their choice now. And they should. Do they want the jury to be told he's a plaintiff, or do they not want the jury to be told he's a plaintiff?
Well, again, the only reason why him being a plaintiff has any bearing whatsoever is that $10 million testimony. So, no, we do think it is contingent upon this court's ruling on our motion in limine regarding the $10 million testimony.
Well, Judge, and how are they going to get that in? I mean, they got to call him as a witness. There's, again, in his deposition, this was prior to the time he filed the lawsuit, and in the second deposition, he explicitly testified that he had consulted with an attorney and he had decided not to file a lawsuit. So there's no deposition testimony that they can use to get it in. They have to call him to the witness stand, which, I mean, that raises a whole host of other problems, but that's the only way they can do it. So, I mean, I think we should really have a clearer indication what they want to do, not if you grant this motion, if you grant that motion.
We're talking about Blaine Jones, right?
Blaine Jones.
Yeah, I remember his testimony. He said that you couldn't pay me $10 million.
That's correct, Your Honor.
Yeah, I remember completely, because apparently he underwent a lot of distress.
Yeah, I remember we had the GoFundMe page that was made in 2020. He didn't have medical insurance because Real Water didn't provide his boys with medical insurance. So he had a GoFundMe page that was at least 12 pages long. And in the deposition, remember we played some during the opening, in some cases, some of them we didn't, but we played it all during the case in chief. He went through his medical condition with a fine-tooth comb. He's up in Utah, he's throwing up. His parents run up there, grab him, they bring him back here. He's advised to go get a liver transplant, maybe. You know, he was in bad shape. You know, he said that himself. And then we asked him, well, given everything you went through, $10 million, he said, sure, I would never go through this for $10 million. That's the testimony that they gave.
Well, and Your Honor, to the extent we're going to argue this, then I suggest we go ahead and hear Real Water's motion in limine number 4 right now, since we're getting into all the facts associated with that motion, and they're pretty closely tied together.
Yeah, I have no problem with that, Your Honor.
Yeah.
Okay.
Excuse me.
So, as it relates to Real Water's motion in limine number 4, Blaine Jones was deposed twice, Your Honor.
Once as a 30B6 and once in his individual capacity. During his personal deposition, plaintiff's counsel asked him about his illness history, which we just heard some comments about. And when he was done providing the history of what he went through, plaintiff's counsel asked him a leading question. He said, "You would not go through this again if I gave you $10 million, would you?" And his response was, "No." Plaintiffs then went on at trial to tell the jury that the sworn testimony of the vice president of Real Water thinks that the baseline ought to be $10 million. That was the argument that was presented. This tactic has several problems. First, Blaine Jones absolutely did not testify that every plaintiff's claim is worth $10 million as a base figure. That's not what happened. The testimony in question was not during his 30B6 deposition. He wasn't testifying to bind Real Water. Real Water had been out of business for multiple years and was in bankruptcy. This testimony is not relevant. It has no tendency to establish plaintiff's damages. And there was not a witness who compared Blaine Jones's injuries to any of the other plaintiffs. There's no medical testimony deciding what Blaine Jones's baseline was compared to any other plaintiff, just like there won't be in this case. This testimony is clearly prejudicial and wildly confusing. It's a leading hypothetical using an arbitrary number that plaintiff's counsel put in Mr. Jones's mouth. That wasn't his number. Imagine plaintiff's counsel had asked him, you wouldn't go through this again for any amount of money, would you? He said, no. Then they'd come in and say, Real Water says that infinity dollars is the baseline for every single plaintiff's damages. That doesn't make sense. It's clearly not probative of anything. Plaintiffs should be held to their standard of proof. They should be required to establish up their own damages based upon their own experiences, not an arbitrary number that was fed to Mr. Jones. They need to satisfy that standard. These cases need to be decided on their own merits, and there shouldn't be a shortcut to damages based on Blaine Jones's hypothetical leading question that he provided an answer to in his individual capacity when he had already met with counsel to bring suit and did so a mere few weeks later. Thank you, Your Honor.
Thank you, sir.
Wait a minute, first of all, on the leading point, he was their vice president. I'm allowed to lead when I take a deposition of their vice president. And then they say, oh, it was out of context, he didn't know what he was doing, he should have asked the questions differently. They had a chance to clean it up in the cross. They didn't ask him one single question about it. I think they were afraid he was gonna go from 10 million to 20 million. Okay, they didn't touch it with a 10-foot pole. So to suggest that it's out of context, they had their opportunity to put it in proper context, they didn't do it. The prior ruling of the court was that this 10 million figure came in, and contrary to counsel, I thought we were very careful in the last case to explicitly say that we were not saying that this $10 million figure applied to everyone. If you recall, I went through the 15 plaintiffs, and I used that as a baseline, and I said, this person is injured a lot more than Blaine Jones, this person is injured a lot less, and we suggested different figures than the $10 million to the plaintiffs. And that's all that Blaine Jones gave us was some sort of baseline to start with. But remember, the rule says, since he was an officer of Real Water at the time he gave this $10 million number, we can use it under 32(3) for any purpose, any reason we want to, Your Honor, and that's what we're doing in this case. So for that reason, the court should stick with its prior ruling and allow this testimony in.
Your Honor, first of all, Mr. Jones was not the vice president of Real Water. It was in bankruptcy. He was removed from his position of being vice president in April of 2020, and this deposition took place years later. He's a layman. He has no basis to say what type of compensatory damages should be awarded for pain and suffering, and it is unquestionably unduly prejudicial and not probative of anything relating to the value of the claims of the plaintiffs in this matter. And just to push back on the notion that it wasn't used as a way of saying it's the baseline, Your Honor, the closing argument is, quote, the sworn testimony of the vice president of Real Water thinks the baseline ought to be $10 million, close quote. That's exactly what it was used for. It's a shortcut to establishing the actual damages of the plaintiffs in the particular case. And for that reason, that testimony should not be allowed. Thank you, Your Honor.
All right, and this is what I'm going to do. Which motion are we on?
Number 4 is the 10 million, and number 18 was.
I think it's important. I get it. I'm going to stand by my prior ruling on this, number 1. Secondly, his testimony is really important in this regard because I remember him testifying as the severity of his symptoms when he was suffering from ingesting Real Water. He was pretty graphic. and he testified to it. And this is important too, all adverse evidence is prejudicial to the party. I mean, it just is. But I don't think it's unduly prejudicial in this case, and he testified to it. And so where does that put you as far as the decision-making is concerned, sir? Okay. And this would be motion eliminating number 4 to exclude testimony of Brian Jones. I deny that.
Right, Chairman, that would be denied, and the decision has to be made on 18, whatever they want to do.
Based off your ruling, Your Honor, we'd like to introduce the fact he's a plaintiff.
Well, that's fine.
Thank you.
And, Your Honor, I think we need to be clear, because our motion is motion to preclude reference. They want to be allowed to make the reference if it's appropriate, meaning they need to call him as a witness, and they can bring it up. So, Mill 18 should be denied that the reference is not precluded. It doesn't mean that they can automatically just publish statements to the jury or you ruled on the motion to admit the complaint.
He has not ruled on that one.
Correct.
Yeah, okay.
Yeah.
Yes, so.
You'll call him? You'll call him, right?
Yeah, that'll be, I think when they're done with theirs, so.
It's time to go.
I think
So,
him calling Blaine
Plaintiff's
Jones.
motion limiting number 18 is denied.
Correct.
We may have time for one more quick one, if we're willing.
If you can do it quick, Mr. Eccles.
I'm not.
You got 8 minutes. Ma'am, you can stand right there. I can hear you.
Okay. We're gonna do 21.
Respectfully, Your Honor, I think 21 is going to take more than 8 minutes.
Respectfully, Your Honor, you've already decided this 3 times.
Which one?
Twice, sorry. Customer complaints, to pre-admit the customer complaints. So I think we can get it done in the time necessary. Shane, can you go ahead and pull up Exhibit 1 to our reply? So by this motion, plaintiffs seek to pre-admit the real water customer complaints. You've seen these twice before. This is a substantial similar motion that was granted in Brown. In fact, the minute order is, the infamous minute order is what we're pulling up here, Your Honor. As this court has determined from a thorough review of Nevada case law, and in fact has reviewed all these complaints, they are similar under Nevada law and require pre-admission. These are sufficiently similar to demonstrate notice of causation. They're all symptoms of nausea, vomiting, diarrhea, or otherwise clear indications of manufacturing defects of, we've even mentioned them here, the fishy or chemical smell or the oily substance. All of these customer complaints are clearly real water documents that should be pre-admitted. They're not overly prejudicial. So these complaints should be based on the Nevada Supreme Court decisions under Beattie, Guinness, Robertson, Reginald, and Shane, if you can kind of scroll through this. You've determined the 6 factors and talked about the similar events analysis. Real water tries to suggest that it's substantially similar, but as this court has already ruled, it is similar, and that's what the case law says, and plaintiffs clearly meet this. And if you go to the very bottom, Shane, on the second and the next page. All right.
See, this is what I don't have the time to do right now.
No, exactly. And you've already done it, so it doesn't, further upon review, the court finds that the similar events at issue are substantially similar for purposes of product liability, and therefore, and it's finding in conformity of Krauss. So these were admitted in Brown. You denied their exclusion in Gallagher. We respectfully request that they be pre-admitted here. Thank you.
How much time do you have, sir?
Well, Your Honor, we have to go through Kraus, Andrews, Reginald. We have to go through the the order that we just saw and discuss the fact that, contrary to what opposing counsel says.
I'm gonna let you make your record. Don't worry about that.
Well, my question is, do we want to? This is why I was saying this might not be the best motion for right now.
No, I mean, you're gonna take 20 minutes at least, right?
I think so.
And you have a right to. So I'm not giving you a hard time because of that.
Yeah.
I don't have 20 minutes.
That's my point, Your Honor. That's what I was trying to say from the bench, Your Honor.
But that's okay. I remember this issue fairly well because I actually went back and read a lot of the Nevada cases specifically as it related to this issue.
Yes, we talked about the Kraus case for 3 hours.
But I mean, Kraus was pivotal, because Kraus was the latter case and the lever, right? And I think I made a distinction on that, and that's why I made it broad. But sir, what time can we come back tomorrow? 1:30.
Perfect. I'll see you then, Your Honor. Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. So 1:30, yeah.
Thank you. Long day.
Appreciate it.